surprise me if Democrats did not want to extend this trial. A piece of it is a motion to make sure that deliberations occur in public. That is not automatically guaranteed. Also, don't forget that President Trump's State of the Union address is slated for next week on Tuesday, and it's not clear that Democrats would like to give President Trump that free pass heading right into State of the Union.
Meredith, I want to turn to you at the White House. There's some breaking news from the New York Times. We're getting some excerpts that the New York Times is posting, understanding of what John Bolton's book that has really changed the discourse on this and moving forward on impeachment. And what we are hearing from the New York Times is that Bolton is saying in this book that he had pressure put on him from President Trump as early as May to try and put the pressure on Ukraine. Is the White House responding to this?
At the moment, no, but this new excerpt that the New York Times is reporting on is, like you said, the earliest example we have so far of President Trump putting pressure on his aides to solicit help from Ukraine to investigate his political rivals that are now at the heart of this, of course, impeachment trial. But this is the earliest known example that we've heard of so far.
So just to recap here, we were expecting potentially a vote today. It doesn't seem like that's going to happen. And now we're hearing that this vote could potentially be pushed to Wednesday. It was really the big news. And just minutes ago, the New York Times has published this account, and it's saying that folks who may have known about this, Chief of Staff Mick Mulvaney potentially in the room, President's personal lawyer Rudy Giuliani were in this conversation, and then White House counsel Pat Cipollone as well. What does this mean for the players involved and the folks who might have known about this pressure campaign?
Well, Giuliani in the New York Times piece denies that this happened, but it does put additional pressure on these folks, of course, to be heard from. While we know that Senator Susan Collins and Senator Mitt Romney are likely to vote to have witnesses, it does bring in this last-minute pressure to solicit more information from folks who may have been in the room when all of this happened. And I didn't mean to actually make a reference to Bolton's book. That's the title of his book. But it does put additional pressure on those folks to potentially come forward and share what they know about this conversation that we're just learning about today.
Keir, Democrats have long focused that there's an abuse of power here. Does this change anything, learning these new details from Bolton's book, that this was a key witness that folks wanted to hear, someone Capitol Hill really wanted to hear from?
So yeah, this would be relevant evidence if it came in at a trial, at a trial with a witness under oath. There are several eyebrow-raising facets to this report. Of course, we have to remember, as Meredith just said, Mr. Giuliani denies this, so we need to say that. But the timing is important, that it happened in May, which was after President Biden announced his run for the president. So one of the defenses that we've heard is that President Trump was concerned about the goings-on in Ukraine before President Biden, Vice President Biden announced his campaign. This does not answer that question, but rather bolsters, it's another piece of evidence to show that President Trump, after Vice President Biden announced, was interested. It's very eyebrow-raising that Mr. Cipollone was in the room.
What does that tell you, Keir? You say it's eyebrow-raising, but what does that tell you?
Well, he's one of Mr. Trump's counsel in the Senate trial, and ordinarily an attorney who's also a witness would not be able to be the attorney, particularly where there's a denial. Where there has been a denial about what happened in the room, then you may need every witness in the room to determine whether or not what Mr. Bolton says is true or not. You can't, as a lawyer, you couldn't step out of that and then say, well, because there are other witnesses that can testify. Because it's been disputed now, Mr. Cipollone becomes a witness in the trial, and that places him now also as counsel in a very awkward position. The fact that Mr. Giuliani was in the room with other people. So Mr. Giuliani has been claiming that there's an attorney-client privilege, personal, with him and Mr. Trump. But because there were other people in the room, that now places the attorney-client privilege claim in doubt.
Siobhan, we've been watching certain senators as to how they might, what way they might go. And today, Senator Alexander's decision today to oppose witnesses. with that in mind, we're still waiting to hear from Lisa Murkowski. We do know one thing for certain about this vote, whenever it takes place, is that it'll be incredibly partisan. Are Republicans worried at all that if they vote to acquit at this point, that these other details that are drip, drip, drip from Bolton's book, potentially from Lev Parnas, that it could somehow affect the calculus?
Well, at least if you listen to Republicans' rhetoric, they're not worried, and that's because they feel they got a built-in defense during the arguments when they got the White House lawyers to say that even if all the facts were true, which the White House disputes, Mr. Trump's behavior is not impeachable. And part of that argument, the White House says, is that no crime was committed, and also that you kind of have to impute an ill motive. And so the Senate Republicans feel that they have largely protected themselves against the threat of any additional evidence coming out. Also noteworthy, Lamar Alexander's statement was eye-popping in one way. Lamar Alexander came right out and said, yes, Donald Trump did it. He agreed that the evidence was overwhelming, but he just thought that the behavior was not impeachable.
You know, what you heard from Siobhan there, Kara, what do you make of Alexander's argument when he put this forward as to why he's voting this way?
So I completely agree with Siobhan that this is a very important indicator from one of the senators. So the idea that the conduct is inappropriate, is bad, but doesn't quite reach the level of removal, that is a position in the Senate that does not do damage, constitutional damage to the impeachment provisions. The idea that even if it's all true, it's unimpeachable on the theory that Professor Dershowitz has been espousing in the well of the Senate, that idea is very dangerous. His position is an outlier among constitutional scholars. In my opinion, he is flatly wrong, and it creates a scenario where future presidents on that theory could repeat or believe they could repeat President Trump's conduct and ask foreign countries for dirt on an opponent and do it with impunity.
He's also saying here, he looks at China, that there were some favors done for Turkey and China as well. I mean, there's the president was effectively granting favors to autocratic leaders like Erdogan of Turkey and Xi Jinping of China as well. There's so much to unpack from this Bolton book, Meredith. Did the White House make efforts to sort of lobby these senators to oppose witnesses, and was there pushback from the Republican side on this?
Well, my colleague Anita Kumar and I both reported that there was pressure that was put on senators, not from, of course, the council, but from legislative affairs and from the communication shop. But most importantly, there was pressure put on from Senate Majority Leader Mitch McConnell and his operation. He is someone who is known to keep a really tight ship, especially with this Republican Party. And certainly they didn't want anybody voting out of line. That being said, there was anticipation that some players, some of the more moderate independent leading players like Romney and Collins were going to go their own way no matter what. But there certainly was pressure to stay and vote against witnesses.
Meredith, we know that the president can be incredibly masterful when it comes to media attention. He's going to have two huge platforms coming up in the next week. He's got a one-on-one interview, I understand, with Sean Hannity on Super Bowl Sunday, incredibly large audience. And then he's going to have the State of the Union this week. What do you think is the narrative that the White House is going to be crafting on all of this?
Well, I think the president's schedule this past week was so interesting to see. It was packed full of policy announcements, of speeches, of rallies. It really was the White House trying to craft a narrative and a message that President Trump is acting presidential. He's doing very presidential things while this trial is to remove him from office is going on. And so I think you'll see more of that, of course, in his State of the Union speech. We should be getting a preview of that from from the White House comm shop later today, but we've learned that much of the speech itself is going to be focused on a lot of the president's past achievements over the course of his time in office. And then in Sean Hannity's interview, this is somebody, it's an ally of the president. It's somebody that he calls on as not only a media ally, but a close buddy of the president. Mm-hmm. So I can imagine that conversation will be pretty candid and focused a lot on perhaps railing against what he's been seeing happen on Capitol Hill.
It should be very interesting. We heard Hannity himself say on a show this week that he was very disappointed in Bolton, and he said he helped get the job for John Bolton, and he said he can't recognize the man that he is today. Siobhan, as we're waiting really minute by minute as to the decision of what Alaska Senator Lisa Murkowski can do, I'm just curious if you've heard anything and what you can tell us about her voting history, and maybe potentially, do you have a sense of how she might lean on this vote?
Lisa Murkowski has been incredibly hard to read. A bunch of us were staking at her office earlier this morning for hours. No sign of Lisa Murkowski. She has a very interesting history here. The reason she has this Senate seat is because she won a write-in campaign. The Republican Party, led by Mitch McConnell, had left her for dead and backed the person who actually won the Republican primary. Lisa Murkowski, consequentially, owes the party nothing. She voted against the repeal of the Affordable Care Act in that dramatic moment when she and Susan Collins and John McCain voted to take down a priority of President Trump. She was the Republican who voted against Supreme Court Justice Brett Kavanaugh. And so she's got a history of bucking the party. But there's a big pressure point for her here. If the Republicans are able to muster 3 votes to join with Democrats, you have a 50-50 tie. And that puts pressure on John Roberts. His habit, the expectation is he would not intervene. A tie would fail. But it's hard to imagine that Mitch McConnell would like to put John Roberts in that position. And so there's going to be incredible pressure on Lisa Murkowski to stick with the Republican Party here.
It's interesting, Keir, because John Roberts' mentor, correct me if I'm wrong, was Rehnquist, who also presided over the Clinton impeachment. And the sense was, he is somebody who believes not to put yourself in the middle of all this. Am I right?
Yeah, so Rehnquist's famous quote from the Clinton impeachment was that I did nothing and I did it very well.
Yes.
So as a model, certainly I would think that the tendency for Chief Justice Roberts would be not to intervene. I think it would be a very large signal if it came down to a 50-50 vote and he decided to cast a vote.
I apologize. We've got Senator Klobuchar here, one of the Democratic potential candidates. Let's listen in.
Issues like this president putting his own private interest in front of the interests of our country. I don't have the luxury to switch the channel and watch cartoons, as one of my opponents suggested. I'm here. I'm hoping that the people see it as a plus, and I'm going to do my job. We don't know that yet, right? We haven't yet had the vote on witnesses. You never know what happens. News seems to be seeping out every day. And as I keep telling my Republican colleagues, this isn't one of those instances where the truth comes out 5 years from now. The truth may come out 5 weeks from now. It may even come out 5 days from now. John Bolton could go on any of your TVs and make an interview and do an interview with great detail, but yet they're denying him from coming forward to being part of this hearing. That makes no sense. That's what's going to be left on their shoulders. So I'm hoping that enough of them will come around. They will actually have witnesses. I'm going to go in there.
Senator Klobuchar weighing in there. I want to take your attention to the bottom of the screen. You see that smaller video there. We're getting unconfirmed reports from Mar-a-Lago that we're monitoring right now. That's, of course, where the president's Florida resort is. Somebody may have attempted to ram a gate on the property with the vehicle. Our affiliate there in Palm Beach, WPEC, is saying that there is still heavy police presence in that area. So we're going to continue to monitor that shot, and we'll have updates for you on that as well. Keir, I want to talk a little bit more sort of about what Lisa Murkowski said, about this coming down to 50-50, the votes, that the witnesses, that this decision ultimately falls on Chief Justice John Roberts. You said you don't think he would weigh in. Is that correct?
Yeah, I don't think that he would want to. He's sitting as the presiding officer here, but of course, carrying with him on his shoulders is the reputation of his third branch of government that he represents as the chief. And so, I think it's potentially, his calculation would potentially be about not wanting to tip the scales on a matter that the legislative branch controls. I think his inclination, that would be my suspicion. However, he would have discretion, I believe. He could cast a vote. I don't know whether or not the Senate would accept that vote. They could then take a separate vote to overrule him on whether or not he's had the authority. But let's say for a moment that he did decide to cast that tie-breaking vote. I think it would be a very large signal. Now, you just mentioned that his mentor was Chief Justice Rehnquist. Based on what I know about him, he did not have a lot of trial judge courtroom experience.
Rehnquist?
No, Roberts. And so he did not see the way schemes and evidence and corruption cases come in a courtroom, and there are nuances that you pick up with experience. I think this may be a new experience for him, and I'll be watching to see in the future if the Supreme Court's decisions on corruption cases and on executive power cases, now that he's had an up-close microscopic view of what this looks like in practice, whether or not his opinions and his writing will become maybe a little bit more nuanced.
It's so fascinating to hear you say it because, as you know well, the video is not allowed inside the Supreme Court. We don't really get to see him interacting in that level. But you believe that this could change his approach to the bench in the Supreme Court?
I believe that the way these arguments have come in, there are skilled lawyers on both sides of this, and the way these arguments have come in, I think, can't but help someone who hasn't seen the nitty-gritty of corruption evidence coming into a courtroom, or at least corruption allegations. Let's put it that way. To see the way those allegations play out in a courtroom, I think will be potentially very helpful for Chief Justice Roberts.
All right. Siobhan, I want to turn to you on Capitol Hill. I want to talk about one of the yes votes on witnesses, Senator Susan Collins. Do we have a sense of what went into her decision to vote for witnesses, and how much did re-election play into that vote?
So Susan Collins' position is that she is acting totally independently, that her re-election campaign is not a factor. But that said, she's clearly under a lot of pressure. Susan Collins' coalition includes Republicans, Democrats, and independents. And she's got a very, very fine line to walk here if she is to keep that coalition together. Don't forget also a ton of money is pouring into the Maine Senate race. A colleague of mine pulled the data, and it looks like more advertising dollars have poured into Maine since the September 24th decision by Nancy Pelosi to formally declare an impeachment than any other race in the country. The advertisements are already on television all over the place there, and she's clearly under incredible pressure here.
We're getting some reporting from our Nancy Cortez on Capitol Hill. She said the news broke just as this is talking about the Bolton article, the New York Times, the new excerpts. This news broke just as Senate Democrats and Republicans were walking into their prospective pre-trial lunches. A source inside the Senate Democratic lunch says that the story was just discussed during the lunch and that many senators are actually reading the article now as they eat. So, Siobhan, there was this lunch taking place. The Democrats have congregated. What do you make of Nancy's reporting here? They're all devouring this New York Times story as well.
Well, if there was any doubt about the trial extending into next week, erase that doubt. The new disclosures are clearly going to be explosive for the Senate Democrats, and it's hard to see them cutting short their opportunity to extend this trial.
Meredith, we just saw Senate managers walking in there. It's expected to start in about 10 minutes or so. Meredith, is the White House frustrated that Senators Collins and Mitt Romney are siding with Democrats on witness votes, or are they understanding that this was going to happen?
I'm sure they're frustrated by it, but these are two senators that have always taken a more independent streak and haven't been afraid to break from the White House, to break from President Trump on certain issues. And so I certainly think that they were expecting that there might be a few defectors when it comes to the actual vote. So I don't think it took anybody by surprise. But of course, there are others that they feel that they might be able to sway one way or the other, but certainly this new report from the New York Times could have an effect.
And it's not, Siobhan, just Republicans. You know, we've also been watching 3 Democratic senators, Joe Manchin, Kyrsten Sinema, Doug Jones, as being potential defectors from their own party. Is the Democratic leadership concerned that they might side with the president?
Not on the issue of witnesses. There is a possibility, of course, that at the end of the day, someone like Joe Manchin decides that he is not willing to convict the president. But it is a 2020 election year, and there is some sense among the leaders of both parties that members in tough races should be given a little bit of a pass to go their own way.
Siobhan, what about Michigan Senator Gary Peters? He comes from a state that the president won in 2016. He's up for re-election. Where does he stand on this issue?
You know, I don't know exactly where he stands on conviction. A good indicator is the votes that took place at the very beginning on whether or not to bring in witnesses. And all of the Democrats were in lockstep at that point. So even if Gary Peters decided to reverse himself, make a bit more of a bipartisan play, I would think that early vote would stick to him and that he's kind of boxed himself in at this point.
We know, Siobhan, this is going to be obviously a largely partisan vote here. What's the movement on in the House? You know, if they decide no witnesses move forward, do House investigations continue? Do they try to get John Bolton to speak and testify?
So House Intelligence Committee Chairman Adam Schiff has clearly indicated that this is an ongoing investigation. It's not going away. He has declined at this point to issue John Bolton a subpoena, and it appears this is a move to keep the pressure on the Senate, to let the pressure build. However, Nancy Pelosi, in her press conference yesterday, declined to rule out the possibility of bringing John Bolton in. So it seems that that is a play that is clearly on the table, that remains a possibility.
All right, my understanding is we have a White House response on the Bolton book that just came down. I want to read this to everyone. In a White House statement, they are denying that the meeting took place, and this is a statement from President Trump. It says, "I never instructed John Bolton to set up a meeting for Rudy Giuliani, one of the greatest corruption fighters in America, and by far the greatest mayor in the history of New York City, to meet with President Zelensky. That meeting never happened." Meredith, I want to turn to you. What do you make of that statement?
I'm just looking at it myself at the moment.
So they're saying the meeting never happened. You know?
Right, they're completely denying that the meeting ever happened. I think one of the things that's been interesting to watch is, of course, attacks on Ambassador Bolton's credibility. Bolton is somebody that has long been a player in Washington. He's long been a player in Republican politics. He served for President George W. Bush, of course, and he's been on the scene for a while. And he's also written a few books about his experiences. So one of the things that has been interesting, at least for me to watch, is how how his takes on what exactly happened have been attacked.
Yeah, at one point, Bolton said, Fiona Hill, remember, said that Bolton had warned Mr. Giuliani that Giuliani was a hand grenade. I'm quoting here, a hand grenade who's going to blow up everyone. Keir, I want to turn to you a little bit more. I want to get you to weigh in on all of this as well.
Well, I have a question maybe for some of our for Meredith or Siobhan, because they may know this better, but I would wonder whether or not the White House would keep visitor logs and logs of who is meeting with the president and at what time.
Meredith, I'll let you tackle that one about visitor logs and disclosing visitor logs.
Right. That's something that the White House doesn't disclose. Of course, they do track who comes in and out of the White House, but that's not something, of course, that we have access to. But that is a really excellent point. Of course, there are tabs on who the president would be meeting with. And if that information, of course, could be gleaned, this whole account could be disputed or proven.
From a legal standpoint, Keir, how do you think the White House counsel, I mean, these are pretty significant allegations here that John Bolton's putting out, and it sort of changes a little bit about who knew what, who was in the room, and the timeline of this pressure campaign. If you're the White House counsel, what are you trying to do today?
Well, first of all, I think the name of his book is The Room Where It Happened, right? And so now, whether or not it happened in the room, it's this is all just, I think, very good for the potential sales of Mr. Bolton's book. Look, we know from the summary, the call summary, that President Trump himself told President Zelensky to get in touch with Mr. Giuliani and Mr. Barr. So the idea that President Trump, at least we know as of July 25th, he wanted that to happen. This account by Mr. Bolton moves that time frame back to May. But it's hard. It's perhaps I haven't studied that denial, but I don't. But maybe he's not saying that the meeting itself didn't occur, but that the discussion that is described by Mr. Bolton didn't occur at that meeting. I haven't had a chance to study that denial.
Yeah.
But as a former prosecutor, we really when you hear something like this, you really get into the weeds. And you want to look for the evidence that could either corroborate or contradict, like White House logs or other evidence that might confirm.
As somebody who is not entrenched in the legal community as you are, it's been hard to watch just because this really is not like a normal trial.
No, it's very different. And the fact that Mr. Cipollone might be a witness while he's on the floor of the Senate acting as President Trump's counsel, a key witness, a material witness, given these denials, that is something that would be the subject of motion practice in a courtroom, and you'd have a judge who would rule on disqualification of counsel. And here we have the Chief Justice who's officiating, but is acting more in the role of a guide as opposed to a decider. Mm-hmm. And so we're in very different territory from what courtroom procedures are.
Mm-hmm. Siobhan, I want to turn to you. We've just got a few more minutes left in our coverage. What are you looking for? Who are the senators you are watching? And what do you think could be dramatic and that could change the landscape in the next few hours?
I am watching what Lisa Murkowski does on the Senate floor, who Mitch McConnell sends as an emissary to kind of twist her arm. That's something he never does directly, but he has emissaries. I'm watching to see what Democrats are going to do on this question of evidence. One point I will note is that the line that the White House had been putting out is that Mick Mulvaney had always left the room when Rudy Giuliani was talking to Trump so as to preserve attorney-client privilege. If that is not the case, if John Bolton's account is correct, I would think that would be very serious and something Democrats would try to find a way to address on the floor. So I think that could potentially be explosive. Also, this question of Pat Cipollone having a conflict of interest, it's something that Democrats had raised earlier on, but does that now come to a head and make the Senate trial a place of incredibly personal friction? This is not a case in which lawyers and senators are evaluating some third party. They're evaluating themselves, people within their own ranks.
We're going to have to leave it there. I want to thank our entire panel today, Siobhan Hughes on Capitol Hill, Meredith McGraw, and Keir Dugal. We want to take you now to a CBS News special report. I'm Rena Ninan in New York.
This is a CBS News special report. I'm Norah O'Donnell, and we are going to begin this hour with breaking news. Just as the Senate today begins a debate on whether to call witnesses in the impeachment trial of President Trump, a bombshell new report has emerged that could influence the final vote. The New York Times is reporting today that John Bolton, the former national security advisor, will claim in his upcoming book that President Trump directed him as early as last May to help pressure Ukraine for damaging information on Democrats, including Joe Biden. Now, the president himself just moments ago issued a categorical denial to Bolton's claims. We're going to get to that in a minute. Also, Senate Democrats and a couple of Republicans would like to call Bolton as a witness. Also want to update you on some other breaking news. There is a heavy police presence near Mar-a-Lago at this hour. The president's Palm Beach resort, I should say. There are reports that a car tried to breach 2 security gates not far from the resort. They were apprehended, those suspects inside that car, and we're just getting more information about exactly what happened. But of interest, of course, because the president is headed to Mar-a-Lago tonight. Want to begin with all of the news this morning and introduce our panel here. Margaret Brennan is host of Face the Nation and joins us here. CBS News political analyst Jonathan Turley is a constitutional scholar. Our political contributors, Reince Priebus, who is President Trump's first chief of staff, and Jamal Simmons, who is a Democratic strategist. And we've got reporters all over Washington, which we're also going to get to in just a moment. But Margaret, let me start with you because you cover foreign affairs as well and know all the details of this story. Conveniently, this lands with a big thud at noon, just as Republicans go into their private lunch to decide what step they take next. And now Bolton is alleging that it wasn't just August that he got the instruction from the president. It was late May. And there are some other tantalizing details.
There are, and that month of May is a key time period. Specifically, what the New York Times is reporting now is that John Bolton, in this manuscript, this draft of his book, recounts a 10-minute conversation in the Oval Office that involved Pat Cipollone, the White House counsel, a conversation with Rudy Giuliani, the president's personal attorney, Mick Mulvaney, who was doing double duty as budget director, directly involved with aid, and chief of staff. And in that conversation, he says that he was instructed by the president himself to call Ukraine's president, who had just been elected, and to urge him personally to meet with Rudy Giuliani, his personal representative. What is interesting about this timeline is it lines up exactly with May 7th. Marie Yovanovitch, the ambassador to Ukraine, pushed out early. You then also have, I think, May 9th, that Rudy Giuliani was scheduled to go to Ukraine. So Bolton is, the events are lining up in that time frame where this conversation immediately preceded or was around the same time that Rudy Giuliani was openly talking to the press about what he was trying to do in Ukraine with this pressure campaign to get information on Joe Biden. It wasn't secret because he talked about it on television. He talked about it with the New York Times. And now we know from this reporting, he talked about it with the president, John Bolton, and the White House counsel in the room. That's key as well, because Pat Cipollone, the man mentioned in this account, is one of the lead defense counsels on the floor of the Senate. So if he had personal knowledge and was personally involved, that adds a new wrinkle. I'm sure he's going to be asked about it today.
And now we have from the president himself a statement saying, I never instructed John Bolton to set up a meeting for Rudy Giuliani, one of the greatest corruption fighters in America and by far the greatest mayor in the history of New York City, to meet with President Zelensky. That meeting never happened. Now, interestingly, that statement does not deny that he asked him to tie the aid to the investigation. It just says, I never instructed Bolton to set up a meeting for Giuliani.
Right. Well, and Bolton says he didn't do that, what he was told to do. But what we know is that in that conversation in July, that partial call record, the memorandum, Rudy Giuliani was brought up in the course of that conversation between the two leaders, with President Zelensky saying, and by the way, I am going to meet with Rudy Giuliani. He brought it up, but he brought it up in this framing. We now know that the president's personal attorney and perhaps other members of the White House team were urging the meeting to take place. So it hurts part of the Republican defense there. But again, it is he said versus he said, as you say, because Rudy Giuliani also saying it's categorically untrue.
All right, let's bring in Nancy Cordes on Capitol Hill. I was up there earlier on the Hill, and it's already been a busy morning, as of course the early thought was that this whole thing may be wrapped up by the end of the day. That the Republicans believe they had the vote to block any additional witnesses, that there could be an acquittal vote late tonight or early in the morning. This has thrown all of that into doubt. But whether this trial will now stretch into next week, what are you hearing?
Well, Nora, as you mentioned, this news broke just as senators were walking into their lunches with their party that they hold every day before the trial begins. And I'm told that Democratic senators were actually sitting there in the lunch, many of them, reading the article as they ate, discussing it with one another. It came up at the lunch. I managed to reach one of those senators, Chris Coons of Delaware, who said, "Stunning article, just reading it now, makes me reconsider many statements I have heard from Trump's team over the course of this trial." New Jersey Senator Bob Menendez spoke to us a short time ago. He said the drumbeat for witnesses becomes clearer and more powerful every day with every revelation. Democrats are homing in particular on that detail that Margaret mentioned, the fact that the chief White House counsel, Pat Cipollone, was, according to Bolton in this manuscript, in the Oval Office while the president was urging Bolton to participate in this effort to pressure the Ukrainians. And it is Cipollone and his team that have been arguing, after all, over the past week and a half, that there is absolutely no evidence that the president asked anyone to pressure Ukraine. So that is absolutely going to come up at the trial today.
And what has the president's counsel, Pat Cipollone, said about whether there were efforts by the president to tie the aid to Ukraine to investigations of the Bidens?
There has been a blanket rejection over and over again, Nora, at this trial by the president's team to the notion that there is any evidence whatsoever that the president asked any top official on his behalf to pressure the Ukrainians. We have heard it from multiple White House lawyers. And beyond that, it was Cipollone himself who authored this very fiery and now infamous 8-page letter to Congress back in October explaining why the White House was not going to be cooperating with any requests for documents or for witnesses. They call this impeachment inquiry a sham. He said the president is not going to allow your constitutionally illegitimate proceedings to distract him because he has a country to lead. And what Democrats are already arguing is that this new article indicates perhaps that Cipollone may have had a personal reason for sending this letter and for refusing to allow witnesses to participate because perhaps he thought that his involvement might come to light. That's what Democrats are arguing. What Republicans are sure to say is that this is simply another attempt in the closing days of this trial to make the president look bad when Democrats clearly don't have the votes to remove him from office.
All right, Nancy, thank you. I want to go to Weijia Jiang at the White House because the timing, of course, is key. Not only had the White House and Republicans hoped to wrap up this impeachment trial today, they wanted the president to be able to give a big interview with Sean Hannity on Sunday during the Super Bowl. Monday, of course, the Iowa caucuses. Tuesday, the State of the Union, where the president could claim a victory lap, even on the day of the Super Bowl. Does this now throw into doubt that timeline for what the White House had hoped would be a quick end to this trial in the Senate?
Nora, even before this Bolton bombshell, the White House was acknowledging that this could go into next week and even Wednesday, which is something that they are dreading. You're right. They really wanted this to wrap up tonight, and they were hoping for that. But I can tell you, I talked to sources this morning who are working with the president's team. There are other members of our White House unit who talked to lawyers who are actually on that team. And we all got a different answer when we asked about when they thought this trial was going to wrap up. And that's because, you know, regardless of what they think, regardless of what educated guess they can make, they know it's really up to the Democrats and how long they want to draw this out after they vote on whether or not to hear from witnesses. We are anticipating a lot of other motions, a lot of other debate, and so they are really aware that this could continue next week. And, you know, one thing that sources wanted to stress is that regardless of what happens, President Trump is going to deliver that State of the Union on Tuesday, even if this hasn't wrapped up, because it's really an opportunity not only for him to tout his achievements, but to talk about impeachment and to deliver the message we've been hearing that this is all trying to undermine him and his presidency as he tries to continue working for the American people. Now, of note, with regard to that Bolton bombshell, I will say typically what we've seen always is the president tweeting a response. And I really thought he was going to attack Bolton's character again and say that he's just a disgruntled employee who has a book to sell. But this statement, Nora, that you read goes right to the facts because the New York Times has so many details about that meeting. And the statement from President Trump came from the press office. And I can tell you that that's unusual for them because typically the White House press secretary or one of her deputies will write something in defense of the president, but not from the first person. And today we saw this was President Trump saying that meeting never happened. Nora?
All right, Weijia Jiang, thank you. And just as Weijia was talking, I'm texting with a source about what happened inside that Republican luncheon, that we are expecting a vote around 5 o'clock or later on the witness, the question about the witnesses, and that sounding like a final vote on acquittal of the president could be Tuesday or Wednesday of next week. And I must say just exactly what Weijia was saying. I was with a top Republican part of the leadership and early this morning, and that was the thought that they were going to get it done by the end of the day. So things have changed a little bit. Bryant, I have to ask you, because you are the former White House chief of staff to President Trump. I mean, extraordinary that the National Security Advisor, not only writing a book about his time in the White House, but also this week we're getting different details about his conversations with the president. And in this particular case, an Oval Office meeting that included the White House counsel, the president's personal attorney, about what the president was instructing his national security advisor to do.
Well, obviously don't know what's true and what's not. I think Rudy Giuliani denied the report outright. Mick Mulvaney basically denied it 3 days ago with that broad sweeping denial of any meeting or any conversation that he's heard or witnessed. But look, I don't think it's going to change much. Lamar Alexander's already provided the trap door here, where he said, even if it's true, I don't like it. I didn't think it was appropriate, but it's not enough to remove the president. Therefore, no witnesses in a vote to acquit. So I think the roadmap has been laid out by Lamar Alexander, no matter what you think about this new report.
Can I ask you, because the sense, too, in talking to a number of Republicans is they feel like Lamar Alexander, which is that the president's actions were inappropriate, that they were wrong. They're no longer really contesting some of the facts that the managers laid out, but that they don't believe it's impeachable, removal, an offense that's worthy of removal from office. Does it matter then if some of these senators then go on the floor and give speeches, which I've heard they want to do, and essentially talk about what was wrong about what does it matter?
Well, what you may see is sort of a constructive censure, where the senators say, we believe you proved your case. We believe that he said something deeply inappropriate. We believe that he tied these two things together. We just don't believe it's enough to remove an American president. So you could have a majority of senators essentially going on the record chastising the president. But this can also backfire. You touched on
McConnell would never let that happen, I don't think.
Well, he might not be able to control that with some of these members. I agree with you. I've talked to a number of these senators, and they do hold that view. But this can also backfire. This is another perfectly timed leak. And these are people that don't like to be played. And they're being played right now.
Who's being played?
The Senate. I mean, this leak hit right when they're about to talk about the witnesses. The earlier leak happened right when the White House is going to present its main defense. And these are people that don't like to be played.
Right. And I think it's also going to add to the biggest problem the defense has, or the House managers have. They conducted a lousy investigation. They've built a terrible record. And they've gone to the jury with a terrible record. And this is going to highlight the terrible record and the fact that they didn't take their time. And for as much complaining as they're going to do, it just highlights the fact that they didn't take the time to do a decent job.
But would you acknowledge that part of the record that they lined up is now lining up with the president's own national security advisor?
Perhaps, but they have never, in the record, there's no direct linkage. And the only apparent direct linkage is an article that we have now at noon that everyone else in the room is going to deny by the time we get to our first break.
I will point you to another article, Article 2 of the impeachment, which is that the president obstructed Congress in his attempt, in their attempt to try to find out what happened. And he stonewalled them so he couldn't get it. I'm at the point now, if this were really a fair process, people really want to know what happened, you got to put the president under oath. Because the president is someone who is willing to say whatever it takes to say in front of the news media. We saw that in the course of the Mueller investigation. He does not feel like he has to be honest when communicating with the American public or the news media, but he should have to acknowledge whether or not he wanted to do this, and that would help inform him.
Bolton is not a novice. He's been around Washington for decades and has worked for different administrations, and I can't imagine that he would allege something like this, that the President of the United States, his White House counsel, Rudy Giuliani, were all involved in, and just do it based on his word. I don't know. That's just a sense that I have.
Right.
It's not.
He's known as a masterful bureaucrat at working systems, taking copious notes, keeping records, and doing things methodically.
He's not the only one. Remember, Sondland said they were all in the loop. I mean, this came out repeatedly over the course of the House testimony that it was more than just the president. There were other people in the administration involved.
How do you think this then affects? It's not a legal hearing that's going on right here. It's a political one, but we do have 2 hours of debate on each side. This is just, you're going to hear the House managers say, proof again, we need to prolong this trial.
But the White House has to confront the fact it does tear away at their narrative. In the last day, they said this was a topical subject because an article had just been published on corruption in Ukraine. This pushes it back a bit, so it does chip away at the narrative. But you're still with the central problem. A lot of these senators, I think, honestly don't believe that this phone call should be the basis to remove a president.
And that's what it comes down to. I mean, the book's going to come out eventually, right? So this conversation is going to be had again with more detail. But it's going to come down to the fact that even if true, you don't remove a president 9 months before an election.
Chaplain Barry Black is bringing everyone to prayer, including the Chief Justice you see there. Want to bring in Nancy Cordes as well. Nancy, jump in here as you follow this conversation.
Well, Nora, I think one of the most intriguing developments over the past 12 hours or so is the fact that a top Republican, Lamar Alexander, even as he announced that he was not going to be voting in favor of hearing from additional witnesses, said that the reason that he doesn't need to hear from witnesses like John Bolton is because he believes that Democrats have already proven their case, that the president did something inappropriate, pressured Ukraine for his personal benefit using U.S. military aid. The only thing he went on to say is that he just doesn't think that that's impeachable. But that is a top-ranking, longtime Republican basically saying that the House impeachment managers are right on the facts of this case and the president's defense is wrong. And it's going to be very interesting to see if more senators now sort of follow that blueprint, Republican senators that is, and come out with similar justifications for their decision to vote against witnesses and for acquittal.
All right, Nancy Cordes there on Capitol Hill, and we're going to go now to listen to the Majority Leader.
We'll take a break about 2 hours out.
Pursuant to the provisions of Senate Resolution 483, the Senate has provided up to 4 hours of argument by the parties equally divided on the question of whether or not it shall be in order to consider and debate under the impeachment rules any motion to subpoena witnesses or documents. Mr. Manager Schiff, are you a proponent or opponent? Mr. Cipollone, are you a proponent or opponent? Thank you. Then, Mr. Schiff, you may proceed.
Before I begin, Mr. Chief Justice, the House managers will be reserving the balance of our time to respond to the argument of counsel for the President. Mr. Chief Justice, Senators, fellow House managers, and counsel for the President, I know I speak for my fellow managers as well as counsel for the President in thanking you for your careful attention to the arguments that we have made over the course of many long days. Today we were greeted to yet another development in the case when the New York Times reported with a headline that says, "Trump told Bolton to help his Ukraine pressure campaign," book says. The president asked his national security advisor last spring in front of other senior advisors to pave the way for a meeting between Rudolph Giuliani and Ukraine's new leader. According to the New York Times, more than 2 months before he asked Ukraine's president to investigate his political opponents, President Trump directed John R. Bolton, then his national security advisor, to help with his pressure campaign to extract damaging information on Democrats from Ukrainian officials, according to an unpublished manuscript by Mr. Bolton. Mr. Trump gave the instruction, Mr. Bolton wrote, during an Oval Office conversation in early May that included the acting White House Chief of Staff, Mick Mulvaney, the president's personal lawyer, Rudy Giuliani, and the White House counsel, Pat Cipollone, who is now leading the president's impeachment defense. Now, you will see in a few moments, and you will recall Mr. Cipollone suggesting that the House managers were concealing facts from this body. He said all the facts should come out. Well, there's a new fact which indicates that Mr. Cipollone was among those who were in the loop. Yet another reason why we ought to hear from witnesses. Just as we predicted, and it didn't require any great act of clairvoyance, the facts will come out. They will continue to come out. And the question before you today is whether they will come out in time for you to make a complete and informed judgment as to the guilt or innocence of the president. Now, the Times article goes on to say that Mr. Trump told Mr. Bolton to call Vladimir Zelensky, who had recently won election as president of Ukraine, to ensure Mr. Zelensky would meet with Mr. Giuliani, who is planning a trip to Ukraine to discuss the investigations that the president sought in Mr. Bolton's account. Mr. Bolton never made the call, he wrote. Never made the call. Mr. Bolton understood that this was wrong. He understood that this was not policy. He understood that this was a domestic political errand and refused to make the call. The account in Mr. Bolton's manuscript portrays the most senior White House advisors as early witnesses in the effort that they have sought to distance the president from, including the White House counsel. Over several pages, according to the Times, Mr. Bolton laid out Mr. Trump's fixation on Ukraine and the president's belief, based on a mix of scattershot events, assertions, and outright conspiracy theories, that Ukraine tried to undermine his chances of winning the presidency in 2016. As he began to realize the extent and aims of the pressure campaign, Mr. Bolton began to object. He wrote in the book, affirming the testimony of a former National Security Council aide, Fiona Hill, who had said that Mr. Bolton warned that Mr. Giuliani was a hand grenade who's going to blow everybody up. Now, as you might imagine, the president denies this. The president said today, I never instructed John Bolton to set up a meeting for Rudy Giuliani, one of the greatest corruption fighters in America. So here you have the president saying John Bolton is not telling the truth. Let's find out. Let's put John Bolton under oath. Let's find out who's telling the truth. The trial is supposed to be a quest for the truth. Let's not fear what we will learn. As Mr. Cipollone said, let's make sure that all the facts come out.
Mr. Chief Justice, Senators, Counsel for the President, last Tuesday at the onset of this trial, we moved for Leader McConnell's resolution to be amended to subpoena documents and witnesses from the outset. This body decided to hold the question over. You have now heard opening arguments from both sides. You have seen the evidence that the House was able to collect. You have heard about the documents and witnesses President Trump blocked from the House's impeachment inquiry. We have vigorously questioned both sides. The President's counsel has urged you to decide this case and render your verdict upon the record assembled by the House. The evidence in the record is sufficient. It is sufficient to convict the President on both articles of impeachment, more than sufficient. But that's simply not how trials work. As any prosecutor or defense lawyer would tell you, when a case goes to trial, both sides call witnesses and subpoena documents to bring before the jury. That happens every day in courtrooms all across America. There is no reason why this impeachment trial should be any different. The common sense practice is born out of precedents. There has never before been a full Senate impeachment trial without a single witness. In fact, you can see in the slide, in every one of the 15 prior impeachment trials, the Senate has called multiple witnesses. Today, we ask you to follow this body's uniform precedents and your common sense. We urge you to vote in favor of subpoenaing witnesses and documents. Now, I'd like to address one question at the offset. There has been much back and forth about whether, if the House believes it has sufficient evidence to convict, which we do, why do we need more witnesses and documents? So I'd like to be clear. The evidence presented over the past week and a half strongly supports a vote to convict the President. The evidence is overwhelming. We have a mounting of evidence. It's direct, it's corroborated by multiple sources, and it proves that the President committed grave, impeachable offenses to cheat in the next election. The evidence confirms that if left in office, President Trump will continue to harm America's national security. He will continue to seek to corrupt the upcoming election, and he will undermine our democracy, all to further his own personal gain. But this is a fundamental question that must be addressed. Is this a fair trial? Is this a fair trial? Is this a fair trial? Without the ability to call witnesses and produce documents, the answer is clearly and unequivocally no. It was the President's decision to contest the facts, and that is his right. But because he has chosen to contest the facts, he shall not be heard to complain. He shall not be heard to complain that the House wishes to further prove his guilt, to answer the questions he would raise. He complains that few witnesses spoke directly to the President about his misconduct beyond his damning conversations with Sondland and Mulvaney. Okay, let's hear from others then. The witnesses the House wishes to call directly to the President's own words, his own admissions of guilt, his own confessions of responsibility. If they did not, all the President's men would be on their witness list, not ours. These witnesses and the documents their agencies produce tell the full story. And I believe that we are interested in hearing the full story. You should want to hear it. More than that, the American people, we know they want to hear it. The House Republicans' own expert witness in the House, Professor Turley, said if you could prove The president used our military aid to pressure Ukraine to investigate a political rival and interfere in our elections. It would be an impeachable abuse of power. And Senator Graham, too, recognized that if such evidence existed, it could potentially change his mind on impeachment. Well, we now have another witness, a fact witness, who would reportedly say exactly that. Ambassador Bolton's new manuscript, which we will discuss in more detail in a moment, reportedly confirms that the president told him in no uncertain terms. We're talking about the former national security advisor saying the president told him in no uncertain terms, no aid until investigations, including the Bidens. For a week and a half, the president has said no such evidence exists. They are wrong. But if you have any doubt about the evidence, the evidence is at your fingertips. The question is, will you let all of us, including the American people, simply hear the evidence and make up their own minds? And you can make up your own minds, but will we let the American people hear all of the evidence? You'll recall that Ambassador Bolton, the president's former national security advisor, is one of the witnesses we asked for last Tuesday. We did not know at the time what he'd say. We didn't know what kind of witness that he would be, but Ambassador Bolton made clear that he was willing to testify and that he had relevant first-hand knowledge that hadn't yet been heard. We argued that we all deserve to hear that evidence, but the president opposed him. Now we know why. Because John Bolton could corroborate the rest of our evidence and confirm the president's guilt. So today, senators, we come before you and we argue again that you let this witness and the other key witnesses we have identified come forward so you have all of the information available to you when you make this consequential decision. If witnesses are not called here, these proceedings will be a trial in name only. And the American people clearly know a fair trial when they see one. Large majorities of the American people want to hear from witnesses in this trial, and they have a right to hear from witnesses in this trial. Let's hear from them. Let's look them in the eye, gauge their credibility, and hear what they have to say about the president's actions. For the same reasons, this body should grant our request to subpoena documents, the documents that the president also blocked the House from obtaining, documents from the White House, the State Department, DOD, and OMB that will complete the story and provide the whole truth, whatever they may be. We ask that you subpoena these documents so that you can decide for yourself. If you have any doubt as to what occurred, let's look at this additional evidence. To be clear, we're not asking you to track down every single document or to call every possible witness. We have carefully identified only 4 key witnesses with direct knowledge who can speak to the specific issues that the president has disputed. And we targeted key documents which we understand have already been collected, for example, at the State Department. They've already been collected. This will not cause a substantial delay. As I made clear last night, these matters can be addressed in a single week. As we made clear last night, these matters can be addressed in a single week. We know that from President Clinton's case. There, the Senate voted to approve a motion for witnesses on January 27. The next day, it established procedures for those depositions and adjourned as a court of impeachment until February 4. In that brief period, the parties took 3 depositions. The Senate then resumed its proceedings by voting to accept the deposition testimony into the record. In this trial, too, let's do the same. We should take a brief 1-week break for witness testimony and document collection, during which time the Senate can return to its normal business. The trial should not be allowed to be different from every other impeachment trial or any other kind of trial, simply because the president doesn't want us to know the truth. The American people that we all represent, the American people that we all love and care about, deserve to know the truth. And a fair trial requires it. This is too important of a decision to be made without all of the relevant evidence. Before turning to the specific need for these witnesses and documents, I want to make clear we are not asking you again to break new ground. We're asking quite the opposite. We are asking you to simply follow the Senate's unbroken precedents and to do so in a manner that allows you to continue the Senate's ordinary business. The Senate, sitting as a court of impeachment, has heard witness testimony in every other, as we've said earlier, in every other 15 impeachment trials in the history of the Republic. And in fact, these trials have had an average of 33 witnesses. And the Senate has repeatedly subpoenaed and received new documents while adjudicating cases of impeachment. That makes sense. Under our Constitution, the Senate does not just vote on impeachments. It does not just debate them. Instead, the Senate is commanded by the Constitution to try all cases of impeachment. Well, a trial requires witnesses. A trial requires documents. This is the American way, and this is the American story. If the Senate denies our motions, it would be the only time in history it has rendered a judgment on articles of impeachment without hearing from a single witness or receiving a single relevant document from the president whose conduct is on trial. And why? How can we justify this break from precedents? How would we justify, for what reason would we break precedents in these proceedings? There are many compelling reasons beyond precedents that demand subpoenas for witnesses and cases and documents in this case. And at this time, I yield to Manager Garcia.
And that is Val Demings of Orlando, Florida. As the Democrats are making their final arguments, they get 2 hours. The White House team gets 2 hours, as today the United States Senate will vote on whether to continue this trial and call future witnesses. It looks already like we know the outlines of that vote. We have just heard from Republican Senator Rob Portman of Ohio. He said he will vote no on witnesses. We have heard from Republican Senator Lisa Murkowski of Alaska, who will vote no on witnesses. These were some of the senators that could potentially prolong this trial and seek more information. So now we only have 2 senators on the record, Senator Susan Collins of Maine, Mitt Romney of Utah, who say they want more witnesses. So we are expecting a vote at around 5 or 6 o'clock tonight. And those numbers have even though this New York Times report has come out, you see the Republicans saying In the words of Rob Portman today, the president's actions were inappropriate, but not something worthy of removal of office. Reince?
Well, and like I said earlier, the roadmap has, for those weary senators, has been set by Senator Portman. I think now on the Republican side, this is now a matter of chasing down whether or not Joe Manchin, whether Sinema or any of these other senators, Senator Jones of Alabama,
Democratic senators,
would Democrats vote to acquit the president. And I think that's really the final story left in this conversation.
In addition to the timeline, as this appears it may stretch now into next week. Of course, today was the day we thought the President of the United States could be acquitted of these charges. It looks like that timeline slipping a bit. But, Margaret, on these details from the President's National Security Advisor, placing this discussion about tying the aid to the investigations now earlier than we had thought in early May, a really interesting part if you look at the calendar. It was days after Joe Biden had announced his campaign for the presidency.
Days after Joe Biden announced, we have a letter from Rudy Giuliani that has been made public because of one of his business associates who's turned over letters saying that Rudy Giuliani planned to meet May 13th or May 14th with the president of Ukraine. You have John Bolton saying it was in this month of May. May 7th is when Marie Yovanovitch, the ambassador, was forced out of her position. So everything comes together in terms of the confluence of events that suggests and shows that this wasn't just one-off phone call on July 25th. This was a concerted effort that is being established here. And inappropriate, as you said, Rob Portman, the senator, is referring to it as that, which is basically saying what Lamar Alexander did, who put in his statement, by the way, Democrats proved their case, but they didn't do it well enough to force the ejection of a president.
Yeah, this is what I was talking about in terms of a constructive censure, that if enough senators come forward publicly and say, we don't accept the president's perfect narrative, we accept the allegations, we don't think they rise to the level to remove a president. But it is fascinating, because this New York Times article moves the timeline. You know, the key for the White House was to keep the focus on August and September, to keep it in that little window of time. This is extending the timeline back to the days of May and what happened then. But it may be just simply too little too late. That I think that they've lost the majority of senators. And quite frankly, I think partially it is because they blundered. They gave up their record, they gave up their case too early because they were rushing to a vote.
And this description, of course, by Bolton, his title of his book is In the Room Where It Happened, a play, of course, on Hamilton, and that room is clearly the Oval Office he's describing. Where does this leave the Democrats?
Well, the Democrats have had a couple victories here, actually. If you look at it this way, the president, by moving the vote beyond the State of the Union and beyond Iowa, that's a loss for the president. He wanted to be able to stand there and declare himself, victorious that day. He's not going to be able to do that. Secondly, what Lamar Alexander said is going to help the Democrats when they make their case, because now what you have is bipartisan condemnation of the president's actions. I think that's going to be very helpful politically when the Democrats go out. And lastly, I'll just say Senator Collins, she's been getting beaten up pretty hard by the Democratic Senate Campaign Committee. They've been really going after her in Maine. What you're going to see from her now, if she votes for witnesses, she'll kind of get the best of both worlds. She'll be able to say, I voted for witnesses, but it won't actually matter. The question is, will Donald Trump still punish her? Because in his world, you get no free licks on Donald Trump. He always punches back.
It should be noted that the original rules laid out by the Republican leader McConnell did not allow for a vote on witnesses. It was Senator Collins pushing for that ultimately led us to this moment today. I heard, and we're reporting here at CBS News, that there were threats in the state of Maine, the FBI looking into about some threats about school shootings, that if Senator Collins voted for acquittal, that they would carry out these. This is sort of the level of the level we're at in terms of the anger on both sides about this particular vote, and the Capitol Police and FBI are on top of that. We're going to continue our coverage of the president's impeachment trial on our 24-hour streaming network, CBSN. You can watch it at cbsnews.com or on our CBS News app. We will be back on the air.
I'm Rena Ninan in New York, continuing our CBSN special report. We want to take you back live to the Senate floor. You see right there, Sylvia Garcia.
Silent these witnesses and hide these documents. We don't know precisely what the witnesses will say or what the documents will show, but we all deserve to hear the truth. And more importantly, the American people deserve to hear the truth. Never before has the president been put himself above the law and hid the facts of his offenses from the American people like this one. We cannot let this president be different. Quite simply, the stakes are too high. Second, as this builds on what we have been arguing, the Senate requires and should want a complete evidentiary record before you vote on the most sacred task that the Constitution entrusts in every single one of you. I can respect that some of you have deep beliefs that the removal of this president would be divisive. Others, you may believe that allowing this president to remain in the Oval Office would be catastrophic to our republic and our democracy. But regardless of where you are, or regardless of where you land on this spectrum, you should want a full and complete record before you make a final decision and to understand the full story. It should not be about party affiliation. It should be about seeing all the evidence and voting your conscience based on all the relevant facts. It should be about doing impartial justice. Consider the harm done to our institutions, our constitutional order, and the public faith in our democracy. If the Senate chooses to close its eyes to learning the full truth about the president's misconduct, how can the American people have confidence in the result of a trial without witnesses? Third, the president should want a fair trial. He has repeatedly said that publicly, that he wants a trial on the merits. He specifically said it, you saw a clip, that he wanted a fair trial in the Senate. And that would have to be with witnesses that testify, including John Bolton and Mick Mulvaney. He said that he wants a complete and total exoneration. Well, whatever you say about this trial, there cannot be an exoneration without hearing from those witnesses, because an acquittal on an incomplete record after a trial lacking witnesses and evidence will be no exoneration. It will be no vindication, not for the president, not for this chamber, and not for the American people. And if the president is telling the truth and he did nothing wrong, and the evidence would prove that, then we all know that he would be an enthusiastic supporter of subpoenas. He would be here probably himself, if he could, urging you to do subpoenas if he had information that would prove he was totally not in the wrong. If he is innocent, he should have nothing to hide. His counsel should be the ones here asking today to subpoena Bolton and Mulvaney and others for testimony. The president would be eager to have the people closest to him to testify about his innocence. He would be eager to present the documents that show he was concerned about corruption and burden sharing. But the fact that he has so strenuously opposed the testimony of his closest advisors and all the documents speaks volumes. You should issue subpoenas to the president so that the president can get the fair trial that he wanted. But more importantly, so the American people can get the fair trial that they deserve. The American people deserve a fair trial. I said at the onset of this trial that one of the most important decisions you would make at this moment in history will not be whether you convict or acquit, but whether the president and the American people will get a fair trial. The process is more than just the ultimate decision, because the faith in our institution depends on the perception of a fair process. A vote against witnesses and documents undermines that faith. Senators, the American people want a fair trial. The overwhelming majority of Americans, 3 in 4 voters, 3 in 4, as of this past Tuesday, believe that this trial should have witnesses. Now, there's not much that the American people agree on these days, but they do agree on that. And they know what a fair trial is. That involves witnesses and it involves evidence. The American people deserve to know the facts about their president's conduct and those around him. And they deserve to have confidence in this process, confidence that you made the right decision. In order to have that confidence, the Senate must call relevant witnesses and obtain relevant documents withheld thus far by this president. The American people deserve a fair trial. I now yield to my colleague, Manager Parsons.
Mr. Chief Justice, members of the Senate, counsel for the President. Last week, the House managers argued for the testimony of 4 witnesses: Ambassador John Bolton, Mick Mulvaney, Robert Blair, and Michael Duffy. And during the presentations from both parties, it has become abundantly clear why the direct testimony from those witnesses is so critical, and new evidence continues to underscore that importance. So let's start with John Bolton. The President's counsel has repeatedly stated that the President didn't personally tell any of our witnesses that he linked the military aid to the investigations.
There is simply no evidence anywhere that President Trump ever linked security assistance to any investigations. Most of the Democrats' witnesses have never spoken to the President at all, let alone about Ukraine security assistance. Not a single witness testified that the President himself said that there was any connection between any investigations and security assistance, a presidential meeting, or anything else.
Simply not true, as the testimony of Ambassador Sondland and the admission of Mick Mulvaney make very clear. The evidence before you proves that the President not only linked the aid to the investigations, he also conditioned both the White House meeting and the aid on Ukraine's announcement of the investigations. But if you want more, a witness to acknowledge that the President told them directly that the aid was linked, a witness in front of you, then you have the power to ask for it. I mentioned this portion, there's a slide, I mentioned this portion of Ambassador's manuscript in the beginning, and Manager Schiff referenced it as well. But he says directly that the President told him this. Now, the President has publicly lashed out in recent days at Ambassador Bolton. He says that Ambassador Bolton is, what Ambassador Bolton is saying is nasty and untrue. But denials in 280 characters is not the same as testimony under oath. We know that. Let's put Ambassador Bolton under oath and ask him point blank. Did the President use $391 million of taxpayer money, military aid, intended for an ally at war to pressure Ukraine to investigate his 2020 opponent? The stakes are too high not to. I'd like to briefly walk you through why Ambassador Bolton's testimony is essential to ensuring a fair trial. Also addressing some of the questions that you've asked in the past 2 days. First, turning back to Ambassador Bolton's manuscript. The President's counsel has said no scheme existed. And the President's counsel has cited repeated denials, public denials, of President Trump's inner circle about Bolton's allegations. None of them, of course, under oath. And as we know from the testimony of Ambassador Bolton, how important being sworn in really is. But Ambassador Bolton, as the top national security aide, has direct insight into the President's inner circle. And he is willing to testify under oath whether, quote, everyone was in the loop, as he testified before. Ambassador Bolton reportedly knows, quote, new details about senior cabinet officials who have publicly tried to sidestep involvement, end quote, including Secretary Pompeo and Mr. Mulvaney's knowledge of the scheme. Second, Ambassador Bolton has direct knowledge of key events outside of the July 25th call that confirm the president's scheme. Remember, this is exactly the type of direct evidence the President's counsel say doesn't exist. That's partly because they would like you to believe that the July 25th call makes up all of the evidence of our case. The call, of course, is just a part of the large body of evidence that you've heard about the past week, but it is a key part. But Ambassador Bolton has critical insight into the President's misconduct outside of this call, and you should hear it. Take, for example, the July 10th meeting with U.S. and Ukrainian officials at the White House. Dr. Hill testified during the meeting that Ambassador Sondland said that he had a deal with Mr. Mulvaney to schedule a White House meeting if the Ukrainians did the investigations. According to Dr. Hill, when Ambassador Bolton learned this, he told her to go back to the NSC's legal advisor, John Eisenberg, and tell him, quote, "I am not a part of whatever drug deal Sondland and Mulvaney are cooking up on this," end quote. We already have corroboration of Dr. Hill's testimony from other witnesses like Lieutenant Colonel Vindman. And we have new corroboration from Ukraine, too. Oleksandr Daniluk, President Zelensky's former national security advisor, recently confirmed in an interview that the, quote, roadmap for U.S.-Ukraine relations should have been the substance, but the investigations were raised, end quote. Daniluk also explained why this was so problematic. He raised concerns that being, quote, dragged into this internal process would be really bad for the country. And also, if there's something that violates U.S. law, that's up to the U.S. to handle, end quote. Daniluk elaborated that there were serious things to discuss at the meeting. But if instead Ukraine was being dragged into, quote, internal politics using our president who is fresh on the job and experience, that could just destroy everything, end quote. Another key defense raised by the president has been that Ukraine felt no pressure, that these investigations are entirely proper. Well, here's Ukraine saying the opposite of that. You know what else Daniluk said in the interview? Quote, "It was definitely John who I trusted," end quote, talking about Ambassador Bolton. So if you want to know whether Ukrainians felt pressured, call John Bolton as a witness. He was trusted by Ukraine and he was there for these key meetings. And he was so concerned that he characterized the scheme as a drug deal and urged Dr. Hill and others to report their concerns to NSC legal counsel, who reports to White House counsel Cipollone. So let's ask Ambassador Bolton these questions directly under oath. The president says Ukraine felt no pressure, that soliciting these investigations wasn't improper. Is that true? If it is true, why is Ukraine publicly saying that the talk of investigations could destroy everything? And if the president's administration thought this was okay, why did you use the words drug deal? We should ask him that. Why did you urge your staff to report concerns to lawyers? These are all questions that we can get the answers to. Third, the president has suggested the House managers have not presented any direct evidence about Mr. Giuliani's role in the scheme.
In fact, it appears the House committee wasn't particularly interested in presenting you with any direct evidence of what Mayor Giuliani did or why he did it. Instead, they ask you to rely on hearsay, speculation, and assumption, evidence that would be inadmissible in any court.
Well, once again, that's simply not true. But if you want more evidence, we know that Ambassador Bolton has direct evidence of Mr. Giuliani's role regarding Ukraine and expressed concerns about it. The president has suggested that Mr. Giuliani wasn't doing anything improper, and he was not involved in conducting policy. By their own admission, they said he wasn't doing policy. So let's ask John Bolton what Giuliani was doing, and whether the investigations were politically motivated or part of our foreign policy. He would know. Dr. Hill testified that Ambassador Bolton said Mr. Giuliani was, quote, a hand grenade, which he explained referred to, quote, all of the statements that Mr. Giuliani was making publicly that the investigations that he was promoting, that the storyline he was promoting, the narrative he was promoting was going to backfire, end quote. The narrative Mr. Giuliani was promoting, of course, was asking Ukraine to dig up dirt on Biden. Dr. Hill also testified that Ambassador Bolton was so concerned, he told Dr. Hill and other members of the NSC staff, quote, "Nobody should be meeting with Giuliani," end quote. And that was, quote, "closely monitoring what Mr. Giuliani was doing and the messaging that he was sending out," end quote. So let's ask Ambassador Bolton. If Mr. Giuliani wasn't doing anything wrong, why were you so concerned about his behavior? That you directed your staff to have no part in this. If Mr. Giuliani wasn't trying to dig up dirt on Biden, why did you seem to think he was, that he could, quote, blow everything up? Fourth, the president has said that there was nothing wrong with the July 25th call. But once again, the evidence suggests that Ambassador Bolton would testify that the opposite is true. According to witness testimony, Ambassador Bolton expressed concerns even before the call that it would be, quote, a disaster, because he thought there would be, quote, talk of investigations or worse. Now, if the president would have you believe that the call was perfect, as he's repeatedly stated, why don't we find out? Because all of the evidence before you suggests otherwise. And Ukraine knows this is not the case. The call was not perfect. Danny Ayalon is clear on this point. He said, quote, "One thing I can tell you that was clear from this July 25th call is that the issue of the investigations is an issue of concern for Trump," end quote. Or it was clear. But if there's still any uncertainty, we must ask Ambassador Bolton. If there was no scheme, how did you know President Trump would raise investigations on the call? What made you so concerned a call would be a disaster? Fifth, the president's main defense, once again, is that he withheld the military aid for a legitimate reason. But the evidence doesn't support that. We've heard a lot. The evidence doesn't support that. Witness testimony, emails, and other documents confirm that Ambassador Bolton and his subordinates, on many occasions, including through in-person meetings with the president himself, urged the president that there was no legitimate reason to withhold the aid. But if you're not sure, if you think this could in any way have been about a legitimate policy reason, let's ask the National Security Advisor, who was in charge of that. If this was simply a policy dispute, as the president argues, let's ask John Bolton whether that's true. The president also argues that you cannot evaluate the president's subjective intent, that the president can use his power any way he feels is appropriate. That's, of course, not the case. Whether his intent was corrupt is a central part of this case, as it is in nearly every criminal case in the country. As a backup argument, however, the president claims that we want you to read the president's mind. Juries, of course, are routinely...
Entire impeachment process is about the House manager's insistence that they are able to read everybody's thoughts, they can read everybody's intention, they think you can read minds.
They want to tell you what President Trump thought.
Of course, are routinely asked to determine the defendant's state of mind. That's central to almost every criminal case in the country. And it's disingenuous for the president's counsel to argue that the defendant's state of mind is unknowable, that it requires a mind reader, or is anything but the most common element of proof of any crime, constitutional or otherwise. But if you want more information, let's ask the president whether John Bolton can help fill in any gaps about his state of mind.
If you think about it, John, he knows some of my thoughts. He knows what I think about leaders.
The case is about the president's conduct in Ukraine. John Bolton knows a lot about that. Let's hear from him. A fair trial demands it. And it's more than just ensuring a fair trial. It's about remembering that in America, truth matters. As Mr. Bolton said on January 30th, quote, "The idea that somehow testifying to what you think is true is destructive to the system of government we have, I think, is very nearly the reverse. The exact reverse of the truth, end quote. Now, as Manager Schiff started this out, the truth continues to come out. Again, in an article today, more information. The truth will come out, and it's continuing to. The question here before this body is, what do you want your place in history to be? Do you want your place in history to be, let's hear the truth, or that we don't want to hear it?
Given our time constraints, we will now summarize the reasons why Mr. Mulvaney, Mr. Duffy, and Mr. Blair are also important. Let's turn first to Mr. Mulvaney. To begin with, Mr. Mulvaney participated in meetings and discussions with President Trump at every single stage of this scheme. We just talked about motive and intent. Well, if you want further insight into the president's motives or intent, further direct evidence of why he withheld the military aid in the White House meeting, you should call his acting chief of staff, who had more access than anyone. Mr. Mulvaney is important because the President's counsel continues to argue incorrectly that our evidence is just hearsay and speculation. Faced with Ambassador Sondland and Mr. Holmes saying this was all as clear as 2 + 2 = 4, the President says they are just guessing. That is simply not true. The evidence is direct. The evidence is compelling and confirmed by many witnesses, corroborated by text messages, emails, and phone records. But if you want more evidence, if you want another first-hand account for why the aid was withheld, for the undisputed quid pro quo for that White House meeting, let's just hear from Mick Mulvaney. Over and over again, Ambassador Sondland described to multiple witnesses how Mr. Mulvaney was directly involved in the president's scheme. Here's some of that testimony.
And so when I came in, Gordon Sondland was basically saying, well, look, we have a deal here that there will be a meeting. I have a deal here with Chief of Staff Mulvaney. There will be a meeting if the Ukrainians open up or announce these investigations and, into 2016 in Burisma. And I cut it off immediately there. Ambassador Bolton told me that I am not part of this whatever drug deal that Mulvaney and Sondland are cooking up.
What did you understand him to mean by the drug deal that Mulvaney and Sondland were cooking up?
I took it to mean investigations for a meeting.
Did you go speak to the lawyers?
I certainly did.
What I want to ask you about is he makes reference in that drug deal to a drug deal cooked up by you and Mulvaney. It's the reference to Mulvaney that I want to ask you about. You've testified that Mulvaney was aware of this quid pro quo, of this condition that the Ukrainians had to meet, that is, announcing these public investigations to get the White House meeting. Is that right?
Yeah, a lot of people were aware of it, and
including Mr. Mulvaney.
Correct.
Remarkably, the president is still denying the facts, even as they argue that if it's true, it's still not impeachable. But if the president did nothing wrong, if he held up the aid because of so-called corruption or burden-sharing reasons, he should want his chief of staff to come testify under oath before this distinguished body and say just that. Why doesn't he want Mulvaney to appear before the United States Senate? Well, we know the answer. because Mr. Mulvaney will confirm the corrupt shakedown scheme. Because Mr. Mulvaney was in the loop. Everyone was in the loop. As Ambassador Sondland summarized in his testimony on July 19th, he emailed several top administration officials, including Mr. Mulvaney, that President Zelensky was prepared to receive POTUS's call and would assure President Trump that he intends to run a fully transparent investigation and will turn over every stone. Mr. Mulvaney replied, "I asked NSC to set it up for tomorrow." The above email seems clear. Ambassador Sondland testified that it was clear, that he was confirming to Mr. Mulvaney that he had told President Zelensky he had to tell President Trump on that July 25th call that he would announce the investigation, which he explained was a reference to one of the two phony political investigations that President Trump wanted. And Mr. Mulvaney replies that he'll set up the meeting, consistent with the agreement that Sondland explained he'd reach with Mr. Mulvaney to condition a meeting on the investigations. But if there's any uncertainty, if there's any lingering questions about what this means, let's just question Mick Mulvaney under oath. Mr. Mulvaney also matters because we have heard several questions from this distinguished body of senators wanting to understand when or why or how the president ordered the hold on the security aid. As the head of the Office of Management and Budget, Mr. Mulvaney has unique insights into all of these questions. Your questions. Remember that email exchange between Mr. Mulvaney and his deputy, Rob Blair, on June 27th, when Mulvaney asked Blair about whether they could implement the hold? And Blair responded that it could be done, but that Congress would become unhinged. It wasn't just Congress. It was the Independent Government Accountability Office that determined that the president's hold violated the law. But if the president's counsel is going to argue without evidence that he withheld the aid as part of U.S. foreign policy, seems to make sense that the Senate should hear directly from Mr. Mulvaney, who has firsthand knowledge of exactly these facts. He said so himself.
Again, I was involved with the process by which the money was held up temporarily.
Why doesn't President Trump want Mick Mulvaney to testify? Why? Perhaps here's why.
Did he also mention to me in the past the corruption related to the DNC server? Absolutely. No question about that. But that's it. And that's why we held up the money. Now, there was a report.
So the demand for an investigation into the Democrats was part of the reason that he ordered to withhold funding to Ukraine?
The look back to what happened in 2016 certainly was part of the thing that he was worried about in corruption with that nation. And that is absolutely appropriate.
But to be clear, what you just described is a quid pro quo. It is funding will not flow unless the investigation into the Democratic server happen as well.
We do that all the time with foreign policy. We were holding up money at the same time for what was it? The Northern Triangle countries. We were holding up aid at the Northern Triangle countries so that they would change their policies on immigration. By the way, and this speaks to an important. I'm sorry. This speaks to an important point, because I heard this yesterday, and I can never remember the gentleman who testified. Was it McKinney, the guy? Is that his name? I don't know him. He testified yesterday. And if you go, and if you believe the news reports, okay, because we've not seen any transcripts of this. The only transcript I've seen was Sondland's testimony this morning. If you read the news reports and you believe them, what did McKinney say yesterday? Well, McKinney said yesterday that he was really upset with the political influence in foreign policy. That was one of the reasons he was so upset about this. And I have news for everybody. Get over it. There's going to be political influence in foreign policy.
Is that what the Constitution requires? Get over it? Is that good enough for this body, the world's greatest deliberative body? Get over it? The President's counsel can try to emphasize Mr. Mulvaney and his attorney's efforts to walk back this statement. But as you've seen with your own eyes, the statement was unequivocal. And even when given the chance in real time on that day, on October 17th, to deny a quid pro quo, he doubled down. Get over it, he said. But if you have any questions about what the real answer is, where the truth lies, there's only one way to find out. Let's all just question Mr. Mulvaney under oath during a Senate trial. After all, counsel said that cross-examination was the greatest vehicle in the history of American jurisprudence ever invented to ascertain the truth. Your standard. Finally, I'd like to touch briefly on the importance of Mr. Blair and Mr. Duffy to this case. The President's lawyers have argued that withholding foreign aid is entirely within his right as Commander-in-Chief, that this was a normal, ordinary decision, and that this is all just one big policy disagreement. We have proven exactly the opposite. This can't be a policy disagreement because the President's hold actually went against U.S. policy. The hold was undertaken outside of the normal channels by a president who they admit was not conducting policy. The hold was concealed not only from Congress, but from the President's own officials responsible for Ukraine policy. And most importantly, the hold violated the law. The President has the right to make policy, but he does not have the right to break the law and coerce an ally into helping him cheat in our free and fair elections. And he doesn't have a right to use hundreds of millions of dollars in taxpayer funds as leverage to get political dirt on an American citizen who happens to be his political opponent. But if you remain unsure about all of this, who better to ask than Mr. Blair or Mr. Duffy? They oversaw and executed the process of withholding the aid. They can tell us exactly how unrelated to business as usual this whole shakedown scheme was when it was underway. They can testify about why the aid was withheld and whether there was any legitimate explanation for withholding it. Some of you have asked that very question. Multiple officials, including Ambassador Sondland, Ambassador Taylor, David Holmes, Lieutenant Colonel Vindman, Jennifer Williams, and Mark Sandy, all testified that they were never given a credible explanation for the hold. So let's ask Mr. Blair, let's ask Mr. Duffy, if this happens all the time, as Mick Mulvaney suggests. Why at this time, in connection with this scheme, were all of those witnesses left in the dark. Despite the president's refusal to produce a single document, to produce a shred of information in this impeachment inquiry undertaken in the House, his administration did produce 192 pages of Ukraine-related email records in Freedom of Information Act lawsuits, albeit in heavily redacted form. These documents confirm Mr. Duffy's central role in executing the hold. He's on nearly every single email released. Nearly every single email. Here's an important email from that production. Just 90 minutes after the July 25th call, Mr. Duffy emailed officials at the Department of Defense that they should hold off on any additional DoD obligations of these funds. Mr. Duffy added that the request was sensitive and that they should keep this information closely held. The timing is important because if the aid wasn't linked to the July 25th call, if it wasn't related, why the sensitive, closely held request made within 2 hours of that call? Let's just ask Mr. Duffy. Mr. Duffy and Mr. Blair can testify about the concerns raised by DoD to the Office of Management and Budget, about the illegality of the hold, and why it remained in place even after DoD warned the administration that it would violate the Impoundment Control Act. Now, the president, of course, has disputed this fact. But we have demonstrated that OMB was warned repeatedly by DoD officials of two things. First, continuing to withhold the aid would prevent the Department of Defense from spending the money before the end of the fiscal year. And second, the hold was potentially illegal, as turned out to be the case. By August 9th, DoD told Mr. Duffy directly that DoD, the Department of Defense, could no longer support the Office of Management and Budget's claims that the hold would not preclude timely execution of the aid for Ukraine, our vulnerable ally at war with Russian-backed separatists. Yet, as Mr. Duffy reportedly told Ms. McCusker at the Department of Defense on August 30th, there was a clear direction from POTUS to continue the hold. Clear direction from the President of the United States to continue the hold. So how did Mr. Duffy understand the clear direction to continue the hold? Why is the President claiming that this wasn't unlawful when DoD, the Department of Defense, repeatedly warned his administration that it was? Wouldn't we all like to ask Mr. Duffy these questions? Finally, here's another reason why we know this was not business as usual. On July 29th, Mr. Duffy, a political appointee with zero relevant experience, abruptly seized responsibility for withholding the aid from Mark Sandy, a career Office of Management and Budget official. Seized the responsibility from a career official. Mr. Duffy provided no credible explanation for that decision. Mr. Sandy testified that nothing like that had ever happened in his entire governmental career. Let's think about that. If this is as routine as the president claims, why is a career official saying he's never seen anything like this happen before? Mr. Duffy knows why. Shouldn't we just take the time to ask him? The American people deserve a fair trial. The Constitution deserves a fair trial. The president deserves a fair trial. A fair trial means witnesses. A fair trial means documents. A fair trial means evidence. No one is above the law. I now yield to my distinguished colleague, Manager Lofgren.
Mr. Chief Justice and Senators, it's not just about hearing from witnesses. You need documents. The documents don't lie. There are specific documents relevant to this impeachment trial in the custody of the White House, OMB, DOD, and the State Department, and the President has hidden them from us. I'm not going to go through each category again in detail, but here are some observations. This is, of course, an impeachment case against the President of the United States. Nothing could be more important. And the most important documents that go directly to who knew what when, are being held by the executive branch. Many of these records are at the White House. The White House has records about the phone calls with President Zelensky, about scheduling an Oval Office meeting with President Zelensky, about the President's decision to hold security assistance, about communications among his top aides, about concerns raised by public officials with legal counsel. We've heard about Ambassador Bolton's handwritten notes and book manuscript and Lieutenant Colonel Vindman's presidential policy memorandum. We know of reports about a number of emails in early August trying to create after-the-fact justifications for the hold, but we haven't seen any of them. They're at the White House, being hidden by the President. I think it's a cover-up. Documents at the State Department. Records about the recall of Ambassador Yovanovitch, about Mr. Giuliani's efforts for the President, about concerns raised about the hold, about the Ukrainian reaction to the hold, and when exactly they learned about it. About negotiations with the Ukrainians for an Oval Office meeting. We know of Ambassador Taylor's first-person cable and notes and Mr. Kent's memos to file. We know about Mr. Sondland's emails with Pompeo and Breckbull and Mulvaney and Perry, but we haven't seen them. They're sitting at the State Department. DOD and OMB also have records about President Trump's hold on military aid to Ukraine, about the justification for the hold, about hiding the hold from Congress and trying to justify the hold after the fact, and about why the hold was lifted, but we haven't seen them. They're at DOD and OMB. Why haven't we seen them? Because the President directed all of his agencies not to produce them. This trial should not reward the President's really unprecedented obstruction by allowing him to control what evidence you see and what will remain hidden. You should ask for these documents on behalf of the American people, and you should ask for these documents to get the truth yourself. Now let's come back to the issue of delay, since the President's lawyers have suggested that having witnesses and documents would make this trial take too long. There will be lengthy court battles, they say. The President might even invoke executive privilege for the very first time in this entire impeachment process. It would be better, we're told, to skip straight to the final verdict, to break from centuries of precedent and end this trial without hearing from a single witness, without reviewing a single document that the President ordered hidden. Respectfully, that shouldn't happen. House managers aren't interested in delaying these proceedings. We're interested in the full truth, in a trial that is fair to the parties and to the American people, in the facts that the President's Counsel agrees are so critical to this trial. It's why we've said we won't go to court. We'll follow all the rulings of the Chief Justice. We can get the witness depositions done in a week. In fact, I know we can because if you, the senators, order it, that's the law. You have the sole power to try impeachments. If questions or objections come up, including objections based on executive privilege, the Senate itself and the Chief Justice in the first instance can resolve them. We aren't suggesting that the President waive executive privilege. We simply suggest that the Chief Justice can resolve issues related to any assertion of executive privilege. As the Supreme Court recognized in the case of Judge Walter Nixon, judges will stay out of disputes over how the Senate exercises its sole power to try impeachments. That ensures there will be no unnecessary delay, and it's why we propose we suspend the trial for 1 week, and that during that time, you go back to business as usual. While the trial is suspended, we'll take witness depositions, review the documents that are provided at your direction. The 4 witnesses you should hear from are readily available. Ambassador Bolton has already said he will appear. We can and would move quickly to depose these witnesses within a week of the issuance of subpoenas. The documents, too, are ready to be produced. We're ready to review them quickly and to present additional evidence. Meanwhile, the Senate can continue going about its important legislative work as it did during the depositions in the Clinton impeachment trial. The President's opposition to this suggestion says a lot. The President is the architect of the very delay he warns against. He could easily avoid it. He could move things along. He could stop trying to silence witnesses and hide evidence. I think he's afraid the truth will come out. He hopes his threats of continued delay, however unjustified, will cause you to throw up your hands and give up on a fair trial. Please don't give up. This is too important for our democracy. A decision to forego witnesses and documents at this trial would be a big departure from Senate precedent. When the Senate investigated Watergate, it heard from the highest White House officials. That happened because a bipartisan majority of the Senate insisted. We got to the truth then because the Senate came together and put a fair proceeding above party loyalty. We should all want the truth, and so we ask you, do it again, that you put aside any politics, party loyalty, belief in your president, which we understand and sympathize with, but subpoena the documents and the witnesses necessary to make this a fair trial, to hear and see the evidence you need to impartially administer justice. Now, there's been a lot of discussion of executive privilege during this trial. Even if the President asserts executive privilege, something he has not yet done, it wouldn't harm the President's legal rights or cause undue delay, and here's why. Let's focus on John Bolton, since this week's revelations confirm the importance of his testimony. First, as a private citizen, John Bolton is fully protected by the First Amendment if he wants to testify. There's no basis for imposing prior restraint for censoring him just because some of his testimony could include conversations with the President. That's commonplace. As long as his testimony isn't classified, it is shielded by the Free Speech Clause, by the First Amendment. Ambassador Bolton has written a book. It's inconceivable that he is forbidden from telling the United States Senate, sitting as a high court of impeachment, information that shortly will be in print. If the President did attempt to invoke executive privilege, he would fail. It's true for 2 separate reasons. First, claims of executive privilege always involve a balancing of interests. The Supreme Court confirmed in U.S. v. Nixon, the Nixon tapes case, that executive privilege can be overcome by a need for evidence in a criminal trial. That is even more true here. In an impeachment trial of the President of the United States, which is probably the most important interest under the Constitution, it would certainly outweigh any claim of privilege. Precedent confirms the point. To name just a few, National Security Advisors for President Carter, Zbigniew Brzezinski, President Clinton, Samuel Berger, President George W. Bush, Condoleezza Rice, and President Obama, Susan Rice, testified in congressional investigations. These advisors discussed their communications with top government officials, including the presidents they served. There's no reason why all of these officials could testify in the normal course of events and hearings, but Ambassador Bolton, a former official, couldn't testify in the most important trial there could possibly be. The second reason is the President waived any claim of executive privilege about Ambassador Bolton's testimony. All 17 witnesses testified in the House about these matters without any assertion of privilege by the President. President Trump, as well as his lawyers and senior officials, have publicly discussed and tweeted about these issues at some length. The President has also directly denied reports about what Ambassador Bolton will say in his forthcoming book. Under these circumstances, the President cannot be allowed to tell his version of the story to the public while using executive privilege to silence a key witness who would contradict him. You shouldn't let the President escape responsibility only to later see clearly what happened in Ambassador Bolton's book. There are no national security risks here. The President has declassified the 2 phone calls with President Zelensky. All 17 witnesses testified about the President's conduct regarding Ukraine. We aren't interested in asking about anything other than Ukraine. That's simply a bogus argument. The Constitution uses the word sole power only twice. First, when it gives the House sole power to impeach. And second, Article 1, Section 3, where it gives the Senate sole power to try impeachments. And here's what it says. The Senate shall have the sole power to try all impeachments. When the President of the United States is tried, the Chief Justice shall preside. Now, I think that provision in the Constitution means something. It's up to the Senate to decide how to try this impeachment with fairness, with witnesses, and documents. Privileges asserted can be decided using the process that you devise. That's not unconstitutional. It's what the Constitution provides. You have the power. You decide. Please decide for a fair trial that will yield the truth and serve our Constitution and the American people. I yield now to Manager Schiff.
Senators, before we yield to counsel for the President, I'd like to take a moment by talking about what I think is at stake here. A no vote on the question before you will have long-lasting and harmful consequences long after this impeachment trial is over. We agree with the President's counsel on this much. This will set a new precedent. This will be cited in impeachment trials from this point to the end of history. You can bet in every impeachment that follows, whether it is a presidential impeachment or the impeachment of a judge, if that judge or president believes that it is to his or her advantage that there shall be a trial with no witnesses, they will cite the case of Donald J. Trump. They will make the argument that you can adjudicate the guilt or innocence of the party who is accused without hearing from a single witness, without reviewing a single document. And I would submit that will be a very dangerous and long-lasting precedent that we will all have to live with. President Trump's wholesale obstruction of Congress strikes at the heart of our Constitution and democratic system of separation of powers. Make no mistake, the president's actions in this impeachment inquiry constitute an attack on congressional oversight, on the co-equal nature of this branch of government. Not just on the House, but on the Senate's ability as well to conduct its oversight, to serve as a check and balance on this president and every president that follows. If the Senate allows President Trump's obstruction to stand, it effectively nullifies the impeachment power. It will allow future presidents to decide whether they want their misconduct to be investigated or not, whether they would like to participate in an impeachment investigation or not. That is a power of the Congress. That is not a power of the president. By permitting a categorical obstruction, it turns the impeachment power against itself. How do we respond to this unprecedented obstruction will shape future debates between our branches of government and the executive forever. And it's not just impeachment. The ability of Congress to conduct meaningful and probing oversight that by its nature is intended to be a check and balance on the awesome powers of the executive branch, hinges on our willingness to call witnesses and compel documents that President Trump is hiding with no valid justification, no precedential support. If we tell the president effectively, you can act corruptly, you can abuse the powers of your office to coerce a foreign government to helping you cheat in an election by withholding military aid, and when you're caught, you can further abuse your powers by concealing the evidence of your wrongdoing, the president becomes unaccountable to anyone. Our government is no longer a government with three co-equal branches. The president effectively, for all intents and purposes, becomes above the law. This is, of course, the opposite of what the framers intended. They purposely entrusted the power of impeachment to the legislative branch so that it may protect the American people from a president who believes that he can do whatever he wants. So we must consider how our actions will reverberate for decades to come and the impact they will have on the functioning of our democracy. And as we consider this critical decision, it's important to remember that no matter what you decide to do here, whether you decide to hear witnesses and relevant testimony, the facts will come out in the end. Even over the course of this trial, we have seen so many additional facts come to light. The facts will come out. In all of their horror, they will come out. And there are more court documents and deadlines under the Freedom of Information Act. Witnesses will tell their stories in future congressional hearings, in books, and in the media. This week has made that abundantly clear. The documents the president is hiding will come out. The witnesses the president is concealing will tell their stories. And we will be asked why we didn't want to hear that information when we had the chance, when we could consider its relevance and importance in making this most serious decision. What answer shall we give if we do not pursue the truth now, if we allow it to remain hidden until it is too late to consider on the profound issue of the president's innocence or guilt? What we are asking you to do on behalf of the American people is simple. Use your sole power to try impeachment by holding a fair trial. Get the documents they refuse to provide to the House. Here are the witnesses they refuse to make available to the House, just as this body has done in every single impeachment trial until now. Let the American people know that you understand they deserve the truth. Let them know you still care about the truth, that the truth still matters. Though much divides us, on this we should agree. A trial stripped of all its trappings, should be a search for the truth, and that requires witnesses and testimony. Now, you may have seen just this afternoon the President's former Chief of Staff, General Kelly, said that a Senate trial without witnesses is a job only half done. Trial without witnesses is only half a trial. Well, I have to say I can't agree. A trial without witnesses, no trial at all. You either have a trial or you don't. And if you're going to have a real trial, you need to hear from the people who have firsthand information. Now, we presented some of them to you, but you know as well as we, there are others that you should hear from. But let me close this portion with words, I think, more powerful than General Kelly's, and they come from John Adams, who in 1776 wrote, "Together with the right to vote, those who wrote our Constitution considered the right to trial by jury the heart and lungs, the mainspring and the center wheel of our liberties, without which the body must die, the watch must run down, the government must become arbitrary." Now, what does that mean? Without a fair trial, the government must become arbitrary. Now, of course, he's talking about the right of an average citizen to a trial by jury. Well, if in courtrooms all across America, when someone is tried, but they're a person of influence and power, they can declare at the beginning of the trial, if the government's case is so good, let them prove it without witnesses. If people of power and influence can insist to the judge that the House, that the prosecutors, that the government, that the people must prove their case without witnesses or documents, a right reserved only for the powerful. Because, you know, only Donald Trump of any defendant in America can insist on a trial with no witnesses. If that should be true in courts throughout the land, then as Adams wrote, the government becomes arbitrary. Because whether you have a fair trial or no trial at all depends on whether you are a person of power and influence like Donald J. Trump. The body will die, the clock will run down, and our government becomes arbitrary. The importance of a fair trial here is not less than in every courtroom in America. It is greater than any courtroom in America, because we set the example for America. I said at the outset, and I'll repeat again, your decision on guilt or innocence is important, but it's not the most important decision. If we have a fair trial, however that trial turns out, whatever your verdict may be, at least we can agree we had a fair trial. At least we can agree that the House had a fair opportunity to present its case. At least we can agree that the President had a fair opportunity to present their case, if we have a fair trial. And we can disagree about the verdict, but we can all agree the system worked as it was intended. We had a fair trial, and we reached a decision. Rob this country of a fair trial, and there can be no representation that the verdict has any meaning. How could it, if the result is baked in by the process? Assure the American people, whatever the result may be, that at least they got a fair shake. There's a reason why the American people want to hear from witnesses. And it's not just about curiosity. It's because they recognize that in every courtroom in America, that's just what happens. And if it doesn't happen here, the government has become arbitrary. There is one person who is entitled to a different standard, and that's the President of the United States. And that is the last thing the founders intended. We reserve the balance of our time.
Thank you, Mr. Manager.
Mr. Chief
the
Justice,
Majority Leader is recognized.
I request the Senate take a 15-minute recess.
Without ordered.
Hi, everyone. I'm Rena Ninan in New York. Day 10 of the Senate impeachment trial of President Trump. It's in a short recess. The House managers and the president's legal team have wrapped up their arguments on the motion to call witnesses. However, the efforts by Democrats appear to be hitting a dead end. Alaska Republican Senator Lisa Murkowski will vote against witnesses in the Senate trial. She had reportedly been on the fence for the past 2 weeks. That gives Republicans the expected 51 to 49 majority against extending the trial any further. In her statement, Murkowski said the following, and I'm quoting here, "The House chose to send articles of impeachment that are rushed and flawed. I carefully considered the need for additional witnesses and documents to cure the shortcomings of its process, but ultimately decided that I will vote against considering motions to subpoena. Given the partisan nature of this impeachment from the very beginning and throughout, I have come to the conclusion that there will be no fair trial in the Senate. I don't believe the continuation of this process will change anything. It is sad for me to admit that as an institution, the Congress has failed." I want to bring in Keir Dugal. He's a CBSN legal contributor and former assistant U.S. attorney for New York's Eastern District. And I also want to bring in Molly Hooper, who joins us as well, a CBSN political contributor. She's going to join us momentarily. Keir, there's been so much back and forth. I want to get your thoughts on what we saw this afternoon.
Okay, well, the first thing, we're discussing Senator Murkowski's position. If we've got our math right, and it is in fact going to be 51 to 49, that will eliminate the question we were talking about earlier as to whether or not the Chief Justice could potentially have a role in a 50-50 split. So I think it is significant, very significant from that perspective, in addition to the perspective that it also looks like, if the math is right, there will not be additional witnesses in this trial.
You know, we just heard Adam Schiff there, one of the House managers, the lead House manager, saying what the precedent this could set by not calling witnesses. Obviously, what we are seeing in the Senate, this trial, is very different from what you would see in a courtroom. From a legal standpoint, do you agree with Adam Schiff on that?
So I think what may happen in future impeachment trials where this possibility exists, where a Senate may now have this precedent that no new witnesses will be called, what that will do is force the House investigative process to call all of the witnesses. Mm-hmm. Now, if we are in a process where the House can't confidently rely on the courts acting quickly, I think it's going to sort of up the ante, because the House has an inherent contempt power, and that power is to send the sergeant-at-arms out to arrest people and hold them in contempt while they refuse to comply with lawful subpoenas for testimony and document demands. So this may ratchet up the sort of the process and the aggressiveness that the House will have to take potentially in future impeachments.
Mm-hmm. What do you make of Lisa Murkowski? We've been watching all morning, waiting. She said she would release a statement, which she rightfully did before this trial began this afternoon. The fact that she came forward and said no to witnesses. You see her actually right there live in the blue jacket there. What do you make of her argument? She has said today the Senate has failed.
Yeah. So I think that is, if you take the view that trials are truth-seeking functions where relevant evidence should come in, I think if you take that view, you're going to be disappointed in what you saw. Certainly, I think that the senator has a point, perhaps, that the House process could have, that process wasn't perfect. I don't, as a prosecutor, a former prosecutor, I don't know a single investigation that ever is perfect.
Mm-hmm. But this was so political, Keir. It's hard to ignore just how political and how divided. I mean, even in this statement, she said, the last line of Lisa Murkowski's statement is, "We are sadly at a low point of division in this country."
Yeah, so I'm not terribly compelled by this partisanship argument. The framers were very careful to require a supermajority in the Senate so that that would demand, a two-thirds vote demands that, the senators from two-thirds of the country would agree that the president should be removed. Now, we can imagine a scenario where the Senate is 70% Republican or 70% Democrat, and all of those senators on a party line vote decided that whoever the president was, they should be removed. And I really think that this claims about bipartisanship are not really focused on what the Constitution demands, which is that we have a supermajority of carefully considering senators.
You mentioned the Constitution. Schiff, it's hard to ignore that he closed with, I believe, was it John Adams that he quoted for talking about the heart and lungs. Can you talk to me a little bit about what he said and how he closed, talking about the framers, saying that together with the right to vote, those who wrote the Constitution considered the right to trial, the heart and lungs, essentially, was what he said. I don't have the direct quote, but that's how he chose to sort of wrap this up on that note.
Right. And so, I think that when you have a sort of a very strong theme, something where you can stick your point, stick the landing, that's very powerful. Look, the right to a jury trial in a criminal case is one, as well as the right to a grand jury. Those two rights in our Constitution protect us from...
We've got Senator Schumer here. Let's listen in to see what Senator Schumer has to say.
And we said, there's certainly going to be more revelations that come out. Little did we know that an hour later, a thunderbolt struck. John Bolton sat in the room with Mr. Mulvaney, Cipollino, and they talked all about withholding aid and letting the Ukrainian president know. More and more evidence comes out. It will. No mistake about it. What happened today won't be the only or even the most significant and important leak that comes out, because that's just how it is. When you have so many, one of the most troubling things about this is what the president did was so wrong, and there were so many people in the loop, all of whom shrugged their shoulders and went along with something that was decidedly against the law. Maybe they said to themselves, well, that's who Donald Trump is, that's who we're working for. But when there are so many people in the loop, there are so many revelations from that loop as time goes on. And so, no, folks. And so that it is devastating. As for, there is no agreement between Leader McConnell and myself. We have stood for one thing. We do not want this rushed through. We do not want it in the dark of night. Members have an obligation to tell the American people and to tell the people of their states why they are voting. So we are going to use whatever power we have to prevent it from being rushed through. But right now there is no agreement. I'm not going to take any questions. That's it.
But there could be an agreement soon?
Senate Minority Leader Chuck Schumer weighing in there, saying he's not going to take any more questions. We've got Molly Hooper also joining us here on set, CBSN political contributor. Yes. Molly, there's so many different motions and things that can take place in the Senate that I can never keep track of.
They can never keep track of it almost. The Senate is the place. If you want to stall legislation, go to the Senate because they have motions to just about do anything, raise the sun. But no. But it definitely is something that Democrats are considering because each time, say, Senator McConnell moves to basically wrap it up, which will establish sort of how much time each senator will speak before they finally vote on acquittal or removal. Well, that's an amendable motion, which means Chuck Schumer can keep amending it and offering amendments and offering amendments and offering amendments, and it can look very much like 11 days ago on Monday, before the Senate even was able to hear the opening statements, just in order to set the parameters of how it was going to play out.
What is your sense? What are you hearing from sources on Capitol Hill about the timing of a vote and what other actions could be taken, especially in light of New York Times reporting that Bolton is now placing Pat Cipollone and Mick Mulvaney in the room, part of a pressure campaign on Ukraine that could have started as early as May?
Right. Okay. So there's a couple of things. Number one, on that revelation, if the Republicans are making the argument that what occurred was not impeachable, it doesn't really change their line of thinking. But that doesn't necessarily mean they're going to get the speedy resolution ideally they want. The White House wants this thing done. They want it to be off their plate. They want the president to be acquitted before Tuesday when he gives the State of the Union. And at this point, it just doesn't look like that's going to happen logistically because, as I said, the Senate is a body that moves when everybody agrees to move. That means all 100 senators agree. And in most normal cases, sure, we can move on to a judicial nominee. We can move on to a piece of legislation. But in a situation like this, Democrats will not agree to a speedy end to this impeachment trial, which means it goes on and on. The wrinkle, though, is how do those four Democratic presidential contenders, Amy Klobuchar, Elizabeth Warren, Bernie Sanders, and Michael Bennet, what do they do? Because Iowa is on Monday. And
important day for them.
A very important day, and they could be here on Monday. They could be in session, debating these motions or behind closed doors. But it sounded like what Chuck Schumer was saying, the Senate Democrats do not want to go behind closed doors to deliberate. Deliberate why different senators are feeling the way they do on the final vote.
I want to look at some of the reaction that we've gotten from Republican senators as to why they chose not to call for witnesses. There seems to be a bit of a common theme here, Molly. We've got Republican senators willing to call the actions inappropriate, but they still don't want to vote for witnesses. You see right here, Rob Portman saying, I believe that some of the president's actions in this case were wrong and inappropriate, but I do not believe that the president's actions rise to the level of removing a duly elected president from office and taking him off the ballot in the middle of election. Marco Rubio, just because actions meet a standard of impeachment does not mean that it is the best interest of the country to remove a president from office. And Senator Lamar Alexander, who we were watching very closely, who has weighed in saying no witnesses, he had this to say. It was inappropriate for the president to ask a foreign leader to investigate his political opponent and to withhold United States aid to encourage that investigation. But the Constitution does not give the Senate the power to remove the president from office and ban him from this year's ballot simply for actions that are inappropriate. Molly, is this a coordinated effort here?
I'm not sure how coordinated it is, but I think that it was telling that last night, when Lamar Alexander essentially broke his silence and released this statement, that paragraph was quite pointed. He said these were inappropriate. This was inappropriate behavior. And that sort of opened the way, cleared the way, if you will, for individuals like a Rob Portman, Marco Rubio to come out and essentially say, you're right, it wasn't the best decision. We don't like the call, but again, not an impeachable offense. And really, Lamar Alexander took the lead on that in part because he is retiring, and also because when you have the White House beating down your neck and you have Mitch McConnell and everybody saying you have to vote against it, you have to vote against it. Well, if I'm Lamar Alexander, I'll say, okay, I'm thinking about it. But if I do, you just know that this is coming, and that President Trump is not going to come after me for saying what he did was inappropriate, and he's not going to come after these other people who have to do that as well. So what I'm going to be watching for in the days to come is what is President Trump's reaction on Twitter to what these senators have said.
And it's not just Twitter. He's got a huge interview, Super Bowl. You could not ask for a bigger audience than Super Bowl Sunday. He'll be sitting down with Sean Hannity, someone he's very close to, and Hannity, who has a certain opinion of John Bolton, who said he helped Bolton get the job, and he's very disappointed.
Right.
He doesn't recognize the man he sees now, is what he said. Kira, I want to turn to you. When you look at the evidence at this point, and you know that there's still a drip, 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 no matter what happens. Separately, you've got this Bolton book that's coming out that you have said can't completely, because you have a First Amendment right, the White House can't completely ban from being published.
Correct.
And then you've also got the State of the Union, you've got Lev Parnas, who has also said, I believe just a short time ago, has reached out to Mitch McConnell and some senior folks on the Hill his attorney saying, this is what I'm willing to share with you and say. What do you do with that kind of evidence and information?
Well, I think the risk is that the Senate just looks like it got it wrong, and it's branded as the world's most deliberative body, and it's looking like it may become the world's most deliberately ignorant body by refusing to consider witnesses. As I step back and I look at this from the much broader perspective, we've heard a lot of defenses from the president and the counterpoints from the House managers. From a constitutional law perspective, I am less concerned about the defenses that relate specifically to these facts, to this particular fact pattern, to whether it rises to a particular level of evidence, whether this happened or that happened. I'm much more concerned, as a matter of constitutional law, with a defense that says if the president is seeking re-election, that's in the public interest, and he can do whatever, or she can do whatever they want, as long as it's not a financial bribery, which was this, frankly, very flawed argument, in my opinion, that Mr. Dershowitz made. That defense has very long-term consequences for our republic if it is accepted. The other one that is potentially concerning, and it's the one that Adam Schiff ended on, was the obstruction argument. If the president can, across the board, claim and refuse to cooperate in an impeachment inquiry, that, I think, is important, but slightly less so for the reason we were just talking about, which is, I think, what will happen in the next impeachment when House managers are worried about this. They'll go out and start arresting people who refuse to comply with their subpoenas.
Well, or they could actually uphold the subpoenas. They could subpoena these individuals and contest it in the courts, which I think if they had done that and they had really not been, I've heard some Republicans characterize it as sloppy, even one or two Democrats have said, man, if only we ticked those boxes. Because if you listen to the questions of those vulnerable Republicans, one of them had to be was, if this is not partisan, why was it rushed, and why didn't you tick the boxes? Why didn't you subpoena John Bolton, Charles Kupperman? Why didn't you contest that in court? Instead, you let it drop and said you're going to wait for this Don McGahn ruling. The challenge with the Don McGahn ruling, the former White House counsel, who was interviewed by Bob Mueller, he was interviewed by Bob Mueller, and the White House said, well, no, now Don McGahn can't come talk to Congress. Congress has a different case against Don McGahn since Don McGahn already spoke to Bob Mueller. These other individuals had not. And so for Adam Schiff to just sort of like not move through and, like I said, cross the T's and dots the I's and reissue the subpoenas after the inquiry became official when the House voted for it, that's where I think he may have lost somebody like Lisa Murkowski, Lamar Alexander.
Interesting.
It really.
I see Senator Hirono there of Hawaii. Let's listen in to see what she has to say.
It is up to the voters, as though impeachment is not a constitutional process. The voters are going to get to decide, and the information is going to keep coming out, and believe me, it will be an indictment on not only the president, in my view, but on also all of the Republicans and those who did not vote to have the factual evidence come up. I don't know. We shall see. That's why things change all the time.
In her reaction to Murkowski's statement, where she basically said she didn't see any way that there would be a fair trial. She said Congress has failed, and that she wants to vote no because she doesn't want to put Roberts in a position of casting a tie-breaking vote or getting attacked for not casting a vote.
Chief Justice Roberts is not the issue. The issue is whether or not there are going to be enough Republicans who say, we want the fact witnesses. In fact, Chief Justice Roberts could very well say, I don't want to get involved in, this is not my role to break a tie, so there shouldn't even be a tie. And if that's the sort of the I don't know what, angst that she's feeling, you should think that that's nothing that should be the reason she wants to vote no on the witnesses. Without witnesses, we can't have a fair trial, and we know that the American people have said you can't have a trial without witnesses. And it's not just any witnesses, it's the witnesses who are actually there, who can speak firsthand to what the president was scheming.
One of the things that she is saying, that Lamar Alexander and other Republicans are saying, is that basically no matter what witness were to come forward or evidence would come forward, it wouldn't change the outcome. Do you have any thoughts on that?
Maybe they're prejudging the impact of somebody who's sitting there under oath, being questioned. Maybe they don't want to face that reality or that experience. But the bottom line of what Lamar Alexander is saying is at least he's candid enough to say, okay, the president did those things and they were not appropriate. Please, that is about as benign a way to describe what the president did. What he did is impeachable. So, they're making their own rationale and arguments, but the fact of the matter is the American people want witnesses. We want witnesses. We want documents, relevant witnesses and documents. You can't have that and not. You have to have that in order to get a fair trial. It's pretty simple, I think.
Senator, as far as Justice Bologna is concerned, you're saying that he should be worried. What exactly are you insinuating as far as
well, if the allegations are true that he was actually at a meeting where he was very aware that the president was plotting this scheme to get the Ukrainian president to do his will, political will, and his whole entire argument has been there's no evidence to that effect, and he's one of the witnesses to this happening. There is such a thing as when lawyers lie to the tribunal. There are things that can happen to you.
Senator Hirono, would you like to see?
There are disciplinary actions, but that's, you know what, I'm not focusing on that right now. I'm just saying if I were Pat Cipollone, I would be worried. But I'm still focused on the need to get witnesses.
Senator Schumer said if the president is acquitted, it will have a permanent asterisk on it. Do you agree? And is this now how are Democrats now focused on how Republicans who voted to acquit the president will be remembered by history and by voters?
There's agreement both sides, both the House managers and the Trump team, that this is going to have lasting impact, but the impacts are described very differently. In my view, the lasting impact will be that any president who doesn't want to comply with duly issued subpoenas can say, you know what, I'm just not going to comply with any of your subpoenas. I'm not going to have any of my people testify. You see, that does tremendous damage to the checks and balances. So I don't know how we expect any of our committees in any other matter to get information out of this administration. It is already not that easy to get information from this administration, by the way. For example, there are 6 children who have already died under our custody. Do you think that we're getting all the information as to what's going on with all these children in our custody? No. So with this kind of outcome, I think it's going to be even harder, and that's one of the lasting damages of a non-conviction, in my view. There are many.
State of the Union's on Tuesday night. What do you think is the State of the Union right now, given this impeachment trial, how divided the Senate is? And what are you thinking when you're going to be looking up at the president?
I will be attending the State of the Union to bear witness. That is what I did last year. By bearing witness, that means that I do not clap, I do not acknowledge. No, I'm just there as a witness. And I know that he's going to use that to make all kinds of arguments, because basically he's an unhinged, lawless person who lies every single day. So I expect him to use the State of the Union to lie about everything he's doing. But you know what? That's 2 days from now or however. I'm still focused on what we need to do here, and I'm waiting for the votes on this, and people will be on record. That's for history. They will be on record not wanting to support witnesses who should come forward to enable us to make a decision on whether or not this president ought to be convicted for abuse of power and obstruction of Congress. Those will have lasting impacts on what Congress can do with our oversight responsibilities, and what the president is going to continue to do, because we do need to ask ourselves, what other pot of money is he going to find to use as a bribe to lean on or bully another country? What other country is he going to pick on? What kind of investigations is he going to unleash that may not have any foundation other than is something that he wants to get done politically? And that's what we've been told, that the president can do basically anything he wants under Article 2, and that is his belief, and his non-conviction will simply lend a lot of support to that belief. And we are seeing, as I said yesterday, we are witnessing the coronation of Trump as king, with Mitch McConnell holding the crown and the Republicans holding the train.
Do you think there is still a value in going through the impeachment process, even if you end up with this vindication, acquittal, crowning moment?
this is a responsibility we have, a constitutional responsibility to have this trial. And we're going to continue to advocate for the need for a fair trial, and that's what we need to do. We're not going to just truncate and shut ourselves down. You know, we're going to do everything we can to make sure that our voices continue to be heard and that there's every possibility, down to the time of the various votes, that maybe some Republicans will see the light.
Is part of the strategy in drawing out this trial into next week to deny the president a victory lap at the State of the Union?
I don't think that that's really the impetus for it. There may be some other considerations, such as maybe people need to have a chance to express, their views on what's going on.
Senator, last question: if the president is acquitted, whether it's tonight or next week, would you then support a censure of the president?
I'm not there. To me, in my view, this is an up or down vote based on the evidence, and if it is the Republicans who are saying that the president can get away with doing this, and if there's any effort on their part, such as if Lamar Alexander says, yes, the president did this, it was inappropriate, I think any censure motion, in my view, should come from the Republicans.
All right, thanks, everybody.
We've been listening in to Senator Hirono there of Hawaii weighing in. I want to bring in our panel, Molly Hooper and Keir Dougall. Molly, do we have a sense of when this vote at this point could happen?
Well, again, it's unclear. Essentially, it's supposed to happen. You would think it would happen later this evening after both sides make 2 hours worth of arguments in favor of opening the door, essentially, to allowing witnesses. Yeah. However, when the Senate gets to that vote, that question, as they call it up on Capitol Hill, it is, from what I understand from the people I've talked to, it is an amendable question. Meaning that Chuck Schumer can say, well, I want to amend this vote that we're going to take. I think that we should be allowed to call X number of witnesses, or I move that we go into closed session so that all sides can discuss this between ourselves. There's lots of different motions that the Democrats can make, essentially to make whatever point they want to. Essentially, though, each time they have this amendment that they try to add to the final vote, before the vote, each side gets an hour's worth of debate. So again, that drags it out. And that's not even getting to the vote on these witnesses. Once you've had that vote, then the Senate needs to figure out, okay, how are we going to wrap this up? Because we don't know. They didn't agree to a package that included how this will end. So meaning closing arguments, how much each side will have for closing arguments. Oh, by the way, the senators, all 100 of them, have been sitting on that floor for, what is this, the 11th day? Like 8 hours a day, and they haven't been able to talk. They want to talk. They all want to express. They all want to express themselves in some way or the other. And if you're giving these senators 10 minutes apiece, 15 minutes apiece, that's a lot of minutes that will eventually that just prolongs this whole saga.
But they do have milk.
They have milk. That's right. They do have their milk. That's right. They have their milk.
You know, I do want to, there's been so much that has happened and transpired this afternoon, even before the Senate trial began at 1 p.m. The big news, sort of at about noonish, the New York Times released a story saying that they have some of the excerpts from John Bolton, former National Security Advisor's new book. And among those excerpts, the things that we have read in the New York Times is that potentially some of the people close to the president, including his counsel, Pat Cipollone, Mick Mulvaney, Rudy Giuliani, were all inside of a meeting in May, and they could have been putting pressure on the situation of Ukraine, pressuring Ukraine, asking for this pressure campaign to begin and continue as early as May. I want to get Keir to weigh in on that. Keir, we're hearing from Rudy Giuliani, who tweeted about this revelation of this May meeting, saying the meeting the Times described is a lie. If Bolton is a source and he believed that this was so bad, why didn't he quit? How much integrity and honor will a man sacrifice for greed and revenge?
Right, a very powerful statement. And Mr. Giuliani is entitled to deny the claims. But we have to remember, Ambassador Bolton has stated his willingness to go on the floor of the Senate, swear an oath, testify under penalty of perjury to the truth of what he has to offer. If the manuscript is true, his offer of the description of that meeting in May, which moves the timeline back, included Mr. Cipollone, Mr. Mulvaney, and Mr. Giuliani, if I have, and President Trump, if I have the players correct, and that it involved, the Ukraine scheme that the House managers are alleging. That is a very important, important evidence that you would want to have if you were seeking the truth.
Yeah,
and he's prepared to offer it under oath.
And remember this: even once this impeachment trial ends, House Democrats are still in control. The Democrats are still in control of the House. They are still in control of those investigatory committees. And Nancy Pelosi was asked this the other day: will Adam Schiff subpoena John Bolton after this is all over to come speak to the House Intelligence Committee behind closed doors? And she left the door open that could be a possibility.
How soon do you think we could see something like that? If this,
I think that there's going to be a lot of regrouping after this, because there are still, like I said, committees that are looking into this president, into his finances, into his tax returns. There's a number of investigations that are ongoing over on the House side, partially related to what Mazie Hirono just discussed. What's happened on the border with the children who were detained and separated from the parents. Those investigations are still ongoing. So even though this Senate impeachment trial may end, quote unquote, investigations are not ending. In fact, I have a feeling they might ramp up even more, because there's a lot of Democrats in safe seats who want to keep this up. They want to keep up this oversight. And it's just a matter of what the appetite is for that among the more moderate members of their caucus.
We talk a lot here about how this is not like a normal courtroom trial. This is a bit different. When you walk away, and based on some of the new stuff that we've heard today with the New York Times, Bolton's testimony, we know Lev Parnas, an associate of Rudy Giuliani, has already come forward, reaching out to key senators, saying, here's what I'm willing to tell you. Where do you, from a legal standpoint, where do you see all of this headed?
Well, I want to throw a little grain of salt with respect to Mr. Parnas. It is not clear to me that he has been accepted as a cooperator in the Southern District, where he is under indictment. And so that tells me that there may be some red flags there. One is that they have not yet judged him to be credible. If that's the case, that is more than a grain of salt. That's a very large, that's a salt lick for people out who have farms. If they've determined that he's not valuable, I'm not quite sure why that would be, given that he apparently is very willing to talk to people, and he should be talking to the Southern District prosecutors. Look, it's Molly, I think you hit it right on the head. Where does all this land? It seems like there would be a lot of regrouping, but stepping back again, really back out. The criticism about the House not subpoenaing is, I think it is something that House managers are going to have to grapple with in the future. And so one option we just mentioned is the House's inherent power to arrest people. Another thing that I think as a government we probably ought to consider is somehow putting these congressional investigative subpoenas on a fast track in the courts.
And Congress can do that.
Congress ought to be able to do that. It shouldn't be, I don't believe, it should be up to the courts to decide whether or not to expedite the review of these subpoenas. This is the most important stuff that our government, next to declaring war, these types of, particularly in impeachment, but in other national security investigations, maybe we should not put the House managers sort of at the whim, I hate to say it this way, but at the whim of the court's scheduling.
Well, but here's where that question of dropping those subpoenas comes in, because when those subpoenas were initially ordered for Charles Kupperman, who was John Bolton's deputy, that was before the full House took a vote to authorize an impeachment inquiry. And even though the House changes their rules every 2 years and they gave their committee chairs the power to subpoena without having to go to the full House, that's not how it was done in the past going through the courts. And so if Adam Schiff had reissued these subpoenas and tried to force them, who's to say that the court wouldn't have taken them up more quickly? Because Don McGahn is not part of this particular impeachment, as I've been saying, saga, but he's not in this storyline on Ukraine. I mean, he left the White House before this ever happened, and he's not part of this aspect of the Democratic investigation. So, perhaps they would have gone quickly. And I think that, again, that's where you're having those more moderate Republicans in the Senate. And even when the House was dealing with this whole, with the whole investigation and inquiry, moderate Republicans were privately saying, well, you've got to follow up with the subpoenas. You can't just drop it because then it looks really partisan. And what are we going to do?
Right.
You know?
And so I, of course, my background is as a prosecutor.
You know
right?
the speed.
Right.
Of
And
the
so
courts.
and so as a prosecutor, you're absolutely right, Molly, that it's possible that had those subpoenas been reissued, that the courts might have exercised their discretion to fast track these subpoenas.
And Congress enforced them, right?
But the problem from the prosecutor's perspective, particularly when you believe there's an ongoing crime, what the House managers are alleging is that there's an ongoing crime with a very important deadline for the 2020 election, and you would want to have some certainty. You would want to have not just, well, maybe the courts will do it. You would want perhaps future House managers, if they had that assurance and they knew that the courts would, because they were required to, because Congress has passed a new law or the courts have passed a new rule where these very important separation of powers principles are at stake in a subpoena, that they would act in an expeditious manner, we might be able to play the experiment differently next time.
Well, but I think that when the House managers came up in front of the Senate and the senators are like, well, you didn't enforce these subpoenas and you're just coming to us and you're not doing your due diligence, it may have been more effective for Adam Schiff to say, yes, we have. We are trying to get these people to come speak to us. That's why we are here with you, talking to you, senators, because the court is so slow. But we are actively trying to pursue this. But when they kind of dropped the ball on it, Adam Schiff had to say, oh, well, they're duly authorized through the House rules. And technically that's correct, but remember, this is a political trial. Right. And so even though, and I know this, both parties can get too cute by half on their respective chambers' rules, but when it's this big, I think that you have to give those more moderate Republicans, if you want that bipartisan buy-in, the optics to say we are doing everything we can to have the administration cooperate, but they just aren't working with us.
Right, and the problem is, look, there is a good constitutional argument because the sole power of impeachment and the sole power to try rest in the House and the Senate. But the House managers did not exercise their inherent contempt power to go out and arrest John Bolton.
And you take him to the Capitol Hill. Yeah, you take him to the Capitol Police Station. You can find them.
Now, I get it that this would be a gigantic escalation of the exercise of power, but they had that option.
Molly, walk us through at this point where we expect this debate to continue till and what our understanding is at this hour.
Well, I think there's a lot in flux right now. So that's why this break, I think, is extending a little bit longer than anticipated. Because behind the scenes, what should be happening, Mitch McConnell should be talking to Chuck Schumer about how are we going to proceed here? Which motions are you going to offer? What's our timeline? We got to let our members know if they can go home. We have to plan for next week. Let's work together here. But again, this is where relationships matter. And if you don't have a good relationship with your counterpart, and this dynamic duo we have of Mitch McConnell and Chuck Schumer, they don't love each other. There's no love lost between these individuals, and it makes it that much more difficult to get an agreement which will establish time parameters and give us a better idea of how this is all going to wrap up. Because one thing I've learned from covering the Senate, after coming from the House, the House has rules. It's orderly. They have to. I mean, there's more than 400 of them, right? The Senate has rules, but if 100 senators agree, they can throw out the rules. In fact, that may be a motion that we see this afternoon to suspend the rules and do something totally different. So, again, until Mitch McConnell and Chuck Schumer are able to come to some kind of understanding, even if it's just figuring out, okay, let's just be good for all of our membership. Let's be courteous. We don't have to agree. You don't have to agree with us, we just give us some. So I think that that's what's going on. Just let us know how many amendments you're thinking of, and from our perspective, we can give you what we're thinking. But whereas in previous Congresses, when you had a relationship between, say, Trent Lott and Tom Daschle, they had a great working relationship, and this was not a problem.
Yeah,
right.
Something would be worked out. That's point.
Absolutely.
Take us back, Molly, because Mitch McConnell can be so masterful in how he arranges and lets things play out. Sometimes he's been doing this for a while. He take us back to the beginning of this week. Walks out. I don't have the votes. I just don't have the votes. How did we start off at the beginning of the week with Mitch McConnell saying, I don't have the votes, and then now today, it appears they do have the votes to prevent witnesses from coming.
It kind of goes back to that interview that Nancy Cordes, CBS News' Nancy Cordes did with Susan Collins. And Susan Collins, who is going to vote in favor of having witnesses today, she said, the White House hasn't been doing enough to reach out to people like me who have been on the fence about witnesses. They haven't been doing a good enough job convincing us that we need to vote in favor of to vote against more witnesses. And I think at that point, that's another argument that McConnell was hearing from somebody like Murkowski, Lamar Alexander, Rob Portman, Marco Rubio, these individuals who you did hear from. And so the thing is what I would say is that at that time, Mitch McConnell, he essentially put, you could say, a trial balloon out there. When I heard that he told senators that they didn't have the votes, and he let that leak, I'm like, he's getting the votes. Because
what made you say that? For people who don't understand how this...
Because that puts so much pressure on the White House to get involved and to know how urgent this situation is. Because Mitch McConnell can only tell...
So it's like sending up an SOS to the White House at this point.
SOS. And, this president responds to what's in the Twitter sphere and what's in the news and on the shows. And if he reads on Fox News Channel that Mitch McConnell, this masterful mastermind of the Senate, he doesn't have the votes to prevent witnesses, oh my gosh, we got to do something. You're right, SOS. And so the White House did step to, and we saw more conversations playing out behind the scenes with these individuals. And voila, last night, Lamar Alexander comes out with his statement.
So what do you think? Do we have a sense of what made Lamar Alexander, Murkowski come forward and say, no witnesses, and here's why?
Well, I think that Lamar Alexander is somebody who this is his third term in the Senate. He was the governor of Tennessee years ago, had been the Secretary of Education, ran for president 2 times, was a college president. This is a man who is known as more of a moderate on Capitol Hill. Yes. He's a conservative, but he works with both sides. And, he's seen as an institutionalist. And I think he had reservations with the administration not spending money that was duly appropriated to go towards Ukraine. When the administration steps in and say, for example, like President Trump last year, we had the government shutdown for the border wall. The president decides, I'm just going to declare this a national emergency and take that money from the military. That caused a problem up on Capitol Hill. And Lamar Alexander voted to disapprove of that emergency declaration at the time. So you're talking about an institutionalist who does feel that Congress needs to carry its weight, and it has a great deal of power when they work together. And for what the president did by withholding that aid almost full stop, regardless, that was inappropriate. But again, if these senators, like Elisa Murkowski, who was an attorney, Lamar Alexander was an attorney, see that not every step was taken over on the House side, they have a hard time justifying, moving to hear from more witnesses if, when it comes down to it, is this offense impeachable? Maybe not. So that's why I'm curious, and I have some, texts out to some sources to find out if there's a conversation among Democrats about offering a resolution to censure the president, because that kind of puts those senators, those Republican senators, in a tough spot.
And explain censure here, what this does and why this could be problematic.
Well, it's not necessarily that it does anything, but It's a
the message it
slap.
sends.
The message it sends. It's a slap on the wrist. The only other president to have been censured by Congress is Andrew Jackson. I mean, the only one. And when President Obama was in office, there were a number of resolutions offered in the House to censure the president for various actions he took on, overexerting executive authority and moving through DACA and all these things. Never really came to pass, right? But this is a different situation. And even back when Bill Clinton was going through his impeachment trial, Democrats, incidentally, on the House side, offered a resolution to censure Bill Clinton. They said it's not impeachable, but what he did was not right. He broke the law. He perjured himself. And we all know about it because it was video. It's on video. And so they offered that resolution in the House, and it incidentally failed. But that, this is a different situation now that we're over in the Senate, and really, this impeachment trial is wrapping up. And so I think that if Democrats do offer that motion, number one, when do they offer it? Do they offer it before the final votes on acquittal? Or, which Republicans are they talking to maybe get some bipartisan support for that? Because even if it doesn't pass, I think you have to have 2/3 for a censure, so don't quote me. I'll double check that. But even if that fails, Democrats could come away saying, well, he wasn't acquitted really, because there was bipartisan, support to censure him and essentially to send him to his room for a week because he did something wrong.
I want to play a little bit of what lead House impeachment manager Adam Schiff said that this trial could create a potential new precedent. Here's what he said.
This will set a new precedent. This will be cited in impeachment trials from this point to the end of history. You can bet in every impeachment that follows, whether it is a presidential impeachment or the impeachment of a judge, if that judge or president believes that it is to his or her advantage that there shall be a trial with no witnesses, they will cite the case of Donald J. Trump.
When you talk about constitutional law, when you talk about a situation like this with impeachment, what precedent do you believe that this sets? What's the message?
Well, I think Mr. Schiff is correct that it'll be out there if there are no witnesses. There'll be this one data point as against all the other impeachments where witnesses were called. So, so it is a precedent in that sense. But again, I'd step back to things that are specifically factually related to this impeachment. Those are of less concern than setting constitutional law precedents about presidential behavior. And so here, where the Senate, in its deliberations, as it gets to set its own rules and decide what it wants to hear, it chose on in this particular case not to hear new witnesses. It is a precedent, but I don't think that it is one that will be necessarily as impactful as one that would sort of alter the scope of the impeachment clause itself.
I'm just reading something from the Wall Street Journal here reporting that, with the Senate vote on witnesses expected to fail later, a lawyer for Lev Parnas sends McConnell and Schumer a 3-page letter outlining what Parnas would testify to. Parnas has previously described much of what it is in the letter in TV interviews. Keir, does Parnas coming forward at all change anything?
Well, potentially it could, but we're hearing senators now. Who, like Senator Alexander and perhaps others, who are saying, "Look, we think we think that the conduct has been set forth, and we still don't believe that it rises to. It's wrong, perhaps. It's inappropriate. Pick your word. Pick your descriptor, but it isn't removable." If that's where the Senate has landed, then, you could prove the case beyond a reasonable, you could prove it to an infallible certainty that that President Trump linked the aid, did all these things, withheld it, demanded that the Ukraine get fake dirt on the Bidens. You could accept all of that and then say, we don't believe it's removable. And if Lev Parnas corroborated all of that, it wouldn't change the outcome. What we don't know, what I think we don't know is what we don't know. What do these witnesses say that we don't know. What does Bolton, Mulvaney, Duffy, what do they say? Because we don't have the bullet-pointed letter of every single thing that they might say. Some of it could be good for President Trump. We just don't know. And I think that's the problem with the idea that this is a fair trial. I think that's where the rub is for us now.
And ultimately, Congress
There was Senator Lisa Murkowski there, who had a critical statement out today. Let's see, does she talk? No, she does not talk. Coming forward, we were talking a little bit about Murkowski and how fascinating she is. Oh, yeah. I believe it was you, Molly, who said that she's just not beholden to the Democratic Party. Not beholden to the Republican Party necessarily.
She's not. I mean, this is a woman who essentially took the seat of her father, who went on to become governor of Alaska, and she came in, and in her second essentially run for re-election was contested by then a Tea Party Republican, Joe Miller, in Alaska. I believe he was backed by Sarah Palin at the time. And this is in 2010, sort of the height of Sarah Palin's hype and influence in the GOP. And Lisa Murkowski lost that primary. But she went on to win the general election as a write-in candidate in Alaska as an independent. I mean, that sort of shows you, her power and her hold on that power in Alaska. Now, she isn't necessarily beholden to the Republican Party. That's true. However, she also has interests to represent in that state. She's big on natural resources and energy issues. The Arctic Refuge up in Alaska is for more drilling in that area and research and development. And she's the chairman of the Energy and Natural Resources Committee, which is a powerful committee in the Senate. She's also on the funding, the Appropriations Committee. She's the subcommittee chair on the Interior and Environment, which means issues related to interior, and she gets to decide how to spend that money. Yeah, and
I
that's
just want to flag
she doesn't want to lose.
I apologize for interrupting. I want to flag at the bottom of your screen there. We're watching the Dow dropping almost 670 points there. There are a lot of fears coming out right now about the coronavirus. In fact, I believe, do we have the live shot of the White House that we can pull up? The White House, you see right there, is expected to hold a briefing. It's going to be an on-camera briefing by the president's coronavirus task force, just to show you how concerned the White House is about this. I believe I heard from one person on Wall Street, in fact, saying that 25% of S&P earnings calls have focused or mentioned the coronavirus. So we are monitoring this story very closely as well. I want to turn now to the Senate floor. I believe we are about to start with Justice John Roberts presiding there.
Mr. Chief Justice, members of the Senate, the House managers have said throughout their presentation and throughout all of the proceedings here, again and again, that you can't have a trial without witnesses and documents, as if it's just that simple. If you're going to have a trial, there have to be new witnesses and documents. But it's not that simple. And that's really something that is a trope that's being used to disguise the real issues, the real decisions that you'd be making on this decision about witnesses. Because there's a lot more at stake there. And let me unpack that and explain what's really at stake there. The first is this idea that if you come to trial, you've always got to go to witnesses, have new witnesses come in and that. But that's not true. In every legal system, and in our legal systems on both civil and criminal sides, there's a way to decide right up front in some quick way whether there's really a triable issue, whether you really need to go to all the trouble of calling in new witnesses and having more evidence and something like that. And there's not here. There's no need for that, because these articles of impeachment on their face are defective. And we've explained that. Let me start with the second article on the obstruction charge. We've explained that charge is really trying to say that it's an impeachable offense for the president to defend the separation of powers. That can't be right. But it's also the case that no witnesses are going to say anything that makes any difference to the second article of impeachment. That all has to do with the validity of the grounds the president asserted, the fact that he asserted longstanding constitutional prerogatives of the executive branch in specific ways to resist specific deficiencies in the subpoenas that were issued. No fact witness is going to come in and say anything that relates in any way to that. It's not going to make any difference. And on the first article of impeachment, that too is defective on its face. And we've explained, we heard it again today here, that the way they have this subjective theory of impeachment that will show abuse of power by focusing just on the president's subjective motives. And they said again today here that the way they can show the president did something wrong is that he defied the foreign policy of the United States. And I talked about that before, this theory that he defied the agencies within the executive branch. He wasn't following the policy of the executive branch. That's not a constitutionally coherent statement. The theory of abuse of power that they framed in the first article of impeachment would do grave damage to the separation of powers under our Constitution, because it would become so malleable. They can pour into it anything they want to find illicit motives for some perfectly permissible action. It becomes so malleable, it's no different than maladministration, the exact ground that the framers rejected during the Constitutional Convention. The Constitution defines specific offenses. It limits and constrains the impeachment power. Now, there's also the fact that we actually heard from a lot of witnesses. We heard from a lot of witnesses in the proceedings so far. You've heard 192 video clips by our count from 13 different witnesses. There were 17 witnesses deposed in closed hearings in the House, and 12 of them testified again in open hearings. You've got all of those transcripts, so you can see the witnesses' testimony there. The key portions have been played for you on the screens. And you've got over 28,000 pages of documents and transcripts. You've got a lot of evidence already. But there's another principle that they overlook when they say, well, if you're going to have a trial, there just have to be witnesses, as if the most ordinary thing is you get to trial and then start subpoenaing new witnesses and documents. That's not true either. And we pointed this out. In the regular courts, the way things work is you've got to do a lot of work preparing a trial called discovery to find out about witnesses and depose them and find out about documents before you get to trial. You can't show up the day of trial and say, oh, Your Honor, actually, we're not ready. We didn't subpoena John Bolton or witness X or witness Y. And now we want to subpoena that witness. Now we want to do discovery. And why does that matter here? Because here, to show up not having done the work and to expect that work to be done in the Senate by this body has grave consequences for the institutional interests of this body, and it sets a precedent. Really, it sets an important precedent for two bodies, for the Senate and for the House. Because what the Senate accepts as an impeachment coming from the House determines not just precedent for the Senate, but really precedent for the House in the future as well. If the procedures used in the House to bring this proceeding here to this stage are accepted, if the Senate says, yes, we'll start calling new witnesses because you didn't get the job done, and whatever process you used to get it here, then that becomes the new normal. And that's important in a couple of ways. One is, as we've pointed out, the totally unprecedented process that was used in the House that violated all notions of due process. There are precedents going back 150 years in the House ensuring that someone accused in an impeachment hearing in the House has due process rights to be represented by counsel, to cross-examine witnesses, to be able to present evidence. They didn't allow the president to do that here. And if this body says that's okay, then that becomes the new normal. And they stand up here, the House managers, and say, this body would be unfair if this body doesn't call the witnesses. They talk about fairness. Where was the fairness in that proceeding in the House? And Manager Schiff says things would be arbitrary if you don't do what they say and call the witnesses they want. Well, wasn't it arbitrary in the House when they wouldn't allow the president to be represented by counsel, wouldn't allow the president to call witnesses? There was no precedent in a presidential impeachment inquiry to have open hearings where the president and his counsel were excluded. It also would set a precedent to allow a package, a proceeding from the House to come here that the House managers say, well, now we need new witnesses. We haven't done all the work. And it's witnesses they didn't even try to get. They didn't subpoena John Bolton. And they didn't go through the process when other witnesses were subpoenaed. When Dr. Kupperman, Charlie Kupperman, went to court, they withdrew the subpoena. And now to say that, well, fairness demands that this body has to do all that work, that sets a new precedent as well. And it would change for all the future the relationship between the House and the Senate in impeachment inquiries. It would mean that the Senate has to become the investigatory body. And the principles that they assert, they did a process that wasn't fair. They did a process that was arbitrary, that arbitrarily denied the president rights. They did a process that wouldn't allow witnesses. And then they came here on the first night. Remember when we were all here until 2 o'clock, and in very belligerent terms said to the members of this body, you're on trial. It will be treachery if you don't do what the House managers say. That's not right. When it was their errors, when they were arbitrary and they didn't provide fairness, they can't project that onto this body to try to say that you have to make up for their errors, and if you don't, the fault lies here. Now, they also suggest that it's not going to take a long time, that they only want a few witnesses. But of course, if things are opened up to witnesses, and it is going to be fair, it's not just one side, it's not just the witnesses that they would want. The president would have to be permitted to have witnesses. And with all respect, Mr. Chief Justice, the idea that if a subpoena is sent to a senior advisor to the president, and the president determines that he will stand by the principle of immunity that's been asserted by virtually every president since Nixon, that'll just be resolved by the Senate right here, whether or not that privilege exists, by the Chief Justice sitting as presiding officer. That doesn't make sense. That's not the way it works. The Senate, even when the Chief Justice is the presiding officer here, can't unilaterally decide the privileges of the executive branch. That dispute would have to be resolved in another way, and it could involve litigation, and it could take a lot of time. So the idea that this will all be done quickly, if everyone just does what the House managers say, is not realistic. It's not the way that the process would actually have to play out in accord with the Constitution. And that has another significant consequence. Again, affecting this institution as a precedent going forward. Because what it suggests, the new normal that would be created then is kind of an express path for precisely the sort of impeachments that the framers most feared. The framers recognized that impeachments could be done for illegitimate reasons. They recognized that there could be partisan impeachments. And if this is the new normal, this is the very epitome of a partisan impeachment. There was bipartisan opposition to it in the House, and it was rushed through with unfair procedures, 78 days total of inquiry. Think about that. In Nixon, there had been investigating committees, and there was a special prosecutor long before the House Judiciary Committee started its investigation. In Clinton, there was a special counsel, an independent counsel, for the better part of a year before the House Judiciary Committee even started hearings. Everything from start to finish in this case, from September 24th to the articles of impeachment were considered in the Judiciary Committee, was done in 78 days. In 78 days, and for the 71 of them, the president was entirely locked out. So the new normal would be slapdash, get it done quickly, unfair procedures in the House to impeach a president, then bring it to the Senate, and then all the real work of investigation and discovery is going to have to take place with that impeachment hanging over the president's head. And that's a particular thing that the framers also were concerned about. And I mentioned this the other day. In Federalist number 65, Hamilton warned specifically about what he called, and I'm quoting, the injury to the innocent from the procrastinated determination of the charges which might be brought against them. Because he understood that if an impeachment charge from the House wasn't resolved quickly, if it was hanging over the president's head, that in itself would be a problem. And that's why they structured the impeachment process so that the Senate could be able to swiftly determine impeachments that were brought. That's also suggests that's why there is a system for having thorough investigation, thorough process done in the House. And Hamilton explained that delay after the impeachment would afford an opportunity for intrigue and corruption. And it would also be, as he put it, a detriment to the state from the prolonged inaction of men whose firm and faithful execution of their duty might have exposed them to the persecution of an intemperate or designing majority in the House of Representatives. And that's what's happened here. And if you create a system now that makes the new normal a half-baked slapdash process in the House, just get the impeachment done and get it over to the Senate, and then once the president's impeached, and you have the head of the executive branch, the leader of the free world, having something like that hanging over his head, then we'll slow everything down, and then we'll start doing the investigation and just drag it out. That's all part of what makes this even more political, especially in an election year. It's not the process that the framers had in mind, and it's not something the Senate should condone in this case. The Senate is not here to do the investigatory work that the House didn't do, where there's been a process that denied all due process, that produced a record that can't be relied upon. The reaction from this body should be to reject the articles of impeachment, not to condone and put its imprimatur on the way the proceedings were handled in the House, and not to prolong matters further by trying to redo work that the House failed to do, by not seeking evidence and not doing a fair and legitimate process to bring the articles of impeachment here. Thank you.
Mr. Sekulow.
Chief Justice, members of the Senate, over a 7-day period, you did hear evidence. You heard evidence from 13 different witnesses, 192 video clips, and as my colleague, the Deputy White House Counsel said, over 28,000 pages of documents. You heard testimony from Gordon Sondland. He's the United States Ambassador to the European Union. You heard that testimony. He testified in the House proceedings. I did not have an opportunity to cross-examine him. If we get witnesses, I have to have that opportunity. William Taylor, former acting United States Ambassador to the Ukraine, testified. You heard his testimony. we didn't get the opportunity to cross-examine him. He would be called. Tim Morrison, the former senior director for Europe and Russia of the National Security Council. You saw his testimony. They put it up. We didn't get an opportunity. We did not have an opportunity to cross-examine him. Jennifer Williams, special advisor on Europe and Russia for Vice President Mike Pence. You saw her testimony. They put it up. I did not have the opportunity to cross-examine her. If we call witnesses, we would have to have that opportunity. David Holmes, the political counsel to the United States Embassy in Ukraine, saw testimony from him. We're not able to cross-examine. If he's called, or if we get witnesses, we will call the ambassador and we will cross-examine. Lieutenant Colonel Alexander Vindman, you saw his testimony. He appeared before the House. We didn't have the opportunity to cross-examine him. If we call witnesses, we will, of course, have that right to cross-examine him. Fiona Hill, she is the former senior director for Europe and Russia on the National Security Council. She testified before the House. If we have witnesses, we have the opportunity to call her then and cross-examine Fiona Hill. Kurt Volker, former United States Special Representative for Ukraine negotiations. They called him. We did not have the opportunity to cross-examine. If we're calling witnesses, these are witnesses you've heard from, we would have the right to call witnesses and to cross-examine Mr. Volker. George Kent, the Deputy Assistant Secretary of State for the Bureau of European and Eurasian Affairs. You saw his testimony. They called him. If we have witnesses, we have the right to call that witness and to cross-examine Deputy Assistant Secretary Kent. The former United States Ambassador to Ukraine, Ambassador Yovanovitch, they called her. You saw that testimony. We did not have the opportunity to cross-examine her. If we have witnesses, we would have to call her. Laura Cooper, Deputy Assistant Secretary of Defense for Russia, Ukraine, and Eurasia. They called her. You saw her witness testimony right here. We did not have the opportunity to cross-examine her. We would have to be given that opportunity. These are witnesses against the president. Laura Cooper, Deputy Assistant Secretary of Defense for Russia, Ukraine, and Eurasia. Again, same thing. David Hale, Undersecretary of State for Political Affairs. He was called by the House. You saw his testimony. We never had the opportunity to cross-examine. If we have witnesses, we have to have the opportunity to do that. There were other witnesses that were called, or you saw their testimony or heard their testimony, where it was referred to: Catherine Croft, the Special Advisor for Ukraine Negotiations, Department of the State; Mark Sandy, the Deputy Associate Director for National Security Programs; and Christopher Anderson, Special Advisor for Ukraine Negotiation, Department of State. You heard their testimony referred to. We did not have the opportunity to cross-examine them. So this isn't going to happen if witnesses are called in a week. Now, that's just the witnesses that have been produced that you have seen by the House managers. You are being called upon to make consequential constitutional decisions. Consequential decisions for our Constitution. We talk about the burden of proof. I've said this before, I'll say it again. 31 times the manager said they proved their case. 29 times they said the evidence was overwhelming. Manager Nadler, he didn't only say it was overwhelming in his view. On page 739 of the congressional record, he's very clear. He says, not only is it strong, there is no doubt. That's what he says. The one thing that the House managers think the President Council's got right is quoting me, talking about Mr. Nadler, Manager Nadler, as saying, beyond any doubt, it is indeed beyond any doubt. Now, of course, we think that they have not proven their case by any stretch of any proper constitutional analysis. In the Clinton investigation, they talk about witnesses being called, but the three witnesses that were called had either testified before the grand jury or before the House committees. These weren't new witnesses. What Mr. Philbin said is correct. Under our constitutional design, they're supposed to investigate. You are to deliberate. But what they're asking you to do is now become the investigative agency, the investigative body. If they needed all this additional evidence, which they said they don't need, and by the way, not only did they say it in the record, this is House Manager Nadler, quote, this is when he was on CNN back on the 15th of this month, we brought the articles of impeachment because despite the fact that we didn't hear from many witnesses, we heard from enough witnesses to prove the case beyond any doubt at all. The same can be said of Representative Lofgren. You know, we have evidence proving the case through, for example, at the meeting when Bolton said it was a drug deal. Well, we have fact witnesses. Hill was there, Vindman was there, Sondland was there. So this idea that they haven't had witnesses, that's the smokescreen. You've heard from a lot of witnesses. The problem with the case, the problem with their position is, even with all of those witnesses, it doesn't prove up an impeachable offense. The articles fail. I think it's very dangerous if the House runs up, which they did, articles of impeachment quickly, so quickly that they are clamoring for evidence, despite the fact that they put all of this evidence forward. They got their wish of an impeachment by Christmas. That was the goal. But now they want you to do the work they failed to do. But as I said, time and time again we heard you didn't hear from witnesses, you didn't hear from many witnesses. Mr. Schiff modified that a little bit today. A little bit. You heard from a lot of witnesses. But if we go down the road of witnesses, this is not a one-week process. Remember I talked about the waving the wand and Ukrainian corruption in Ukraine was gone. You're not going to have a witness wand here where we just say, okay, you got a week to do this and get it done. There's no way that would be proper under due process. But you know, due process is supposed to be for the person accused. And they are turning it on its head. They brought the articles before you. They're the ones that rushed the case up and then held it before you could actually start the proceedings. But they're the ones that passed the articles before Christmas. You know, we talked a lot about the court system and the fact that they were seeking witnesses. And when it got close to actually having a court proceeding, they decided that they didn't want to have that witness go through that proceeding. They actually withdrew the subpoena to moot the case out. How many constitutional challenges will we have in this body because they placed a burden on you that they wouldn't take themselves in putting their case forward? If we look at our constitutional framework and our constitutional structure, that's not the way it's supposed to work. Now, our opposition to this motion is rather straightforward, as I've said. We came here ready to try the case on the record that they presented. The record that the managers told us was overwhelming and complete. Mr. Schiff went through every sentence of the articles of impeachment just a few days ago and said, proved, proved, proved. The problem is what it proved is not an impeachable offense. You could have witnesses that prove a lot of things, but if there's not a violation of a law, if it doesn't meet the constitutional required process, the constitutional required substantive issues of do these articles, these allegations rise to the level of a sufficient for a removal of office for a duly elected president of the United States? It doesn't. And especially so when we are in an election year. I am not going to take the time, your time, which is precious, to go over in each and every allegation about witnesses that I could. I could do it. I could stand here for a long time. I'm not going to do that. I'm just going to say this. They created the record do not allow them to penalize the country and the Constitution because they failed to do their job. With that, Mr. Chief Justice, we yield our time.
Thank you, counsel. The House managers have 30 minutes remaining.
Thank you, Mr. Chief Justice. Senators, I want to walk through some of the arguments that you've just heard from the President's counsel. The first were arguments made by Mr. Philbin. Mr. Philbin began by saying the House managers assert that you can't have a trial without witnesses. And he said it's not that simple. Actually, it is. It is pretty simple. It is pretty simple. In every courthouse, in every state, in every county in the country where they have trials, they have witnesses. And I think you heard Mr. Philbin tie himself into knots as to why this should be the first trial in which witnesses are not necessary. But you know, some things are just as simple as they appear. A trial without witnesses is simply not a trial. You can call it something else, but it's not a trial. Now, Mr. Sekulow said something very interesting. He said, the House investigates and the Senate deliberates. Well, he would rewrite our Constitution with that argument. Because the last time I checked the Constitution, it said that the House shall have the sole power of impeachment and the Senate shall try the impeachment. Not merely deliberate about it, not merely think about it, not merely wonder about it. I know you're the greatest deliberative body in the world, but not even you can deliberate in a trial without witnesses. But Mr. Sekulow would rewrite the Constitution. Your job is not to try the case, he says. Your job is merely to deliberate. That is not what the founders had in mind, not by a long shot. Now, Mr. Philbin says none of these witnesses would have relevance on Article 2, I guess conceding that they would have relevant evidence on Article 1. But that's not true either. Imagine what you will see when you hear from the witnesses who ran the Office of Management and Budget, or imagine what you will see when you read the documents from the Office of Management and Budget. What you will see is what they have covered up. What you will see is the motive for their complete obstruction of Congress. When you see not the redacted emails, not the fully blacked out emails that they deigned to give in the litigation under the Freedom of Information Act, but when you see what is under those redactions, you will have proof of motive. When you see those documents, you will see just how fallacious these non-assertions of executive privilege are. You will see, in essence, what they have covered up. It could not be more relevant to whether their panoply of legal argumentation to justify we shall fight all subpoenas is merely a cover-up and legal window dressing. So these witnesses and documents are critical on both articles. Now, you also heard Mr. Philbin argue, and again, this is where we expected we'd be at the end of the proceeding, which is essentially they proved their case. They proved their case. We pretty much all know what's gone on here. We all understand just what this president did. No one really disputes that anymore. So what? So what? It's a version of the Dershowitz defense. So what? The president could do no wrong. The president is the state. If the president believes that corrupt conduct would help him get reelected, if he believes shaking down an ally and withholding military aid, if he believes soliciting foreign interference in our election, whether it be from the Ukrainians or the Russians or the Israeli prime minister or anyone else in any form that it may take, so what? He has a God-given right to abuse his power. And there's nothing you can do about it. It's the Dershowitz principle of constitutional lawlessness. That's the end-all argument for them. You don't need to hear witnesses who will prove the president's misconduct because he has a right to be as corrupt as he chooses under our Constitution. And there's nothing you can do about it. God help us if that argument succeeds. Now, they say that these witnesses already testified, and so you don't need to hear from anybody. There were witnesses who already testified, and so the House doesn't get to call witnesses in the Senate. That would be like a criminal trial in any courthouse in America where the defendant, if he's rich and powerful enough, can say to the judge, "Hey, judge, the prosecution got to have witnesses in the grand jury. They don't get to call anyone here. They had their chance in the grand jury. They called witnesses in the grand jury. They don't get to call witnesses here." That's not how it works in any courtroom in America, and it's not how it should work in this courtroom. Of course, you heard the argument again, repeated time and time again. The House is saying they're not ready for trial. Of course, we've never said we weren't ready for trial. We came here very prepared for trial. I would submit to you the president's team came here unprepared for trial. Unprepared for the fact that there would be, as we all anticipated, a daily drip of new disclosures that would send them back on their heels. We came here to try a case, prepared to try a case, and yes, we had, I hope, the not unreasonable expectation that in trying that case, like in every courtroom in America, we could call witnesses. That is not a lack of preparation, that is the presence of common sense. They didn't try to get Bolton, they argued. Mr. Philbin said they didn't even try to get Bolton. Now, of course, we did try to get Bolton. And what he said when he refused to show up voluntarily is, "If you subpoena me, I will sue you. I will sue you." He said basically what Don McGahn told us 9 months ago. I will sue you. Good luck with that. Now, the public argument that was made by his counsel was that he and Dr. Kupperman, out of just due diligence, they just want a court to opine that it's okay for them to come forward and testify. As soon as the court blesses their testimony, they're more than willing to come in. They just are going to court to get a court opinion saying they could do it. And so, of course, we said to them, if that's your real motivation, there's a court about to rule on this very issue of absolute immunity. And very shortly thereafter, that court did. That was the court, Judge Jackson in the McGahn case, and the judge said this argument about absolute immunity, which, yes, presidents have always dreamed about and asserted, but which has never succeeded in any court in the land. It was ridiculed in the case of Harriet Miers. It was made short shrift in the case of Don McGahn, where the judge said, no, we don't have kings here. In the 250 years of jurisprudence, there is not a single case to support the proposition that the president can simply say that my advisors are absolutely immune from process. And of course, in every other non-impeachment context where the courts have looked at the issue of a Congress's power to enforce its subpoenas against witnesses or documents, the courts have said the power to compel compliance to a subpoena is co-equal, coextensive with the power to legislate, because you can't do one without the other. If we can't find out whether the president is breaking the law, violating the Impoundment Control Act or any other when he is withholding aid we appropriated from an ally, how can we legislate a fix to make sure that this never happens again? We can't. If we can't get answers, we can't legislate. That is a proposition vindicated by every court in the land, and of course, in the context of impeachment, the courts have said that is never more important. Never more important. Now, I don't know why, after saying he would sue us, and we had to expect that, like Don McGahn, where we are still in court 9 months later, I don't know why he's changed his mind. But I suspect it's for the reason that if this trial goes forward and he keeps this to himself, it will be very difficult to explain to the country why he saved it for the book. When he knew information of direct relevance and consequence to a decision that you have to make about whether a president of the United States should be removed from office, it would be very difficult to explain why that was saved for a book. Well, I would submit to you it will be equally difficult for you to explain as it would be for him. But you can ask him that question. Why are you willing to testify before the Senate but not the House? And you should ask him that question. Now, it was said, and it has the character of, you should have fought harder to overcome our obstruction. The House should have fought harder to overcome our stonewalling. Shame on the House for not fighting harder to overcome our stonewalling. If only they had fought harder to overcome our stonewalling, maybe they could have gotten these witnesses earlier. That's a really hard argument to make while they're stonewalling. You should have tried harder. You should have taken the years that would be necessary to overcome our stonewalling. And the reason why that argument is in such bad faith, as I pointed out to you yesterday, that while they're in this body arguing the House was derelict, slapdash, they should have fought harder and longer and endlessly to overcome our stonewalling. While they're making that argument to you, the House should have fought up and down the courts, from the district to the Court of Appeals to the Supreme Court and back again. They're in the courthouse arguing the opposite. They're in the courthouse saying, Judge, they're trying to enforce a subpoena on Don McGahn. You need to throw it out. They don't have the jurisdiction. This is non-justiciable. You can't hear this case. That is a really hard argument to make. I credit them for making it with a straight face. But that's the character of it. You should have fought harder to overcome our stonewalling and obstruction. Now, they also say the Chief Justice cannot decide issues of privilege. No, the Chief Justice can't make those decisions. You need to let us litigate this up and down the court system. That's a pretty remarkable argument, because the Senate rules allow the presiding officer to make judgments, to rule on issues of evidence, materiality, and privilege. That is permitted under your own rules. We don't need to go up and down the courts. We've got a perfectly good judge right here. Now, you heard our proposal yesterday that we take a week, just a week, to depose the witnesses that we feel are relevant, that they feel are relevant, and that the justice rules are relevant. Just 1 week. Now, they can say that the Constitution requires them to go to court, but of course it doesn't. There is absolutely no constitutional impediment from these fine lawyers saying, you know, that's eminently reasonable. We will allow a neutral party, the Chief Justice of the United States of America, to rule on whether a witness is material or immaterial, whether they're being called for purposes of probative evidence or harassment. and whether are you making a proper claim of privilege or merely trying to hide crime or fraud. The concern they have is not that this Chief Justice will be unfair, but rather that he will be fair. But do not make any mistake about it. Do not let them suggest that there is something constitutionally impermissible or it would violate the President's rights to allow the Chief Justice of the United States to make those decisions in this court, because he is empowered to do so by your rules and by the Constitution, which gives you the sole power to try impeachments. In the sole exercise of your power to try impeachments, you can say, we will allow the Chief Justice to make those decisions. Now, Mr. Sekulow said that you've heard the testimony of 13 witnesses. And I think the impression is meant to be given, if not to you who know otherwise, then maybe to the people watching at home, that they must have been in between errands while watching the Senate trial and missed where those 13 witnesses came before the Senate and testified. But of course, you heard no live testimony in this body. There wasn't any live testimony before this body, and I don't recall any of you in that super secret basement bunker they've been talking about. Now, I'll admit there were 100 members eligible to be there, so maybe I missed one of you. But I don't think you were there for the live testimony in the House. Now, Mr. Sekulow says the President was deprived of his right of calling these witnesses himself and cross-examining these witnesses in the House, but that's not true either, because the President was eligible to call witnesses in his defense in the Judiciary Committee and chose not to do so. If the President's counsel felt that, Bill Taylor says that he spoke with Sondland right after this phone call with the President, and Sondland talked about how the military aid was conditioned on these investigations. The President wanted Zelensky in a public box. And I'd really like to cross-examine that West Point grad Vietnam vet, because I don't believe him. They could have called Bill Taylor in the Judiciary Committee and cross-examined him. Or they could have called Mick Mulvaney and put him under oath and let him contradict what we now John Bolton would say. But of course they didn't do that. No, they said merely, just get it over with in the House. For all there was too quick, too slapdash, get it over with in the House. Because as the President said, when it comes to the Senate, we'll have a real trial where he gets to call witnesses. But they've changed their tune, because now they know what they really have known all along, which is those witnesses would deeply incriminate this President. And so, instead, they have fallen back on the argument that if we're going to go down the road to having a real trial, we, the President's lawyers, are going to make you pay. And the form of this argument is, we are going to call every witness under the sun. We're going to call every witness that testified before the House. We're going to call every witness that we can think of that would help smear the Bidens. We are going to keep you here until kingdom come. That's essentially the argument that they're making when Mr. Sekulow says we're going to bring in Fiona Hill and we're going to bring in Tim Morrison, and we're going to bring in this witness and bring in that witness. You have the sole power to try this case. You do not have to allow the President's lawyers to abuse your time or this process. You have the power to decide, no, we gave each side 24 hours to make their arguments. We're going to give each side a shared week to call their witnesses. You have that power. If you didn't, you couldn't have constricted the amount of time for our argument. You can likewise determine how much time should be taken with witness testimony. Now, Mr. Sekulow ended his argument against witnesses with where Mr. Philbin essentially began. It all comes back to the Dershowitz principle. What's the point of witnesses if the president can do whatever he wants under Article 2? What's the point of calling witnesses? What's the point of having a trial if the president can do whatever he wants under Article 2? The only constraining principle, and I think that one of the senators asked yesterday, what's the limiting principle in the Dershowitz argument? If a president can corruptly seek foreign interference in his election because he believes that his election is in the national interest, then you cannot impeach him for it, no matter how damaging it may be to our national security. What is the limiting principle? And I suppose the limiting principle is only this. It only requires the president to believe that his re-election is in the national interest. Well, it would require an extraordinary level of self-reflection and insight for a president of the United States to conclude that his own re-election was not in the national interest. Not unprecedented, mind you. I think that was the decision that LBJ ultimately arrived at. But I would not want to consider that a meaningful limitation on presidential power, and neither should you. Finally, counsel expressed some indignance that we should suggest that it's not just the Senate, it's not just the president, rather, who is on trial here, but it is also the Senate. How dare the House managers suggest that your decisions should reflect on this body? That's just such a calumny. Well, let me read you a statement made by one of your former colleagues. This is what former U.S. Senator John Warner, a Republican of Virginia, had to say. As conscientious citizens from all walks of life are trying their best to understand the complex impeachment issues now being deliberated in the U.S. Senate, the rules of evidence are central to the matter. Should the Senate allow additional sworn testimony from fact witnesses with firsthand knowledge and include relevant documents, he asks. As a lifelong Republican and a retired member of the U.S. Senate, who once served as a juror in a presidential impeachment trial, I am mindful of the difficult responsibilities those currently serving now shoulder. I believe, as I'm sure you do, that not only is the president on trial, but in many ways, so is the Senate itself. As such, I am strongly supportive of the efforts of my former Republican Senate colleagues who are considering that the Senate accept the introduction of additional evidence that they deem relevant. Not long ago, senators of both major parties always worked to accommodate fellow colleagues with differing points of view to arrive at outcomes that would best serve the nation's interests. If witnesses are suppressed in this trial, and a majority of Americans are left believing the trial was a sham, I can only imagine the lasting damage done to the Senate and to our fragile national consensus. The Senate embraces its legacy and delivers for the American people by avoiding the risk. Throughout the long life of our nation, federal and state judicial systems have largely supported the judicial norms of evidence, witnesses, and relevant documents. I respectfully urge the Senate to be guided by the rules of evidence and follow our nation's judicial norms, precedents, and institutions to uphold the Constitution and the rule of law by welcoming relevant witnesses and documents as part of this impeachment trial. That is your colleague, former Senator John Warner. Senators, there is a storm blowing through this Capitol. Its winds are strong, and they move us in uncertain and dangerous directions. Jefferson once said, "I consider trial by jury as the only anchor yet imagined by man by which a government can be held to the principles of its Constitution." The only anchor ever imagined, yet imagined by man, by which a government can be held to the principles of its Constitution. I would submit to you, remove that anchor, and we are adrift. But if we hold true, if we have faith that the ship of state can survive the truth, this storm shall pass. I yield back.
Thank you, Mr. Manager.
Mr. Chief Justice.
The majority leader
I
is
suggest the
recognized.
absence of a quorum.
The clerk will call the roll.
Mr. Alexander. Hello, everyone. I'm Lana Zak in New York. It's day 10 of the Senate impeachment trial of President Trump, still underway, and senators will soon vote on witnesses. The House managers and the president's legal team have spent the day arguing the motion to call witnesses. However, Democrats appear to have been dealt a significant blow. Alaska Republican Senator Lisa Murkowski says she will vote against witnesses in the Senate trial. She had reportedly been on the fence for the past 2 weeks. That now gives Republicans an expected 51 to 49 majority against continuing the trial with additional witnesses in the Senate. In her statement, Murkowski said the following, quote, "The House chose to send articles of impeachment that are rushed and flawed. I carefully considered the need for additional witnesses and documents to cure the shortcomings of its process, but ultimately decided that I will vote against considering motions to subpoena. Given the partisan nature of this impeachment," she writes, "from the very beginning and throughout, I have come to the conclusion that there will be no fair trial in the Senate. I don't believe the continuation of this process will change anything. It is sad for me to admit that. As an institution, the Congress has failed." All of this comes on the heels of yet another report from the New York Times. It alleges former National Security Advisor John Bolton says in his upcoming book that the president told him to pressure Ukraine as early as May. That's 2 months earlier than President Trump's now notorious call with Ukrainian President Zelensky, which is now at the very center of the impeachment case. Bolton also reportedly wrote that White House Chief of Staff Mick Mulvaney, President Trump's personal lawyer Rudy Giuliani, and White House counsel Pat Cipollone were involved in that conversation. Earlier, lead impeachment manager Adam Schiff used the news to make the case for witnesses.
You will see in a few moments, and you will recall Mr. Cipollone suggesting that the House managers were concealing facts from this body. He said all the facts should come out. Well, there's a new fact which indicates that Mr. Cipollone was among those who were in the loop. Yet another reason why we ought to hear from witnesses. Just as we predicted, and it didn't require any great act of clairvoyance, the facts will come out. They will continue to come out. And the question before you today is whether they will come out in time for you to make a complete and informed judgment as to the guilt or innocence of the president.
Adam Schiff trying to make a case to a resistant Republican majority Senate. So I want to bring in Keir Dugal, Molly Hooper, and Catherine Watson. Molly is a CBSN political contributor. Keir is a CBSN legal contributor and former assistant U.S. attorney for New York's Eastern District. And Catherine Watson is a White House reporter for CBS News Digital. So I'm going to start with you, Molly. How else has the news about Bolton really impacted today's trial?
You know, I'm going to veer off a little bit because right now we're waiting. It hasn't, essentially. The witnesses, from what we know, Lisa Murkowski, who is the last standout or holdout, if you will, on this issue of whether or not the Senate will move on to call witnesses. She says, no, I'm not going to call them. So essentially, the White House won that argument. They aren't going to be called. And that vote will happen later this evening. But what's happening right now on the floor as you're watching it, in the bottom of the screen, you'll see Mitch McConnell talking with John Thune to his right and Chuck Schumer. And what they're trying to do is they're trying to figure out what happens after that vote on witnesses. Because as of now, we don't have essentially a roadmap for how this thing wraps up. We don't know how much time both the White House and the House managers are going to have to conclude their cases. We don't know when the final vote is set for. We don't know whether the senators are going to deliberate in open or closed session as they did back in the Clinton impeachment. And so really, Mitch McConnell needs to put forward another resolution that essentially spells it all out. Here's the rub. The rub is that when he offers that resolution to wrap this thing up, Charles Schumer and Democrats can offer amendments to that resolution. And what we can see and what we are anticipating seeing is an effort by, some Senate Democrats to prolong this trial, to extend it as long as they want to, because each amendment that's offered would allow for 2 hours of debate, 1 hour on both sides. And that's sort of reminiscent of what we saw 11 days ago, before the Senate even moved on to opening arguments. They had to figure out the time limits for those. And remember, that day lasted into Tuesday or Tuesday to Wednesday. It was a very long day, which is what Democrats may, in fact, do this go-round.
I wish that camera could pan down and we could zoom in and read those lips right there. I'm trying to get as close to the TV as possible to watch it. But, you know, with Murkowski saying, I'm ashamed of the Senate. This isn't a fair trial, but I'm not going to vote for witnesses. Is it just game over for the Democrats? It's just stalling now, Molly?
Well, it is. That's what it seems like. And, one issue that has arisen over this Senate impeachment trial is that you can tell Chuck Schumer, Mitch McConnell, they don't have the warmest of relationships. And that's where you see in what's going on right now. And it makes it very difficult for the Senate leaders to come to any agreement on how to proceed and actually get to the meat of the matter. But when it comes down to it, with Lamar Alexander coming out and essentially Lisa Murkowski saying, well, and Lisa Murkowski is a little bit different, but Lamar Alexander saying, okay, what the president did, it wasn't good, it wasn't appropriate, I don't need more witnesses to tell me that, but it's not impeachable. Well, it's hard to change that individual's mind that you need to hear from more witnesses.
So let me bring Keir into this conversation now, because it is interesting. We've been hearing from Republican senators, many of the more moderate Republican senators, who have said that they feel like the president's actions were not above board, that he was not doing the right thing. And this is something that you and I have talked about, whether this will have a lasting impact in how the executive branch functions in the future. Is the option for censure now completely off the table? If Republicans wanted to express their displeasure in another way, could they do that, or they tried to do impeachment and that was really their only option? Keir?
So that's a terrific question.
Thank you.
And one that our colleague Jonathan Turley discussed earlier in the day when he noted that statements like the ones you just referred to, if they accumulate, if they get to the point where they get, I guess, critical mass, let's use that term, they become effectively a constructive censure. They become the sort of perhaps majority or even a large majority of the Senate. If there is some agreement that this conduct is inappropriate, pick your adjective, inappropriate, wrong, but perhaps in the view of some not removable, you get a censure.
So, Catherine, how closely has the White House been following today's hearings, and have you been hearing anything from the president about how quickly he'd like this to wrap up?
Sure. Well, the White House has, of course, been following this very closely. I think there has definitely been a sense of a sigh of relief when we heard earlier today that Murkowski was not going to vote for witnesses. That essentially sealed the deal, at least as far as we can tell. It seems kind of more like a game of time rather than whether we're going to call witnesses. But, of course, the White House is still watching closely. Of course, the president's legal team is continuing to figure out strategy. One of my colleague, Major Garrett, our chief White House correspondent, reported earlier today that the president had been briefed on the possibility of this trial extending as late as Wednesday, potentially, and that is something that the president is aware of, maybe not happy about, but understands that might be a necessity. So it's just going to be very fascinating to see moving forward what happens from here. The president is expected to, I am not looking at my phone right now, but really any moment be leaving for Florida, where he is going to be spending the weekend at his winter getaway in Mar-a-Lago. So we'll see if he says anything there, or as always, there are tweets.
Yeah, the president certainly likes to do that. He also likes to gaggle, as we know, on his way out of town. Keir, what do you say about that idea that if the trial were to continue until Wednesday and not actually be wrapped up until that point, if Adam Schiff is correct and more stuff continues to come out, if they've already voted to reject witnesses, can they revisit that idea?
So we're in this very odd scenario here, right? As a courtroom lawyer, in a case where the charges were not dismissed, right, and the president's counsel did not move to dismiss these charges. Under those circumstances, you would expect a trial to have witnesses, as long as they're relevant. You would expect there to be witnesses. if the Senate chooses, and now you have to sort of differentiate. This is not a courtroom trial. It's a trial that it's quasi-political and quasi-legal in nature. You just asked a question, Lana, about whether or not this is a stalling, whether it's just delay.
Right.
So, perhaps if it's futile and it's pointless as a legal matter, you might accept that idea. But as a political matter, and I'll defer to the political experts here on the set, having that extra time as a political matter might serve a very important purpose in a trial that is both political and legal. Look, we all have been discussing the idea that if new information comes out that's material and critical, and the Senate chose not to hear it, and they vote without it, they're subject, down the road to questions about, why did you close your eye, refuse to hear, close your eye, however you want to characterize it, potentially relevant and material evidence in what is called in the Constitution a trial. It's called a trial in the Constitution. So these are hard questions to answer.
That's interesting. So I want to update our viewers because Catherine mentioned the president and first lady have in fact boarded, have left the White House, and they did not in fact stop to answer some of the questions that were thrown at them. Molly, it sounds like Keir just set you up for a perfect discussion right here. The political nature of this trial.
That's right.
I know you want to weigh in. Is this, I see her moving in her seat trying to get into the conversation.
No, just going back to this point of it is a political trial, and there is this option, this remedy of censure that has only really been effectively used once. And now that we're at this point in the Senate trial, when we get to the point essentially where Mitch McConnell offers the new resolution to end the trial, a Democrat could offer an amendment to censure the president. And that may put some Republicans, especially individuals who came out saying that this is inappropriate behavior, it could put those Republican senators in a bit of a bind. Because according to my understanding of the Senate rules, really you only need a simple majority to censure the president.
That was exactly what I was going to ask you. Do they need
well, exactly
51?
Because, that's what my understanding is, because this is not a binding resolution. Now, if the Senate wanted to censure but also apply some sort of punishment, like this was attempted when Bill Clinton was president during his impeachment trial. That is a higher bar to cross, and it wasn't successful. But there were several different attempts to censure President Bill Clinton, which would also require he pay a certain amount of money back to the Treasury in the cost that it was that the impeachment trial cost the public. There were various smaller punishments, but it was more than just a slap on the wrist, which is essentially what a censure would be.
Now, Catherine, a Quinnipiac University poll from earlier in the week shows 75% of independents wanted witnesses to testify. Does the White House really worry, as President Trump is trying to campaign for those independent voters, that having the Republicans push forward without having these witnesses, that could come back to hurt him in the general election?
Absolutely. Of course, there's always going to be some little bit of concern. But if you look at the president's approval ratings, they really have remained fairly stable throughout this entire process, some up, some down, but relatively unmoved. You're seeing the people who have stuck with the president all along continue to. And while there actually has been some support from Republicans for there to be witnesses called, some of that, we think, if you dive into the details, appears to also be an appetite for Joe and Hunter Biden, potentially the whistleblower to be called. We're not expecting that to be any sort of a reality. But as far as those independents go, of course, that's something the White House cares about. But the president and the White House continue to emphasize the economy, how well things are going under the president, and essentially saying, hey, do you want to overturn this economic success, this engine that that we have going. So they're really trying to hammer in those kitchen table issues, even as the president himself is sending messages both about the economy and about how impeachment is all just a hoax.
And we heard that actually from the floor, the president's own counsel yesterday in their testimony, touting the president's economic successes. It almost sounded like talking points from the campaign rally. We do know that Republicans have felt, according to the RNC, that the impeachment trial has been very good for them. So, Catherine, who does the White House feel like it really needs to win over in this re-election fight?
Yeah, well, the White House or the campaign, mix of both, sometimes do think that there are people who will come out to vote for the president who didn't think that he really had a shot of winning in 2016 and now see that he does have the capacity to win and will turn out. They, of course, want to keep all of the people who did vote for the president in 2016 to really work hard for their votes, particularly for among blue-collar workers, among more rural voters. They really are struggling with suburban voters, particularly suburban women. And so you see the White House has kind of enacted some new, or I should say the campaign has been pushing some new groups, formed some new kind of Women for Trump type of operations to try to galvanize the women vote. Because another interesting thing that you see in this impeachment saga is there is a stark difference, no matter whose poll you're looking at, in support for impeachment of the president or even removal, a stark contrast between men and women. Women are in favor of it, generally, in basically any poll you look at. Men are slightly against it in basically any poll you look at.
I just want to make sure I'm understanding
there.
Wait, because that's really interesting. Women have been in favor of the impeachment trial and men have been against it?
Yes, and of course the question is always asked slightly differently. Sometimes it's, do you support the impeachment of the president? Do you support impeachment and removal? But there is a huge gap by as many as 20 points from the polls that I've looked at as far as the difference in women supporting impeachment, always supporting some version of the impeachment push versus men being slightly against it.
That is fascinating. Molly Hooper, Keir Dugal, and Catherine Watson, thank you so much. I want you all to continue standing by. We are going to have continuing coverage after this quick break.
You can watch CBSN 24/7.
We've got an amazing story to share with you.
Let's talk about the latest developments. There's so many levels to this.
We have a CBS News exclusive.
Fires in California. What happens next and how does it all play out?
We are on a mission with NASA.
I understand you have some breaking news. It's not over yet is the bottom line.
This is a massive operation.
It's quite an adventure here at CBSN.
It's been a day.
You can see the desperation in the journey simply by looking at the trail that's left behind.
So she says she's 17. She looks kind of like she's 12.
Said to me, if you tried to do this in New York City, take a picture of a man, he'd break your camera.
There's something very, very uncomfortable about this.
Today, a white supremacist blends.
This area can be the new Silicon Valley.
There was not a cot in the warehouse, not one cot in the warehouse.
We're so far deep at this point that there's no turning back. This is a long road ahead.
Our nation's capital, decisions are made here that affect all of us. So join us every evening as we bring you CBS News original reporting from around the world while keeping our eye on what's going on right here in Washington. Our nation's capital, decisions are made here that affect all of us. So join us every evening as we bring you CBS News original reporting from around the world, while keeping our eye on what's going on right here in Washington.
Understanding the world begins with the right questions.
Does the president have a red line here?
CBS This Morning.
Hello, everyone. I'm Lana Zak in New York. Day 10 of the Senate impeachment trial of President Trump is underway, and senators will soon vote on witnesses. The House managers and the president's legal team have spent the day arguing that motion to call witnesses. However, Democrats appear to have been dealt a significant blow today, with Alaska Republican Senator Lisa Murkowski saying that she will, in fact, vote against witnesses in the Senate trial. She had reportedly been on the fence for the past 2 weeks. That now gives Republicans an expected 51 to 49 majority against continuing the trial with additional witnesses in the Senate. I want to bring back our panel, Keir Dugal, Molly Hooper, and Catherine Watson. Keir, President Trump's counsel, Patrick Philbin, argued today that they've already heard a lot from witnesses. I want to play that.
The Constitution defines specific offenses. It limits and constrains the impeachment power. Now, there's also the fact that we actually heard from a lot of witnesses. We heard from a lot of witnesses in the proceedings so far. You've heard 192 video clips by our count from 13 different witnesses. There were 17 witnesses deposed in closed hearings in the House, and 12 of them testified again in open hearings. You've got all of those transcripts, so you can see the witnesses' testimony there. The key portions have been played for you on the screens. And you've got over 28,000 pages of documents and transcripts. You've got a lot of evidence.
So his argument is that there is already a lot of evidence. There's a lot of witnesses, and so we don't need to hear from John Bolton, frankly. Keir, what do you make of that argument?
So this is very odd to me. For decades, and in courtrooms across the country, the way we get to truth is by swearing witnesses, taking their testimony on direct, and cross-examining them. The president's counsel, I believe, has not cross-examined any of the 13 witnesses that he's describing here. The president's counsel chose not to participate. I doubt very seriously that the president's counsel right now is waiving or giving up their right to cross-examine witnesses were they to be called in the Senate trial. So the idea that, okay, there have been witness depositions, and so we've heard from the witnesses and subjected them to that process that we see every day. That's the meat and potato work of courtrooms across our country. That a deposition would substitute for the live witness cross-examined by the defendant's counsel. So you can see them testify confidently, get nervous, stammer, get their facts confused, be corroborated perhaps by lots of other evidence, or have their testimony contradict all of the records or the other witnesses that were to be found credible. That is the process that we have relied upon for decades, generations literally, to find the truth at a trial. And we are not, apparently, if the vote goes the way we predict, we are not going to see that in this Senate trial.
Well, you know, it's interesting. I'm looking here at an interview that President Trump's former chief of staff, John Kelly, gave to NJ.com. And he says an impeachment trial without witnesses is, quote, a job only half done. So I'll bring back in Molly, and I'm going to throw this to you, Molly, because when I read what Senator Murkowski was saying in making her decision today, one of the things that she said was that she didn't want this trial to be prolonged for weeks or months. But Adam Schiff, the House manager, yesterday made a bargain to Republicans. He said, "Give us 1 week for witnesses." Did that offer by Schiff have any weight at all to Republicans making their decision?
No, because he was talking about give us 1 week and for us to call our witnesses. Because what Lindsey Graham has said all along, and Jay Sekulow, if you've been listening to him, which I know you have, Lana, always, but is that if we open this door to witnesses and you get to call John Bolton, we get to call Hunter Biden, and we're going to call a bunch of witnesses.
But why wouldn't Democrats want to do that, Molly? I mean, if honestly, if this is going to be something that is going to hamstring Biden in the general election, why not get that all out into the public? Have that messy ugliness tried right now before they decide who the nominee is.
Well, because I don't think that Republicans necessarily have the votes to get Hunter Biden either, because it would become a circus in that case. And I don't think that McConnell wants. First of all, I know McConnell, and I know the White House. They want this thing to end as soon as possible. They don't want any more bombshells to come out. They want it to be over, done, full stop. And so that's one of the reasons why you are seeing Democrats, the standstill on the Senate floor, essentially trying to figure out how to proceed. Because even though it feels like, after this witness vote is taken, ostensibly the Senate would just go on and vote on the articles of impeachment. But that's not really how it works, because when you have a body of 100 members and they're considered the cooling saucer and very deliberative, they like to deliberate. And so essentially the Democrats can keep the Senate in session voting on amendments to any sort of resolution that McConnell offers to move on and wrap this thing up, and attempt to get more witnesses, essentially to draw it out. But also there's another thing to consider here. There are 4 Democratic presidential candidates who are hamstrung by this whole thing. They should be in Iowa right now, but they're stuck in the Senate, doing their job, of course. But, the Democrats also have their own internal need to move this on.
Interesting.
Right.
Catherine, over at the White House, we know that there hasn't been a lot of love lost between John Kelly and President Trump. But still, has there been a reaction from the White House to the president's former chief of staff, the person that many had called the adult in the room, coming out and saying that the Senate absolutely should have witnesses? And he's been siding with John Bolton through this.
Well, the president himself, at least unless I've missed a tweet in the last 20 minutes or so, has not personally weighed in on this. Of course, John Kelly had a rather, I don't know if abrupt is quite the right word, but not the most graceful exit from the administration. Like so many others, the president became frustrated with him. So in some ways, there isn't always a lot of love lost, at least on the part of the president. Look, it is another well-respected former, very, very senior administration official who is coming out in support of Bolton, at least saying he believes him, and reprimanding the Senate and the White House, of course, for taking this position. So it is someone, John Kelly is someone at least who has about the highest amount of respect among others after his exit from the White House, just incredibly highly respected Marine general. So yeah, it's something that his words, of course, have some weight, but at the end of the day, I really don't think they're going to make any difference.
So, Molly, following off of what Catherine was saying, with John Kelly being so respected among Republicans and Bolton being respected, at least previously, among many of the Senate Republicans, it seems like a lot of this is being litigated in the press right now, the pressure to try and get Republicans to reconsider that. Do you think any of these senators might budge on their position?
Well, you have to check their polling in the states that are dealing with re-election battles right now, like Cory Gardner. What are his internal polls telling him? Are people in Colorado really paying attention to this impeachment battle, or do they care about health care? What are they thinking about? Are they watching this as much as we are, which I hope they are? But, what are the issues that will move his voters to the polls? What are the issues that are moving voters in Maine for Susan Collins, North Carolina for Tom Tillis, Iowa, Joni Ernst? These are all Republicans in purplish states that are very glad, let's say, that the president signed that USMCA, that trade deal. And it's no coincidence that that signing ceremony for this trade deal, which is going to impact farmers and producers in their states, was signed a few days ago. In fact, yesterday, I'm getting all my days confused, but it was signed
They
either
do blur
yesterday or the day
together a little
before.
bit.
Yes, that's right. But it's like I said, it's no coincidence that he signed that, because those seem to be the issues resonating more, according to feedback that the senators are getting, than, say, perhaps the attention on the impeachment trial. Now, whether Democrats, with the DSCC, the Democratic campaign arm, is able to really hammer those Republicans on voting against witnesses. I mean, they have a lot of material that they can use over the past 11 days of, these arguments being made. But still, really, it would take, I think, a lot for those senators, if they've already committed, and it seems they have, to not hearing from witnesses, to change their opinion.
Let me flip the question on you then, because we're talking about Republican senators voting in favor of calling witnesses. What about, and you're mentioning the polling, so what about those Democratic senators who are in either red districts, in the case of Doug Jones in Alabama, or in purple districts, and I'm thinking about Joe Manchin in West Virginia? Are they potentially going to vote to acquit the president when it does get to that place, so that the president can claim a bipartisan acquittal?
They may well do that. They very well may do that. The challenge somebody like a Manchin and a Doug Jones has, they were supporting witnesses. They wanted to hear from more witnesses. So what do you do if you're, say, Doug Jones, and the Senate votes against having witnesses, and then you, as ostensibly a vulnerable senator, have to take a vote on whether to acquit or to remove the president, right? Without having all the information that you deem necessary to make your final decision. And it really comes down to that question of, is what the president did, is that impeachable? Is that an impeachable offense? And, that's a little tricky for those Democrats. It really is. And add Kristen Sinema of Arizona to that mix as well. I mean, Arizona is sort of a wild card. It's the Wild West in a lot of respects, and in the Senate respect as well. The Senate race respect. I mean, Kristen Sinema votes almost more with the Republicans than she does with Democrats. So this is a tough issue for a number of senators right now.
So, Keir, let's actually ask something that's a very basic question. For those senators who are on the fence, can they abstain from any of these votes? Can they abstain on the question about whether or not to acquit the president? Can they abstain on the question of whether or not to call witnesses?
I suppose they can, but I sure hope they don't.
Actually, the way that you have to respond is guilty or not guilty.
Okay.
So there is no abstention.
From the Senate rules, you don't get the option of saying pass. You can say it maybe once or twice, but they come back to you, guilty or not guilty.
So, Catherine, what would that mean then? For the White House, if President Trump were to be acquitted, and not just acquitted, but acquitted with the votes from some Democratic senators?
Well, the president all along has really wanted impeachment to be, push back against impeachment to be bipartisan. After the House vote, when we had a little bit of crossover from Democrats and no crossover from Republicans, the president really was able to go out with this message of, hey, guess what? I had actually Democrats who voted to keep me, to not impeach me, and there were no Republicans who voted to impeach me. So he was able to claim that, yes, it was bipartisan, but it was bipartisan in my favor. So you can really expect that to be what his argument, or what his message, I should say, would be if there were any Democrats who were to cross over.
And is the White House now fully confident, Catherine, that they have the votes, that they are going to be able to just move this through to its predetermined course, that they're going to have acquittal, they're going to be able to shut down the call for witnesses, and all of this will be wrapped up by around Wednesday?
There is a lot of optimism, yes, or confidence, I should say, but it's also cautious. Sources are really not wanting to claim any sort of victory yet because, hey, it's still the Senate. Anything could happen, as Molly likes to say. So, of course, there could be a lot of procedural wrenches that are thrown into the mix here between now and over the next however long this takes. So the White House is very keen not to claim any sort of victory before everything is said and done. But yeah, at this point, just from a strategic standpoint, it is virtually impossible to see how there are enough votes to call witnesses, and certainly how there would be enough votes to convict the president.
Yeah, and I know from my time in covering the White House that sometimes they don't say exactly how they feel, but you definitely can tell it from the atmosphere when they're concerned about things, and it sounds like the mood there is much more optimistic. Is that right?
I would definitely say so. I would definitely say there is a lot more ease now that we know how Murkowski is going to vote and some of these other potential senators who might have voted for witnesses. So it is pretty sealed at this point. So there isn't quite as much tension as there was even last night or the day before.
Molly Hooper, Keir Dugle, and Catherine Watson, thank you all so much. Stand by. We're going to take another quick break. A reminder, you can keep up with the latest developments in the impeachment trial at any time by visiting our live blog. Just head to cbsnews.com/impeachment. We've got more coverage straight ahead. You're streaming CBSN.
You can watch CBSN 24/7.
We've got an amazing story to share with you.
Let's talk about the latest developments. There's so many levels to this.
We have a CBS News exclusive.
Fires in California. What happens next and how does it all play out?
We are on a mission with NASA.
I understand you have some breaking news. It's not over yet, is the bottom line.
This is a massive operation.
It's quite an adventure here at CBSN.
It's been a day.
You can see the desperation in the journey simply by looking at the trail that's left behind.
So she says she's 17. She looks kind of like she's 12.
Said to me, you know, if you tried to do this in New York City, take a picture of a man, he'd break your camera.
There's something very, very uncomfortable about this.
Today, a white supremacist lens.
This area can be the new Silicon Valley.
There was not a cot in the warehouse, not one cot in the warehouse.
We're so far deep at this point that there's no turning back. This is a long road ahead.
Our nation's capital. Decisions are made here that affect all of us. So join us every evening as we bring you CBS News original reporting from around the world while keeping our eye on what's going on right here in Washington.
Thanks for sticking with us. I want to bring back out our panel, Keir Dugle, Molly Hooper, and Catherine Watson. Molly, you and I have been looking at the Senate floor. Tell us what's happening inside the chamber right now.
Well, right now, the senators are kind of milling around because it's really unclear at this point how the Senate will proceed to essentially wrap up this trial once the Senate votes on the witness question, which we've all seen the reporting that the chamber will vote against having witnesses. The question is whether the Senate moves on directly to take up the question, or the two charges essentially, or do they have debate in between? Essentially, how long will this last? There are a number of senators who've been sitting on that floor for 11 days, and they want to have their say. They want to speak about it. Are they going to do that in public? Will they do that behind closed doors as they did during the Clinton impeachment? All those questions have yet to be resolved. And once they are resolved and put into a resolution, see, resolution, Mitch McConnell will offer that to the chamber. They'll all take a vote. But that resolution is up for amending. I mean, you can amend it. So that gives Democrats the opportunity to throw a bunch of, procedural wrenches, as Catherine just said. I like that, procedural wrenches, into the works here, and it could prolong this trial until some are saying Wednesday, possibly Thursday, or depending on what kind of appetite the Democrats have to keep this going, maybe not. It's just really in flux right now.
So what do we actually know about the status of discussions between McConnell and Schumer?
And I just kind of chuckle a little bit because they're not known for having the best of relationships. And in a position like Majority Leader of the Senate, Minority Leader of the Senate, where so much is dependent on unanimous consent agreements, getting the agreement from both sides of the aisle to move forward on any piece of legislation, really, that makes for some tricky situations, just as we're seeing here. Back in the Clinton impeachment, when Senator Trent Lott was the majority leader, a Republican from Mississippi, he was his cohort, I guess, the Democratic cohort, was Tom Daschle, a Democrat from South Dakota, and they had a very productive, respectable, respecting type of relationship, and they were able to work these things out behind the scenes. They actually talked to each other. McConnell and Schumer don't have that relationship, and it goes back a number of years, back to the financial bailout bill, and I can get into that later, but just suffice it to say that when Mitch McConnell's wife, Elaine Chao, was up for to become the transportation secretary, which she is now, Chuck Schumer voted no. And it was not a controversial vote, and that's something that Mitch McConnell has not forgotten, we shall say.
High drama.
Very.
Catherine, so it looks like this is going to be prolonged past the State of the Union, which is the president is scheduled to deliver on Tuesday. How much, if any, do you think that the impeachment trial will be a topic of conversation for President Trump?
Sure. Well, a senior administration official did hold a briefing off camera with reporters on this very topic earlier today, giving a little bit of a preview of what the president would be talking about, really a sense of optimism from his speech, from what they could say. But this official would not really go into detail about whether the president would bring up impeachment or in what way he might bring up impeachment. This was a question that reporters asked about multiple times and couldn't really get any sort of answer. Now, the State of the Union is obviously very scripted. It's something that where every line is gone through meticulously. And this is a president who doesn't like to stick to the script. He really has in past State of the Union speeches. So it will be interesting to see whether impeachment is addressed. Of course, the timing of this acquittal vote is really everything. Is the president able to claim victory, or is this trial still going to be ongoing? At which point, that absolutely has to be a point of frustration for the president, who wants to be able to claim victory at his very
very public
stately
forum,
address,
right,
very
right.
public forum with all of Congress and very high profile people there.
And as you mentioned that, I'm thinking about the president stepping for the first time since impeachment has begun in front of the chamber, seeing those House managers, seeing those Republican senators who were on the fence, and looking all of them in the eye for the first time. It's a reminder of the magnitude of what is happening right now. Keir, talk to us about the significance of this trial. When this is all said and done, if the president is acquitted, which is what all of the intelligence that we've received from Republicans and from the majority leader so far have told us, how will this go down in history books?
So aside from the result of the vote, whether he is removed or not, that's probably the next most important question. And so the thing that I want to sort of separate the defenses that have been offered for the president. And there's a group of defenses that are sort of very factually specific to this situation. Those, I think, can be distinguished for later impeachments because there'll be a different set of facts. It's the defenses that relate specifically to the scope of the impeachment clause that are, I think, the most important ones in terms of precedent and history. So Dershowitz's claim that the president, as long as he is seeking re-election and believes that that's in the public interest, provided he's not committing a bribery or she is not committing a bribery, can do whatever he or she wants. In my opinion, and in the opinion of most other people who have studied the Constitution, that is incorrect, it is flawed, it is wrong, and in my opinion, it's dangerous. Now, the good news is that a binary vote, and thank you, Molly, for telling us that it will be a binary vote.
Well, that is, unless the Senate suspends the rules and passes a change, but that requires a 2/3 vote.
Okay, well, it doesn't look like that's going to happen, perhaps.
Right.
But it is a binary vote, and so you don't know very much. We're going to the senators, and when they vote to acquit, they could vote to acquit on factual grounds, on these specific different, they didn't like the House manager's procedures. Okay, they don't think it was proven to the burden of proof that they believe should apply here. We're going to have a potential cornucopia of reasons that aren't necessarily going to mean that the Senate has adopted this very much of an outlier view of what the scope of the impeachment clause is. If I were to become White House counsel to a future administration and Donald Trump were to be acquitted in the next few days, I would not advise the president that they could repeat President Trump's conduct or anything like it and feel comfortable and safe that they had comported themselves with their oath of office and to avoid the impeachment clause.
So one of the things that I'm wondering about, because we've heard how many times on the Senate floor references back to the Clinton impeachment, to the very few previous precedents that exist. And we've also heard so much how this has been a partisan impeachment. Do we need to rethink the rules of impeachment? Does this make it too difficult to actually have a fair trial when we know that Republicans are going to vote in favor of a Republican president and Democrats are going to vote in favor of a Democratic president, and both sides are going to switch their opinions when somebody else is occupying the Oval?
So I hope that we don't continue or see that pattern, but I think the idea that an impeachment must be bipartisan is a little bit off track. The framers built a safety check into the Constitution that addresses that problem. It requires a supermajority in the Senate to convict. It requires, at this point, 67 senators. So look, let's say in the future that 75% of the Senate is Democratic, and they vote, 75 senators are Democrats. If they voted on a party line basis to remove a Republican or, say, a Democratic president, it would not be bipartisan, but it would sure represent a huge swath of our country.
But could they even get there anymore?
Well, but I think if you have that many senators that are going to vote against you, Nixon resigned. I mean, if you.
But I feel like we're not playing by the Nixon rules anymore, right? If the president does it, it isn't illegal.
No, but what I'm saying, if there's enough votes, if the writing's on the wall and there are enough votes in the House with Republicans and Democrats to convict you or to impeach you, and then over in the Senate to remove you from office, it's sort of Jonathan Turley's. If there is enough evidence and the boxes have all been ticked and you've gone through the courts and litigated the questions over documents and witnesses and tapes, and that has all taken place, and what comes out is so revealing and that would be worthy of impeachment, a president, it seems, would resign. I think that was an argument that Jonathan Turley made prior to appearing before the House Judiciary Committee on this issue, is that, ultimately, Congress needs to do such a thorough job that they have so much evidence that there's nothing really left for this individual in the White House to do but resign, because there is so much evidence that both parties are convinced that they would remove him from office.
I know, but if we've become so partisan, quick roundtable, does it seem like any president in the future, no matter basically how egregious their behavior, can be impeached. And I also asked from the Republican perspective, are presidents going to continue to just get to be drawn through this impeachment process because it is overly political now? Molly?
I think you have to wait to see what happens in the congressional elections.
Keir?
Look, I think that this is a moment of truth for when you have this type of a question. And that the senators ought to be concerned with the truth, ought to be concerned with the facts, ought not to be concerned with party. It is a concern that impeachment will become weaponized. It is a concern. The House manager's obligation is, it's not about, I believe, it's not about a bipartisan impeachment. It's about an impeachment that is strong, evidence that is strong enough to convince a supermajority. However that's made up, that's their burden. If they don't make it here, well, they don't make it here, and that'll be a chilling effect for future houses.
We are watching history in the making, ladies and gentlemen. Molly Hooper, Keir Dugal, and Catherine Watson, thank you all so much. Stand by. We're still awaiting a vote on additional witnesses in the Senate impeachment trial. For now, a quick break. You're streaming CBSN.
You can watch CBSN 24/7.
We've got an amazing story to share with you.
Let's talk about the latest developments.
There's so many levels to this.
We have a CBS News exclusive.
Fires in California. What happens next, and how does it all play out?
We are on a mission with NASA.
I understand you have some breaking news. It's not over yet, is the bottom line.
This is a massive operation.
It's quite an adventure here at CBSN.
It's been a day.
You can see the desperation in the journey simply by looking at the trail that's left behind.
So she says she's 17. She looks kind of like she's 12.
Said to me, if you tried to do this in New York City, take a picture of a man, he'd break your camera.
There's something very, very uncomfortable about this.
Today, a white supremacist lens.
This area can be the new Silicon Valley.
There was not a cot in the warehouse, not one cot in the warehouse.
We're so far deep at this point that there's no turning back. This is a long road ahead.
Our nation's capital. Decisions are made here that affect all of us. So join us every evening as we bring you CBS News original reporting from around the world while keeping our eye on what's going on right here in Washington.
We are still awaiting a vote on additional witnesses in the Senate impeachment trial. Grace Seegers is a political reporter for CBS News Digital. She's on the phone with us, and she's also right outside of the Senate chamber. Grace, you have had such interesting insight into all of the things happening. Right now, we're seeing a huddle of Republican senators as we await a vote. Do you know what they're discussing?
Well, really, it's anyone's guess. I think that even they don't really know what is going to happen next. So Mitch McConnell called a quorum call, which is pretty much an active break, a way for senators to stay and chat and make plans about next steps without taking a recess. But it's very clear that negotiations for what happens next are still ongoing, and we don't know if this could end tonight or if it could go into next week.
And I have been watching your detailed notes about the things that we're seeing just off screen, and I want to ask you about some of that. You've noticed some note passing that's been happening there in the Senate chamber?
Yes, it's kind of funny, all of these senators acting like students in high school where they'll pass notes to each other or they'll chat with each other. It's very kind of social in a way, even though you'd think these are such state serious proceedings, these senators are still also being social and friendly with each other.
It's interesting because when you've made that analogy to students in a big lecture hall in the past, and you said that today there's kind of been a little bit of a mood change there.
Yes, I would say that senators were pretty bored today, as if they're really over everything that's happening. They've heard these arguments before from Adam Schiff and from the president's lawyers, and they're ready to move on. So it seemed to me as if, unlike previous days where there was some real engagement with what the managers and the president's lawyers were saying, really, I would say that a bunch of senators were probably spacing out.
They're just done. They're ready for summer vacation.
They really are.
And you said, in particular, it almost seems like House Manager Adam Schiff. I can't help but think of Don Quixote when I'm reading your notes, that he is still trying so hard to command the attention of the room, but it's not there anymore.
That's exactly right. He's still making the same kind of passionate speeches that he's been making from the beginning. And he's very eloquent, very good at speaking off the cuff, and he does have a lot of passion when he speaks. So,
thank you so much, Grace. We're going to continue listening to your wonderful notes, but I want to go back to the Senate floor. We see that they are now reconvening. Everybody starting to get into their positions, and we hear Chief Justice Roberts and Mitch McConnell, so we'll go there right now.
And it leads to the following. We'll now cast a vote on the witness question, and once that vote is complete, I would ask that the Senate stand in recess, subject to call of the chair.
Thank you. Without objection, so ordered. The question is, shall it be in order to consider and debate under the impeachment rules any motion to subpoena witnesses or documents? The yeas and nays are required under Senate Resolution 483. The clerk will call the roll.
Mr. Alexander? No. Ms. Baldwin? Aye. Mr. Barrasso? No. Mr. Bennett? Aye. Mrs. Blackburn? No. Mr. Blumenthal? Mr. Blunt? No. Mr. Booker? Aye. Mr. Bozeman? No. Mr. Braun? No. Mr. Brown? Aye. Mr. Burr? No. Ms. Cantwell? Aye. Mrs. Capito? No. Mr. Cardin? Aye. Mr. Carper? Aye. Mr. Casey? Aye. Mr. Cassidy? No. Ms. Collins? Aye. Mr. Coons? Aye. Mr. Cornyn? No. Ms. Cortez Masto? Aye. Mr. Cotton? No. Mr. Kramer? No. Mr. Crapo? No. Mr. Cruz? No. Mr. Daines? No. Ms. Duckworth? Aye. Mr. Durbin? Aye. Mr. Enzi? No. Ms. Ernst? Mrs. Feinstein? Aye. Ms. Ernst, no. Mrs. Fisher? No. Mr. Gardner? No. Mrs. Gillibrand? Aye. Mr. Graham? No. Mr. Grassley? No. Ms. Harris? Aye. Ms. Hassan? Aye. Mr. Hawley? No. Mr. Heinrich? Aye. Ms. Hirono? Aye. Mr. Hoeven? No. Mrs. Hyde-Smith? No. Mr. Inhofe? No. Mr. Johnson? No. Mr. Jones? Aye. Mr. Kane? Aye. Mr. Kennedy? No. Mr. King? Aye. Ms. Klobuchar? Aye. Mr. Langford? No. Mr. Leahy? Aye. Mr. Lee?
No.
No. Mrs. Loeffler? No. Mr. Manchin? Aye. Mr. Markey? Aye. Mr. McConnell? No. Ms. McSally? No. Mr. Menendez? Aye. Mr. Merkley? Aye. Mr. Moran? No. Ms. Murkowski? No. Mr. Murphy? Aye. Mrs. Murray? Aye. Mr. Paul? No. Mr. Perdue? No. Mr. Peters? Aye. Mr. Portman? No. Mr. Reed? Aye. Mr. Risch? No. Mr. Roberts? No. Mr. Romney? Aye. Ms. Rosen? Aye. Mr. Rounds? No. Mr. Rubio? No. Mr. Sanders? Aye. Mr. Sass? No. Mr. Schatz? Aye. Mr. Schumer? Aye. Mr. Scott of Florida? No. Mr. Scott of South Carolina? No. Mrs. Shaheen? Aye. Mr. Shelby? No. Ms. Sinema? Aye. Ms. Smith? Aye. Ms. Stabenow? Aye. Mr. Sullivan? No. Mr. Tester? Aye. Mr. Thune? No. Mr. Tillis? No. Mr. Toomey? No. Mr. Udall? Aye. Mr. Van Hollen? Aye. Mr. Warner? Aye. Ms. Warren? Aye. Mr. Whitehouse? Aye. Mr. Wicker? No. Mr. Wyden? Aye. Mr. Young? No. Mr. Blumenthal? Aye.
Are there any senators in the chamber wishing to change his or her vote? If not, the yeas are 49. The nays are 51. The motion is not agreed to. Under the previous order, the Senate stands in recess, subject to the call of the chair.
Hello, everyone. I'm Lana Zak in New York. The Senate has just taken their historic vote, striking down the call for witnesses in the impeachment trial of President Trump. This means that the testimony of former National Security Advisor John Bolton will not be heard under oath in the Senate. This comes after the House managers and the president's legal team spent the day arguing this very question. Up next, there will be a vote on the articles of impeachment unless Democrats introduce motions and amendments. I want to bring back our panel, Keir Dugal, Molly Hooper, and Catherine Watson on the heel of this very important vote. Molly, where do we go from here?
Well, here's the thing. So we just had this vote, and ultimately they'll vote on whether to acquit or remove. But how you get from this point to that point is a whole different matter, because what happened when the Republicans approved their rules of the road package 11 days ago, they did not account for what happens after the witness question. And so that's why we're having an extended break off camera, because Mitch McConnell is basically rallying his troops to find out what the Republicans will accept. The challenge is part of the Republican conference wants this thing to be done. They want to move right to an acquittal or a removal vote. That's it. But other Republicans don't. They want to talk. And here, well,
and speaking of talking, here is Minority Leader Chuck Schumer. We see him just having left the Senate chambers on the heels of that historic vote. He's now in the Senate subway, standing in front of the microphone. So we expect that he's going to be speaking to reporters in just a second. It's interesting, as we saw, the entire Democratic caucus voted for witnesses, but we did hear from at least two Republicans, Senator Mitt Romney and Senator Susan Collins, that they broke with the Republican rank and file and voted in favor of witnesses. Let's hear from Chuck Schumer right now.
Okay. To not allow a witness, a document, no witnesses, no documents in an impeachment trial is a perfidy. It's a grand tragedy, one of the worst tragedies that the Senate has ever overcome. America will remember this day, unfortunately, where the Senate did not live up to its responsibilities, where the Senate turned away from truth and went along with a sham trial. If the president is acquitted with no witnesses, no documents, the acquittal will have no value, because Americans will know that this trial was not a real trial. It had no witnesses, no documents. It is a tragedy on a very large scale. I will be now going up to my caucus to discuss what we're doing next. I will not talk about it here. Okay? Thanks.
Very brief but impassioned comments from the minority leader. He called it a grand tragedy, the vote against witnesses in the Senate. He also said that the Senate turned away from the truth and went along with a sham trial. I want to bring in our White House reporter, Catherine. The acquittal, he said, has no value when that happens, but the White House doesn't see it that way.
They don't, although this is an argument that Schumer and other Democrats are obviously using to attempt to kind of stick it to Trump, if I can use that phrase, or something similar. The president so wants to be vindicated that this message that he might not really be vindicated if it isn't a real trial in the way that Democrats see it is a tactic that Democrats are trying to use to show that, hey, you know, it's not a valid trial if you don't have witnesses and documents. We're waiting to see what the president's response is to this really historic vote.
Full exoneration, full acquittal. We're continuing to hear from Republican and Democratic senators as they have left. Most of them, it seems like, not speaking a lot to reporters. There is certainly a lot of huddling that's going to happen. We heard that from Schumer. They now need to figure out what is happening next. And so my apologies in advance to my panel if I have to cut you off. But if we hear something important, we're going to obviously go to that. Molly, let me throw that question to you.
Well, and actually, the question for Chuck Schumer is essentially which amendments he will try to offer to whatever resolution Mitch McConnell is going to submit to the chamber later this evening, that will establish how the Senate gets from here to there. Because as I said, there are some members of the Republican conference that want this thing done now. They want to vote to move on to votes. They don't want to talk about it. Just let's move forward, get this thing done with.
It's interesting. We see Senator Elizabeth Warren there, it looks like speaking with an aide, not stopping to speak with reporters. And certainly for a lot of the senators who are running for president, this is a platform for them to address the nation, as we know that so many are tuning in right now. Is this the order from their leader, from Chuck Schumer, to just get over there and start hashing this out and not really talking to reporters?
Well, right now, like I said, the Democrats are trying to figure out which amendments they're going to offer to the Rules of the Road Part 2 package that Mitch McConnell will offer tonight. Mitch McConnell's problem is how long do Republicans in his conference want to talk? Because there are a number of Republicans who want to speak their piece on the Senate floor to explain why they will vote against removing this president for these charges that the House managers brought to the Senate. And also, they also need to figure out how much time to allot to the White House counsel and the House managers to make closing arguments, because we haven't heard the closing case yet. And really, it's up to Republicans who do control a majority of the chamber to decide on those items and how they will respond to whatever the Democrats try to put up and block this evening to draw it all out. And so there's a number of questions that Mitch McConnell needs to work out that he hadn't necessarily been thinking of up until about like this morning, because he was busy making sure he had enough Republicans to vote against calling witnesses.
So despite the Constitution and despite Senate rules, we're still in somewhat uncharted territories when it comes to what happens next.
Well, a little bit, because if you're the White House, you want this thing done and over with. The president's having a big interview with Sean Hannity, and during the Super Bowl on Sunday, he has the State of the Union address, and he wanted to come up to Capitol Hill and say, "Hey, I'm fully exonerated. This whole thing was partisan." The challenge, though, is what does he say if the Senate is still debating and deliberating? And they haven't taken their final votes of guilty or not guilty yet. When President Clinton was in office, he actually did end up giving the State of the Union while he was under impeachment.
So we're hearing from Senator Ron Wyden. I want to go there now.
Every opportunity to make sure that the relevant witnesses and the relevant facts get out. I will tell you that is going to happen regardless of what position I take, and I think it will happen sooner rather than later. At the rate in which we're going, practically every single day, there is another development. It is not a small development, it's a major development. So I'm not going to stand before you and say my position on urging people to do X, Y, and Z is most relevant. I think at the rate we're going to see significant development. Some people say, well, there'll be books and the like months and years from now. I think it's going to continue to be something we see every day. Okay? Got to get into that.
All right. So we are hearing from some Democrats. It looks like the senator from Connecticut, Senator Richard Blumenthal, is going to speak now.
A final vote, but there is no vindication here for anyone. And frankly, as I sat there on the floor voting, I thought about all the reasons I wanted to be a senator, all the respect I had for this institution, all the high images and expectations I had, and I was so bitterly disappointed in my colleagues for voting uniformly in a partisan way and putting party above country.
Do you share the concern that some of your colleagues have said that the president will look at what happened here today and think, well, I can just keep doing this?
The guardrails are potentially gone, in Donald Trump's mind at least, which means we have to renew our commitment to those checks and balances that are the reason that we did this impeachment in the first place. The whole reason for the impeachment of Donald Trump was because he has contempt for the rule of law. He impounded funds, he obstructed justice, he stonewalled Congress, and he committed corrupt abuse of power. And that was shown.
Is it your expectation that Republicans will try to get the acquittal vote done tonight as soon as possible, to just try to get it out of the way?
I know that some of my colleagues want to rush it, want to just do it, get it done. The most historic act that most of us will ever take as a member of the United States Senate, they want to do in the middle of the night. And that is really disgraceful and shameful. As I sat on the floor of the Senate to cast my vote, I thought how absolutely disgraceful it is for the free press doing the investigative work that the United States Senate is too cowardly to do in uncovering the wrongdoing that will continue to come out. Thank goodness for the free press and our independent judiciary. They're going to be the heroes of this era because the truth will keep coming, and my colleagues will be honored by it.
Can you talk about what exactly is being negotiated right now? What's your understanding of the state of play? What do Democrats want? What are Republicans, not giving you at this point?
We want an opportunity for full, fair, open, I stress open debate. I have a motion to open the deliberations, which otherwise would be secret, along with my colleagues Durbin and Brown. And the American people have a right to see what we say, not just how we vote.
How many Republicans do you have on that with you, do you think?
We have no Republicans with us.
Do you think you're going to be able to get that through or agree to?
See, after declining to hear evidence, barring witnesses and documents, I don't know how my Republican colleagues can shutter the debate and, in effect, determine the future of the president behind closed doors. Makes no sense.
Thank you, Senator.
Thank you.
We just heard from Senator Richard Blumenthal. He says that he has offered up a motion to open the deliberations, like we have heard from other Democratic senators. He said he expressed a disappointment in the process. He said that all the reasons why he wanted to be a senator, all the expectations that he had, all of those hopes he had in what it meant to be in that chamber, that all of that was really impacted by the vote today. He also said, in regards to President Trump's actions in the future, quote, the guardrails are potentially gone. Catherine, I want to bring you into this conversation now. Have we heard anything from the White House? We have heard certainly from Senator Mitch McConnell. He's saying that never in Senate history has this body paused an impeachment trial to pursue additional witnesses with unresolved questions of executive privilege that would require protracted litigation. Senators will now confer among ourselves with the House managers and with the President's counsel to determine next steps as we prepare to conclude the trial in the coming days. Catherine, we know that the Senate Majority Leader, Mitch McConnell, has been working in lockstep with the White House counsel's office. What are we hearing from them today?
Sure. Well, I just wanted to point out that phrase "in the coming days" from the Senate Majority Leader, indicating that he isn't ready to wrap this up immediately, or at least thinks that it can't be wrapped up immediately. I was just checking my phone a couple of minutes ago to see if we have any statements from the White House. I don't have anything official yet, but we do know that there have been individuals, of course, from the White House, both the White House counsel's office, the president's legal team, individuals within the White House.
Sorry, it sounds like Senator Lindsey Graham. Oh, he's just left. Sorry to interrupt you. Obviously, for all of our viewers, this is a very fluid situation. The vote had just taken place. The Senate has voted, as we expected, largely along party lines, with a very few, with at least two Republicans voting in favor of witnesses. Catherine Watson, Molly Hooper, Keir Dougal, thank you all so much. Stand by. We're going to take a short break. The Senate is on recess after blocking that motion to allow witnesses in the impeachment trial of President Donald Trump. We'll have a lot more ahead. For now, you're streaming CBSN.
You can watch CBSN 24/7.
We've got an amazing story to share with you.
Let's talk about the latest developments.
There's so many levels to this.
we have a CBS News exclusive.
Fires in California. What happens next and how does it all play out?
We are on a mission with NASA.
I understand you have some breaking news.
It's not over yet, is the bottom line.
This is a massive operation.
It's quite an adventure here at CBSN.
It's been a day.
You can see the desperation in the journey simply by looking at the trail that's left behind.
So she says she's 17. She looks kind of like she's 12.
Said to me, you know, if you tried to do this in New York City, take a picture of a man, he'd break your camera.
There's something very, very uncomfortable about this.
Today, a white supremacist lens.
This area can be the new Silicon Valley.
There was not a cot in the warehouse, not one cot in the warehouse.
We're so far deep at this point that there's no turning back. This is a long road ahead.
Our nation's capital, decisions are made here that affect all of us. And today, more than ever, people want truth, understanding, and accountability. So join us every evening as we bring you CBS News original reporting from around the world, while keeping our eye on what's going on right here in Washington.
The CBS Evening News with Norah O'Donnell, now from Washington, D.C. Understanding the world begins with the right questions.
Do you trust Kim Jong-un?
Doesn't the blame reside with Jewel?
Is it now our top terrorist threat?
With the right people.
So you have forgiven.
I have now.
Right here.
Check this out.
More news.
I'm Tony DeCoppel with CBS News.
More original reporting.
It puts everything in perspective.
We are on a mission with NASA.
Every morning on CBS This Morning.
We're going to begin with breaking news.
Wow. That's not normal.
The biggest names in politics.
Whoa, that's news. Are we at a tipping point?
Face the questions you want answered.
Margo, that's a great question.
Good question. Face the Nation with Margaret Brennan.
Hello, everyone. I'm Lana Zak in New York. You are looking at the Capitol, where the Senate has just voted to strike down the call for witnesses in the impeachment trial of President Trump. This means that the testimony of former National Security Advisor John Bolton and others will not be heard under oath. This comes after the House managers and the president's legal team spent the day arguing the case for and against witnesses. Up next in the process, there will be a vote on the articles of impeachment unless Democrats introduce motions and amendments. So now I want to bring back our panel to discuss whether or not that's going to happen and what it could look like. Keir Dugal, Molly Hooper, and Catherine Watson. So Molly, let's start with you. Tell our viewers very succinctly, where do we go from here?
We have to figure out a way to end this, is basically what Mitch McConnell is discussing with Republicans. They need to figure out how much time the White House counsel and the House managers will get to make closing arguments. They have to figure out whether or not to allow senators to speak on the Senate floor in public about how they're going to vote, because typically and under Senate rules, these deliberations on impeachment-related matters happen behind closed doors. And Richard Blumenthal, a Democrat, was just alluding to this earlier this evening. He's going to offer a motion that the Senate will vote on, essentially to open up the chamber, the public, to see what the Democrats and Republicans say about the vote leading up to whether they will acquit or remove.
So what does that really mean? Because we hear motion to open deliberations, we hear all of these things, but for folks who are following this and maybe aren't as much of a political junkie as you are, Molly, tell us what the real implications are of opening up those deliberations.
Well,
does it just
the
mean
whole
more
world gets
boring,
to see
like
it. No, because
procedure, or does it mean some substance?
It's deliberations. It means that the senators who've been sitting on that floor for the last 11 days not saying anything for fear of being imprisoned get to actually say their piece, speak their piece, and explain why they are going to either vote guilty or not guilty when it comes to the two articles that they will be considering for that final vote. And otherwise, what happened, I mean, again, in the Clinton, we go back to the Clinton impeachment trial, what happened at that point, when the Senate got to the point where they were actually going to move on to the question of whether to acquit or remove, the Senate chambers close all the doors, kick everybody out, even most of the staffers, and it's just the senators who speak amongst themselves, and nobody knows what's going on. And that process back in 1999 lasted 3 days because there are 100 senators, and typically they would get 15 minutes apiece to speak on each article. And so that's really what Mitch McConnell is wrangling with right now, because essentially Republicans have control of how this, of the schedule is for the next 2 days. But there are some Republicans who do want their chance to speak on the Senate floor. And, Mitch McConnell has to figure out a sort of a scheduling package that works for all 51 for at least 51 of his membership and will withstand the Democratic amendments that Chuck Schumer, Richard Blumenthal, and a lot of other Democratic senators plan to introduce when Mitch McConnell offers this scheduling package to the Senate to debate.
And when you said the senators were imprisoned, you mean, I assume, by the Senate rules where
that's right.
Where they were writing down their questions and submitting it to Chief Justice John Roberts to read.
There's that,
to avoid some of the showboating, but we know some of that still took place.
Exactly. Well, no, but every day, hear ye, the Sergeant at Arms comes out and says, all these senators, you must be silent on pain of imprisonment if you speak up, which is why we have not heard any of these senators speak, with the exception of Mitch McConnell and Chuck Schumer. They're the only two senators who are allowed to speak. But McConnell and Schumer had an agreement from all 100 senators that when the senators were submitting their questions, at least on the Republican and Democratic side, eventually, the senator could stand up and say, Mr. Chief Justice, I have a question for whichever counsel.
And you're looking at the view in the hallway there, right outside. It looks like that's right outside of the Senate chambers, right? When we do know that that Senator Schumer, I believe, is inside the door on screen left there, huddling with his leadership as they're trying to figure out the way forward. Presumably, Republicans are doing the same thing now. As we heard from Majority Leader Mitch McConnell, he said that they're now going to confer among themselves to try and pursue the path forward to conclude the trial in the coming days. I'm wondering about Senator Romney and Senator Collins, both Republicans who voted in favor of hearing from witnesses. How are they facing their Republican colleagues now?
Well, that was kind of expected, and I think at this point, with you get a pass when you're a senator up for re-election in a very purple state like Susan Collins, and you took a very tough vote last year to approve Brett Kavanaugh's nomination to be a Supreme Court justice. And
so behind closed doors, this was all fine.
Exactly.
As long as they got the desired results.
Exactly. What they're really wrangling with in that statement, Senator McConnell makes the point of saying that we're back there with the White House counsel as well, because the White House wants this thing done. They want that if they had their preference, the Senate would work all night, get through all the Democratic amendments, and essentially done. We're going right to the vote, no deliberating, because the president doesn't want to go into his State of the Union having impeachment still hanging over his head. He'd like to be exonerated. He also has an interview planned for the Super Bowl Sunday with Sean Hannity. And you can't really say that you're acquitted or exonerated until that vote has actually taken place, even though you know that the outcome is pretty certain.
So, Keir, you're our legal expert on this. Now they are trying to figure out the fair rules for moving forward. The possibility has now been raised that by Senator Blumenthal that they will make these deliberations public. What does that do in terms of transparency and the law?
So the key word in your question was fair. And it's interesting to note that we just saw Senator Schumer say that this was a perfidy, which that's something that's bad, claiming that it is grossly unfair. We have a statement from Senator Murkowski, a Republican, saying that the Congress has failed and that the trial has not been fair. As a courtroom lawyer, there are years, decades and decades of precedents and procedures and statutes that are designed to ensure a fair trial. And over many, many thousands and thousands of trials over the decades, there is largely a consensus about what that process ought to look like, so that at the end of the day, both sides, the prosecutors, defendants, believe that they had a fair shake, they had an opportunity to explore the truth, cross-examine the truth, defend themselves, put on evidence to vindicate violations of law, or in this case, the Constitution. And I think the large concern at the end of this, now perhaps the second impeachment trial in the modern era, the third impeachment trial in the history of our country, we don't have all the kinks worked out. So that's I think the larger point here. And Molly, you're just describing this process of senators being able to explain themselves. I think both in terms of history and what kind of precedent, if any, this event that we've seen will come from that process of senators explaining themselves. And we'll, just one last point, see whether or not there are additional Republican senators who will say that the president's conduct was not perfect.
And on that, when we're talking about the law and we're talking about our standards for looking at a fair trial, one of the things that we have heard so much from the president's counsel is that the presumption of innocence is something that's sacrosanct here in this country. So heading now into what looks to be an acquittal vote at some point in the coming days, should senators, based off of a sense of American law and justice, given that there wasn't the witnesses that they wanted to hear from, should those senators who are on the fence now vote to acquit?
So this is a very difficult question, because what we're looking at in an impeachment trial is not a criminal trial. And in fact, the framers were very careful to remove imprisonment, the things that typically go along with the punishment for a crime. They took all of that out of the Constitution. We are talking only about whether or not the president can hold his office and be disqualified from future offices. These are privileges that you earn by hard work and by winning an election, but they are not things like life and liberty. So the presumption of innocence in a criminal trial is one of the bulwarks of our Constitution to require that prosecutors prove their case and carry the complete burden of truth. So, and burden of proof, excuse me. Here, we've got this hybrid process. It isn't really criminal. So,
And it's not criminal. Specifically, it is not criminal.
Specifically not criminal, although we talk about it in terms of guilty. I think the better term is proven, unproven. We talk about
impeachable or not impeachable.
Correct.
Because if you look at the Republicans, like Lamar Alexander, maybe it's proven, but he doesn't think it's impeachable.
So whether this presumption is something that is required here in a non-criminal proceeding, I think it's probably better to say that the House has the burden to satisfy a supermajority of senators that the president's conduct warrants removal and disqualification. And that, I think, is the way that you ensure that the burden be carried by the House managers.
And it requires such a large majority, because you're right. You're not depriving this individual of his freedom, of his liberty, but what you ostensibly are doing is removing the franchise from the individuals who voted to elect this person to be the president of the United States. states, which is why, we would see the White House counsel argue that it's so, that not only would the Senate be removing this president, they would also, undoing an election, they would also be disqualifying and removing his name from the ballot in 2020 and disqualifying him from holding that office to which he was elected. And that's a big deal, because that's denying all those individuals who voted for him their vote. And that's taking something away from a lot of people, which is why there is such a high standard. But what's interesting is that even if that individual was impeached and removed, still could be subject to criminal charges afterwards.
Right. And it's interesting. We've heard this argument over and again by the President's counsel that it's taking away those votes, taking away that franchise. But we need to step back. As a country, for close to 240 years, we've all agreed to be bound by the Constitution. And the reason why we have a 4-year election, why we have these interim elections to replace our president, is because of the Constitution. And so, in addition to that 4-year election cycle, of course, we have the impeachment process.
Right.
So while we do agree that presidents and that our citizens should have a vote every 4 years, we have also agreed since the founding of the Republic that a president who commits misconduct in the middle of their term is subject to removal upon that 2/3 vote from the Senate. So the question is, what are you taking away, right? Are you taking away this foundational agreement that we've had for over 240 years, that our Constitution supplies an impeachment provision, or are you taking away these interim votes?
Right.
And we're starting to hear more from senators, their reaction to this. Senator Bernie Sanders, obviously running for president, tweeting out, "Today is a sad day for democracy," where we're hearing from, and which echoes much of what we've been hearing from the Democratic senators, a sense of sadness, questions about the impartiality of the Senate and of the future of democracy. And then from Republicans, we're hearing that this was a foregone conclusion, that there wasn't enough evidence there, and it's just time to move on. We hear from Senator Thune. He said, "We're still trying to figure out how to land the plane." And actually, Senator Rounds used a very similar analogy, saying it's just a matter of agreeing how we land the plane. So for them, they're ready to move on. I want to bring Catherine into this discussion. She's right there and has been following the White House. How are they reacting to this, even though they knew that this was likely going to be the outcome? Are they relieved?
To point out that the president has tweeted in the last few minutes. It was a very short tweet. He said, Democrats 17 witnesses, Republicans 0, referencing proceedings in the House, which isn't quite accurate because Republicans did have several witnesses. I think it was 3, although I would have to double check that number. Of course, the president still has expressed very recently that he does want witnesses if he had his druthers, even though he would like this trial to be wrapped up quickly. He still, in recent days, has said he wants to hear from Hunter Biden. He wants to maybe even hear from the whistleblower, but Hunter Biden has certainly been a name that has been on the president's lips. He is still frustrated that he can't get exactly what he wants in that regard. So we'll see what else the White House has to say. I've been texting sources. We have nothing official from the White House yet.
We are hearing from Senator Coons, a Democrat of Delaware, in terms of the timing, which is now the big question, though a lot of senators are still post-gaming the vote that we just heard that would eliminate the call for witnesses. Senator Coons says that there are lots of factions with different views about whether we should try to end tonight or tomorrow or Wednesday. Molly, you're used to seeing the Capitol much emptier on a Friday night. Usually by Friday afternoon, all those senators are on their way out of town. Senator Amy Klobuchar was asked about whether she's going to Iowa, and her response was eventually. For Democrats,
they should have asked, are you going eventually before or after the Iowa caucus?
Well, for Democrats, might some of them, particularly those running for president, be interested in aligning themselves with the White House now and go ahead and make it a speedy exit?
Well, that'd be interesting, strange bedfellows, but there have been instances like that before. I never thought I would hear Democrats, calling to hear from John Bolton. I mean, those are strange bedfellows. But right now, it's not just Democrats who want this to keep going. I mean, there are Republicans, Senate Republicans, who want to make their case. They want to speak on the floor. Even some want to do it behind closed doors. And
so what you're saying is they don't want this to go to bed for their constituents to hear either a guilty or not guilty vote without them being able to go on the record saying, I may be voting to acquit the president, but I still have some problems with what he did.
Well, and they want to deliberate like that. The world's best deliberative body they haven't deliberated anything. They've been sitting on the Senate floor and have not spoken. They wrote questions. One or two of them.
Passed notes, as we know from Grace.
About 100 of them were able to get up and say, Mr. Presiding Officer, I have a question for the desk. Or I have Mr. Leader, I have a question for the presiding officer. And that's it. And they want to deliberate. They want to have their say, and explain why they will support or vote against acquitting this president. And so there's that. And you also have some Democrats who want the exact same thing. But again, it's unclear. What is clear, though, if the Senate does abide by the rules package adopted, the rules package part 1, 11 days ago, essentially, we could see the Senate in session tomorrow, but most likely they would be off on Sunday and come back Monday. So those candidates could at least make a small trip or a short jaunt to Iowa for the day.
We do know that Senator Klobuchar made that very quick overnight trip to have a rally there in Washington. If you're just joining us, I want to bring you up to date. The Senate has voted against allowing witnesses. There was a question over the last 2 days, particularly after that bombshell report that the former National Security Advisor John Bolton had perhaps more information that he said he was willing to share with the Senate. Information leaked in a manuscript for an upcoming book that seems to contradict what the president and his counsel have said. It did seem for a while, right after we learned of that the Senate might in fact vote in favor of having witnesses, but they have just taken the vote. Despite 2 Republicans voting in favor of it, the motion has failed. And now Republicans and Democrats are huddling right there in the Capitol on a cold night in Washington, D.C., trying to figure out the way forward. Keir, lead impeachment manager Adam Schiff argued on Friday that there can't be a trial without witnesses. Is that true, or is this just, as you said before, this isn't a criminal trial? This is something else entirely?
Well, yeah, it's not a criminal trial, so things might be a little bit different. But let's just get back to basics. You are the House manager, and it's your job to prove up the articles of impeachment because you believe that there's been misconduct. You have the burden to convince 2/3 of the Senate by a standard which is probably something like clear and convincing or maybe proof beyond a reasonable doubt, but it's a high standard. And if you have facts that are being disputed by the president, how else do you prove your case? I mean, as a lawyer who's tried cases, if I had those burdens and I could not put my evidence on, I don't know what you would call it. I certainly not any trial that I could recognize as a trial. The Constitution calls for the Senate to have the sole power to try an impeachment and uses that specific term. There are other contextual clues from the Constitution that indicate that what the framers intended was what we would all think of as a trial. Where there are disputed facts, the prosecution here, I know we're saying it's not a criminal trial, but the House managers are effectively acting in an analogy to that. In any courtroom in America that was a law courtroom, you would expect that there would be an ability to put on documents, put on witnesses on both sides. The prosecutor might call only 3 witnesses. The defense might call 15, or vice versa. It would be subject to cross-examination. This does not look like it doesn't look like a trial to me, in my opinion.
Well, it is interesting that, as you've made that distinction, that it's not, that in some ways it is a trial, in some ways it isn't. It's another beast entirely. It is interesting how so much of this is uncharted. That as you said, Molly, that they haven't figured this out and haven't even been thinking about it until this point.
Well, the challenge is Law and Order. I got to admit, I like Law and Order. I love Perry Mason and Matlock. Don't get me started. But this is uncharted, and it's a political trial essentially, and the rules for politics are just different. And when it comes to the Senate, as I keep saying, even though there's rules, there's really not any rules, because if you can get 100 senators to agree to forget about the rules, you can do anything you pretty much want, which is difficult these days. But the point is that the Senate is kind of moving to its own rhythm, and they're accountable to a different. They need to hear from their constituents to find out if those individuals were convinced that the House managers had, a strong case. And so essentially, the real jurors in this whole process have been the American people watching and calling into their senator's offices. And I know from experience on Capitol Hill, when there have been, moments of landmark legislation that have come up on the Hill, Senator, especially vulnerable or moderate Republicans, Democrats, depending on which party's in the majority, they would get flooded with calls that really influence how their member or their senator will vote. In this case, I've heard, there have been some calls coming up on the Hill, but it hasn't been with the same intensity, perhaps as with Obamacare, when Obamacare was happening, or when cap and trade was happening. So really, it's a matter of convincing the people who are going to go out and vote for these individuals what to think.
And I want to update our viewers on what is happening right there in the Senate tonight. We have just heard from Senator Braun, Republican of Indiana. He gave a readout of the GOP conference, which has just broken up. He says that they will finish tonight around 8:30 or 9 p.m. after another organizing resolution with 3 or 4 more amendments. They would then return on Monday at 11 a.m. for floor speeches, which Molly has been talking about. And he says that according to the GOP conference, the final vote would be on Wednesday. We're also hearing that the Democratic conference meeting is breaking up right now as well. Senator Coons from Delaware says that they are heading to the cloakroom for dinner, and that the minority leader, Senator Chuck Schumer, Democrat from New York, says we'll see when asked what will happen next. So, Molly, what about the Republicans that did vote in favor of calling for more witnesses?
What about them? I mean, they did it.
They did it, but now you predict that they will vote in favor of acquitting the president, since, as you say, they can't abstain in this vote.
They can't abstain in this vote. And actually, that is a good question. What will these individuals do?
Right. They wanted to have witnesses. They wanted to hear more information. Right. They were shut down by members of their party who decided to instead move forward without those witness testimonies. Knowing them so well, knowing Senator Romney, knowing Senator Collins, how do you think they'll vote?
Well, again, because I have covered Collins for a long time, I got to be honest with you, I'm not sure. She's in a really tough position back home. She's taken some very tough votes on behalf of this president, and she's taken hits in Maine, and she's up for re-election, and she wants to hold on to her seat. So it's unclear. At this point, Senator Romney, again, another matter. The question is,
but he's helped, even though Utah is conservative and Republican, he's helped by the fact that his constituents don't necessarily see themselves as supporters of President Trump.
Well, that's true. The other question is whether he thinks what the president did was impeachable, and that's this argument that we keep coming back to, that the White House is sort of making behind the scenes. Okay, even if all this stuff happened, is it impeachable? And we saw last night Lamar Alexander come out and say inappropriate, not right. but it's not impeachable. And so really that will be the question. It's interesting when the Republican Senator Braun comes out and says that this is how the resolution is going, this is how the night will move. That's great. And I'm sure that the Republicans do have 51 votes for that plan. The question is, what are Democrats going to do? Which is why when reporters are asking Chuck Schumer, so what are you going to do? Because Chuck Schumer can offer as many amendments as he wants. And every amendment gets an hour of debate on both sides. And that can eat up time, eat up time, eat up time. Now, if there is an agreement with the Democrats like Chuck Schumer to wait until after 8:30 tonight, or hold off until Monday to offer those amendments, that's one thing. But it's unclear to me if both parties agreed to that.
And I'm looking at an email from one of our Capitol Hill reporters there, Amber Alley, who says that as the senators left the chambers, the Democrats seem to be confused as to what their next steps will be. So I want to bring Catherine in. Catherine, you cover the White House. How much will Republicans be taking their cues from the White House versus Democrats who it sounds like they don't know who to take their cues from?
Sure. Well, there certainly is agreement among Republican senators, at least certainly most Republican senators, and the president's legal team that they would love to have this wrapped up as quickly as possible. So I think they're very much in agreement on that. Of course, there is some consideration as far as what the president's legal team would like to do. But really, it's as Molly was saying, a lot is in Chuck Schumer's court right now. He can offer as many amendments as he would like. It really is a process that might be left up to him, but we'll see. It will be very interesting to hear. It sounds like Republicans have come to some sort of agreement, and as far as Democrats go, it'll be very interesting to see if when we hear from Chuck Schumer or any other representative from the Democrats, whether they agree to that sort of timeline. They do still seem to be not entirely certain what's next.
And we understand that we're going to we'll see the president next. Pretty soon he's arriving at Palm Beach International Airport in potentially just a few minutes from now. Potentially might be giving the first words on impeachment following that historic vote.
That's always possible. The president hasn't been speaking to reporters as much when he gets on and off, either while loading Marine One or getting off the plane lately. But of course, it's always possible. I think it is much more likely that we will hear from him in the form of his favorite form of communication, which is Twitter. We're still waiting to see if the White House is going to be issuing any sort of formal statement this evening, or whether they're just going to wait for any official sort of comment until after the ultimate vote, which we expect would be to acquit the president.
And we see reporters there trying to get reactions from Republican and Democratic senators. All of them seem to fall basically into one of two camps. If you're a Democrat, you are saddened by the vote. If you are Republicans, you are ready to have this trial concluded. But Keir, no matter how the vote on the articles of impeachment go, ultimately President Trump will always have been impeached, even if he's not removed from office. So what does it mean legally if he's acquitted?
Well, it means that he will not be disqualified and he will not be removed from office, and we will continue on with him as our president. The House, perhaps the Senate, to the extent that they want to, can continue their oversight, their oversight authority, and probe if there are other issues of misconduct that they are concerned about. They will continue perhaps apace with that. Look, the Constitution speaks in terms of, no person shall be convicted without the concurrence of 2/3 of the members present. We've talked about this before, this very high bar. It means that the president has not been convicted under the articles of impeachment or found to have been removable and disqualifiable.
I continue to check on Twitter to see if the president has responded. Catherine, you've been following all of this from Washington, from the White House. Is there a sense now that that McConnell has all the votes, he has the power, he has his members all aligned, that he is going to really be able to drive this process forward in a way that that leads to that acquittal sooner rather than later?
I think so. Well, certainly in a process that leads to acquittal, the White House is very confident in McConnell's capabilities. He is a very successful, not just legislator, but leader within his party, and who just commands an incredible amount of respect for his ability to reach the ultimate conclusion that he wants. And so I think there is certainly a lot of confidence, certainly that he knows what he's doing. McConnell knows his members very, very well, and of course has been speaking with them privately, individually throughout this process to figure out what it is that they need. So I don't think there's any lack of confidence that McConnell will be able to land this plane eventually, as a couple of the senators put it. Of course, it's just a matter of how long that takes. It really is looking like we're seeing from the Republican senators who have spoken that they don't expect this acquittal vote to really take place sooner than Wednesday. That Wednesday really is the date that is on everyone's lips right now, which of course is after the State of the Union, is after the Iowa caucuses. So we have a few more days left here, it looks like.
Yes, and we are continuing to watch as those Republican and Democratic senators are conferring. It's a good opportunity then to take a bigger picture look, and that's where I want to turn to Keir. Lead impeachment manager Adam Schiff, he argued that there cannot be a trial without witnesses. We've talked about that, but he said that there's an implication that it will have for the future. Take a listen.
This will set a new precedent. This will be cited in impeachment trials from this point to the end of history. You can bet in every impeachment that follows, whether it is a presidential impeachment or the impeachment of a judge, if that judge or president believes that it is to his or her advantage that there shall be a trial with no witnesses, they will cite the case of Donald J. Trump. They will.
We have talked, Keir, about what the implications will be on future presidents, on the executive powers. What about, though, that question of witnesses and the executive privilege that this White House has exerted? So not a question about future precedent in terms of presidential behavior when it comes to potential or alleged campaign interference or leveraging power with foreign governments. But what about just that idea of calling witnesses? Is that going to be something that is now dead for future impeachments, that for future trials, that every president will be able to have this very broad view of executive privilege that will shut down witnesses?
So I think Mr. Schiff is correct that in the future, presidents or senates that are considering impeachment, now that this precedent has been set, may more comfortably do so without calling witnesses. But, you know, there are a number of other impeachment trials, mostly of judges, of two other presidents that did include witnesses. So you would now say that the weight of precedent is for calling witnesses. The issues about executive privilege and the assertion of constitutional privileges, those are important. And, you know, again, this is why I think it'll be interesting to hear what the senators ultimately. I hope we do hear what they say, what their justification is for their votes. You know, I think the fact that this president has asserted across the board privileges, while in an earlier segment or earlier soundbite we heard him say that he is somewhat upset that he didn't get to call witnesses. It's hard to evaluate that claim from President Trump when he's says that he'd like to have witnesses, but that he then ordered all of them not to testify.
But remember, in the beginning, after the House voted for impeachment, he said, "We're fine. You want to do impeachment? Republicans control the Senate. We're going to have we are going to have witnesses." witnesses. We're going to call Hunter. We're going to call Joe. We're going to call the whistleblower. I mean, he wasn't thinking of it in terms of who would be called on the Democratic side. He really thought, okay, it's in the Republicans' hands now. We got it in the Senate. We're just going to call all those witnesses, and I'm going to be exonerated. And he's since had to obviously walk that back because the Senate is a beast that is very difficult to tame. It doesn't matter which party is in control.
So if I was a House manager for an impeachment in the future and knowing that this was a possibility, I would want to make sure that I called every possible witness in the House. And the problem then becomes this long process that we currently face now about resolving these individual executive privilege claims or these absolute immunity claims. And when we talked earlier in the day about perhaps legislation in the Congress that would expedite that litigation in the courts, that is something that could perhaps facilitate the ability of the House managers to put together an utterly complete record.
Well, and actually,
guys, sorry, I want to pause you for just a second. Senator Roy Blunt was speaking and wanted to check out what he has to say.
What I believe happens is that the leader lays that resolution down. The Democrats have 4 or 5 non-debating amendments. They're debatable, but we believe they will not be debated, and we vote on those. We then wouldn't be here tomorrow or Sunday, and there'd be 4 hours Monday, I think from 11 to 3 for final arguments. The chief would be here for that, and then he would not be back until sometime on Wednesday, and between the time he leaves and the time he comes back, the time on the floor would be available in a more normal session for members to talk about their vote and the process and whatever else they want to talk about. And then I think the time to have the final vote would be 4 o'clock Wednesday.
Is this plan certain?
What?
Is this plan certain? Is this how it's going to happen?
Well, it's as certain as anything is until it's done, but it appears to be certain. And I think from our point of view, I'd have much rather seen it done right now and finished in whatever time it took to stick with it if we were done. But I do think the Democrats could make the case that if they wanted to, they could extend all of this with various motions and other things through Wednesday at about 4 o'clock. And so accepting that argument, we decided the best thing for everybody involved would be to go ahead and come to that certain date, but try to eliminate any of the needless pain and suffering as if this hasn't been painful enough already.
You don't think if you powered through tonight, you could have gotten this done by the State of the Union?
You know, the belief of the leader and his staff was that Democrats, if they wanted to, and they appeared to be willing to, could take it into Wednesday afternoon. So I guess that would mean they were not willing to get this done before the State of the Union on Tuesday.
Are you aware of any discussions of changing the date of the State of the Union?
Not aware of any. Not aware of any. That could happen, but I'm not aware of it at all.
Has Senator Schumer agreed to this plan?
I hope so. Certainly was presented to us as if it was something he and the leader both were agreed on.
Can I ask some details of what you just laid out? So the Chief Justice would be there on Monday for 4 hours of final arguments?
Right.
And those are arguments between the House managers and the President's lawyers, like official arguments. And then they would leave after 4 hours.
Well, we would hope they'd leave even sooner than that, but they would have up to 4 hours, and then the trial would go out of session. And then would you all start arguments again would you guys start speaking on the floor on Monday, or would you until Tuesday? So then you're just in normal Senate session. Yes.
You can talk through the day Tuesday, up until the State of the Union, basically. And then you could talk, then the court goes into session on Wednesday, is that right? I mean, I'll have to for the final.
Whether we'd have to go in at 1 or not, I don't know. If this is an agreement, we could probably come in for a final vote closer to 4.
Okay.
Because that would be a non-debatable.
Because the arguments would have already been done Monday.
That would be a non-debatable thing, right?
But can't the articles be amended, or is this part of the agreement they wouldn't be amended?
They can't. No, they wouldn't.
Okay.
Okay. Thank you all.
But the Chief Justice only has to be here for the closing arguments, right?
Some crucial new information coming from Senator Roy Blunt right there. He says that he believes that the final vote is expected on Wednesday. We had previously heard that idea floated. He says that this information was presented as though the minority leader, Senator Chuck Schumer, was in fact on board with that timeline. He said that they wanted to eliminate, quote, needless pain and suffering, because as we have discussed here at this panel, that Democrats, though they lost on the vote to call witnesses, still could potentially have the ability to prolong this impeachment trial, even though it doesn't seem that they have the votes to actually remove the president from office, that they could still do it. So this, he said, was a sort of compromise between Republican and Democrats to allow for the opportunity for senators to speak from the floor. The timeline would be as follows. On Monday, final arguments would be presented. Both sides would have up to 4 hours to make those arguments, and then the floor would be open to senators who would be able then to make speeches from the floor, either for or against impeachment, arguing on their part why they are justifying whatever vote they intended to take. And one thing that is so fascinating about the timing of all of this is that from that same Senate floor, then the President of the United States, President Donald Trump, who is the subject of this impeachment trial, would then come and deliver a State of the Union address on Tuesday night. Then on Wednesday, following that State of the Union address, they would then reconvene as a Senate chamber. More speeches would discuss this impeachment trial, and then on Wednesday, a final vote likely to acquit the president. Molly, CBS News has been reporting all of this out from the White House, from Capitol Hill. Given your knowledge and extensive experience there on the Capitol, who's the winner and who's the loser in this timeline?
I'm not sure if there's a lot of winners or a lot of losers, but it sure seems like at least the Democratic presidential candidates can get out to Iowa, have Saturday, Sunday, and the early part of Monday to do their campaigning ahead of that caucus later in the evening, because with the Senate coming back into impeachment trial mode at 1 p.m., they do have some time in the morning to get their campaigning done. I have a feeling that's one of the reasons why Chuck Schumer agreed to this deal in the first place.
And so much, as we've discussed, of this impeachment trial has been taking place not only on the Senate floor, but also in the court of public opinion, with this backdrop of an election pending. If you're just joining us, I want to tell you where we are right now. Senators voted against introducing additional witnesses at the impeachment trial of President Trump on Friday. There is no more testimony or evidence that will be introduced. The vote was 51 to 49 in favor. 2 Republicans broke rank and sided with their Democratic colleagues, but it wasn't enough to tip the scales. A pivotal moment came when Republican Senator Lisa Murkowski said today that she would vote against the additional testimony, essentially sealing the win for the grand old party. The calls for additional witnesses intensified in the previous days as lawmakers wanted to hear from former National Security Advisor John Bolton in particular. Bolton reportedly claims in an upcoming book that President Trump personally ordered him to withhold aid from Ukraine. Earlier, lead impeachment manager Adam Schiff used the news to make the case for witnesses.
You will see in a few moments, and you will recall Mr. Cipollone suggesting that the House managers were concealing facts from this body. He said all the facts should come out. Well, there's a new fact which indicates that Mr. Cipollone was among those who were in the loop. Yet another reason why we ought to hear from witnesses. Just as we predicted, and it didn't require any great act of clairvoyance, the facts will come out. They will continue to come out. And the question before you today is whether they will come out in time for you to make a complete and informed judgment as to the guilt or innocence of the president.
Molly, we have just heard from Senator Roy Blunt that the final vote on impeachment is expected to take place on Wednesday. What procedural measures will the Democrats be taking in the interim period? What more do we expect to see in addition to these speeches that we're going to see from both Republican and Democratic senators who finally are going to be unmuzzled on the Senate floor?
Well, that's right. And actually not in the impeachment setting, as Roy Blunt said. You know, once they break on Monday, they'll go back into regular Senate session, and the Chief Justice won't even have to be there. So essentially, they'll be making speeches on the Senate floor, but get to do it sort of in the midst, in this donut hole between one official impeachment time and the other one. But really, you know, it's unclear which amendments Democrats will offer. Richard Blumenthal mentioned, however, that he was going to offer an amendment that would allow the deliberations to take place in open, because really, even though we will hear of the senators on the Senate floor, it won't be in the official impeachment trial setting, and it's not necessarily deliberations. When you think about it, there won't be necessarily colloquies happening between members, pleading their cases to individuals, which is what typically has happened in the past behind closed doors. But this is an unusual time. I mean, when Clinton was impeached, 10 Democrats voted to remove President Clinton on the perjury charge. 10 Democrats with all 45, and there's a 50-50 split on the obstruction of justice. So there was a lot more maneuverability and perhaps room to convince your colleagues to do one thing or the other. It doesn't seem like that's happening in this case. So it's unclear which amendments Democrats will offer. Perhaps they'll try to slip in an amendment to suspend the rules, as they say, and call for more witnesses, which obviously is going to fail, but you know, they might try.
It would be an interesting move on the part of Democrats to do that, particularly since we have heard from the American public and all of our polling that they wanted witnesses, but we also know that Republicans have been doing very well in terms of fundraising and the president's reelection campaign by calling this a sham impeachment trial. So I want to go back over to the White House. Catherine, I understand that we are hearing for the first time from the president's legislative affairs director. What is he saying?
Absolutely. I was just hoping you might mention that. Let me read this comment from Eric Ueland, really the first on-the-record comment we're hearing. He is the president's legislative director, or the White House legislative director. He says, so the president is gratified that finally, at long last, after multiple delays, the Senate will set a schedule for his acquittal as quickly as possible. We do not believe that that schedule interferes with his ability to deliver a strong and confident State of the Union message next week in the House of Representatives to the country and the world. So the White House really getting that message across that, no, we don't think that this is going to mess up the State of the Union, and a lot of confidence in that statement.
A lot of confidence certainly coming out of the White House. Now, they had expected that the vote would fail in the call for witnesses today. That was after uncertainty in the days that preceded it, with Senate Majority Leader Mitch McConnell saying that he did not have the votes to block witnesses at one point. That changed this morning when Senator Lisa Murkowski said that she was disappointed in the Senate, but she did not feel like there was reason to hear from more witnesses. So, Catherine, tell us more about what we've learned about the White House and how they feel really about the trial potentially extending into next week, now that we understand that Democrats and Republicans, it sounds like, have come to a basic agreement that the actual vote on whether or not to acquit the president will take place on Wednesday.
Well, I think there's really a settling into the realities, the legislative realities of the Senate. This is not known to be a fast-moving body. It likes to call itself the greatest deliberative body in the world. So, you know, it really should not be that much of a surprise that it's taking a couple weeks, a little more than a couple of weeks, to get through this entire really large, historic process. So even the president, as Major Garrett reported earlier today, had kind of come to terms with the reality that this might be something that needed to happen, a little bit of a longer trial than the White House had initially hoped for. So, hey, that's just how it is. At the end of the day, the White House recognizes that the most important thing to them is that the president is acquitted and is able to say that. So it's frustrating to the president, I'm sure, that he isn't able to say that at his State of the Union address, that this vote is going to come one day after, Wednesday afternoon, is what we've been hearing from these Republican senators. But that's just how it is. And at the end of the day, the president is almost certainly going to be able to say that he has been vindicated, and, you know, that's what matters most to him.
To quote the music at President Trump's campaign rallies, you can't always get what you want. So, Keir, new information has been coming out about the Ukraine case. What impact could that have in all of this?
Well, that's one of the wild cards, right? So 3 days, or up until next Wednesday, if I can even count right now, up until next Wednesday, that is a window when the uncertain things can happen. When witness could step forward, John Bolton could hold a press conference. We just don't know. President Trump might say something that was a surprise in his State of the Union address and change the equation that we all think that we can predict now, but maybe we can't. So, you know, these are the things that we need to keep our eyes on, I think, in the short run. Just to finish up on what Molly and I were talking about before, in the long run, I think another thing I now want to keep my eye on, given that the House, we're talking about this precedent about maybe no witnesses at the Senate, future House managers, I am going to be watching to see whether the House Sergeant at Arms decides to buy a bunch of handcuffs and build some jail cells. Because,
or they can fine.
Because if they can't be assured of calling witnesses in the Senate, and the courts are going to take a very long time to resolve these claims of executive privilege. You know, extreme circumstances may call for extreme measures, and we may see the reviving of the inherent contempt procedure, which we haven't seen since the 1930s or so.
Well, also, there are legislative remedies to this. Congress controls the power of the purse. They don't have to fund all the programs of the DOJ that would, you know, if these programs aren't going to enforce our subpoenas, then let's just slash them from the budget. I mean, it's a way to get at these. I mean, I was talking to House Democrats earlier this year, well, late last year, and, you know, about, you know, if you keep funding these agencies and they're not doing what you need them to do, they're not giving you the information you want, why are you funding them? And actually, that had been something discussed among members of that Democratic caucus, because they do. Congress has the power to fund these agencies. They have the power to fund programs, to fund money, to fund projects that go to build border walls and such, and to deny it as well. And that's why Congress can be very powerful when it unites. And in order to unite these days, it seems like there's something lacking. And what's lacking is bipartisanship and, you know, trusting your fellow lawmaker and really knowing their district and where you can push them politically to get them to agree to what you're agreeing to. There's a lot of give and take that has to happen on both sides. And if I'm in a Republican and I'm in a vulnerable district, and you are a Democrat, a liberal Democrat, and you want me to sign on to your legislation, okay, and I want to, but you got to help me out. You're going to have to take a hit for me because we're going to have to balance this out. And it seems like because lawmakers don't spend as much time on Capitol Hill and they are going back to their districts so often, that time needed to really get to know your fellow lawmaker is lacking. And so, you know, it's unclear the way forward, but I know that was one of the items discussed last year, at least, by, you know, let's just, if these agencies aren't going to provide documents, cut off the funding. OMB, you don't need any money if you're not going to give us our documents.
But that's, as much as that's an interesting idea, wouldn't that be just a complete breakdown of our democracy when the Department of Justice can't function anymore because Congress has decided to lock horns with it?
But think about what Republicans have done to the IRS. They kept defunding it because of Obamacare, and they didn't want IRS auditors to go enforce the laws, the independent mandate. I mean, the requirement that individuals have health care, you know, or you have to pay a tax for it. So over the past, you know, however many years, Republicans were slowly denying funding for for the IRS. And yes, it does create a lot of problems, obviously, but it's a way to push back at the executive. And again, it's not necessarily the answer, but it's a possible way to get the solutions you need.
We have been continuing to follow the small machinations of senators walking around there in the Capitol. We've heard from a few, though. They basically are all saying the same thing. Democrats not quite sure how this is going to wrap up. Republicans all looking towards their majority leader, Mitch McConnell, to give them guidance. They're expressing optimism that things will be smooth sailing with an acquittal for President Trump, potentially even a bipartisan acquittal for President Trump come Wednesday. But that's not before the State of the Union address, which will take place right there in the Senate on Tuesday. Keir, you and I have been talking a lot about the future implications of this case, and Molly's adding in some other ideas about how Congress, at least the House, could exact their revenge.
No, it's not ideas. These are things that members of Congress were talking about last year. I mean, this is talk amongst the caucus. They didn't act on them, but it's a possible solution that they could take to actually, show that Article 1 matters and that they have the power of the purse. And if you're not going to spend it and give us the documents you need and you're not going to let us do our oversight, then why are we going to be funding you?
Yeah, and it's not just the caucus, too.
No,
the framers talked about this
in
the constitutional
exactly.
debate.
So
that's exactly where I wanted to
it's not my idea, trust me. It's not mine.
No, it's a good idea.
I'm reporting what I've heard has been discussed.
A good point, Molly. But that's exactly where I want to go with you, Keir. I want you to reality check us on what these members have been telling Molly. Is this possible? What did the framers have in mind?
Absolutely. They placed the power of the purse in the Congress as a way to do exactly what Molly just said. Now, I come to this table as somebody who was a prosecutor who brought out allegations of misconduct and was required to prove them, and needed tools to prove my case, right? So I don't know how frequently Congress has the opportunity to apply that power of the purse tool, whether it's an annual budget.
Every fiscal year, my friend.
Well, if I'm a prosecutor and the fiscal year starts on October 1, right, and I've got something I need to start proving on October 2, I don't want to wait 12 months.
That's right.
Right? I want to use the tools that I have at my disposal to apply the pressure that is appropriate and proportional to the circumstances.
Right.
But if I'm worried that I will never be able to get a witness called in the Senate, I will start considering seriously having and I'm also worried that the courts will not react quickly to me. I will then and the other thing is to refer a contempt citation to the Department of Justice. That's the other option. If I don't think the Justice Department is going to respond to me, I'm going to go talk to my House Sergeant at Arms and tell him to go buy some handcuffs.
Handcuffs
right.
in the future in Congress.
That's right.
We've just now gotten a statement from Senator Schumer's spokesperson. As you know, he is the Senate Minority Leader, leading the charge for Democrats. This is what they say. Senator McConnell and Republicans wanted to rush through an acquittal vote tonight, but Democrats wanted votes on witnesses and documents for the House managers to be able to make closing arguments, ample time for every member to speak, and to prevent the GOP from rushing this through. This is, of course, according to Senator Chuck Schumer's spokesperson. He also goes on to say there will now be 4 votes on Democratic amendments tonight. Closing arguments will take place then on Monday. Speeches from senators will take place Monday through Wednesday. And the final vote on the impeachment trial of President Trump will take place at 4 p.m. on Wednesday. And according to the spokesperson from Senator Schumer, in bold is written, a day after the State of the Union, which is when that will take place. They also say that Democrats still oppose this McConnell resolution as it does not include witnesses and documents. Certainly that will be something that will echo on the campaign trail. You see right there Senator Amy Klobuchar, who is running for president. She has been working the phones and also working her influence in Iowa ahead of the Iowa caucus, which will take place then on Monday. Certainly, we expect to hear from the Democrats. that the White House tried to shut down this impeachment trial by shutting down information. We've already heard how they have been crying about the inability to have received, both in the House, testimony from people because essential witnesses, they say, because the White House has exerted executive privilege. So I want to go back to you, Keir. This question about executive privilege, what we have heard from Democrats is that the White House has overexerted their executive privilege. Is that a fair complaint on the part of Democrats?
Right. So we get now into the very first question that was asked by the senators in the question and answer section, which is this question about mixed motives. So it's certainly true that where a president has a bona fide claim of executive privilege or a non-frivolous claim to absolute immunity after the McGahn decision, it's becoming, I think, harder and harder to make a non-frivolous claim that there is absolute immunity from testimony. Certainly, presidents in the future should have the ability, in good faith, to make those points. The problem comes with an effort, if it's an effort to obstruct. If it's an effort to obstruct using the office for an improper purpose, right? So that goes to this question of mixed motives and proof of what the purpose is. So here, where to a degree that we have never before seen in history, where a president across the board is asserting absolute immunity, executive privilege, in a circumstance where the Congress, because the impeachment power is vested in the Congress, its need for information is at its absolute zenith, where the president has been talking on Twitter and arguably waived much of these claims, where the claims themselves begin as qualified and they are generally inapplicable where they're used to shield wrongdoing. Where all of that set of circumstances comes together, I think it is certainly reasonable to make the claim that that is improper. So, and that's what the articles of impeachment allege.
But if the articles of impeachment fail, as we expect that they will, and the president is acquitted on that charge, on all charges, does that mean then that with this question of mixed motives, that the presidents in the future will be able to exert this executive privilege in a way that is nearly universal?
So, look, I think it's going to end up being somewhat unresolved. So I think that an aggressive president in the future could make these same claims. The issue is, I think, in the future, will our system adjust now after this to create a safety valve, a way to resolve them, either by expedited review in the courts, or will the House managers react by turning back to this old procedure of inherent contempt to expedite the resolution of these claims of executive privilege?
And we have heard from some of the senators an interesting take on that uncomfortable area that this question now occupies. That there are many senators on the Republican side who feel like the president has done something that certainly extends his reach, his executive power beyond what is appropriate. But as we heard from Senator Marco Rubio, that they don't think that necessarily that means he ought to be removed from power.
Right. So, and again, I want to sort of distinguish the rationales that senators may apply, and hopefully we will learn about after Wednesday or maybe on Wednesday when they discuss why they're casting their votes. To the extent that they're voting on factually specific issues relating to this particular conduct, I think those votes will be, things that can be distinguished, because if we do see another impeachment, undoubtedly there'll be different factual circumstances. The votes that are under the Constitution, that rely upon this theory that Alan Dershowitz has propounded. I think those are the ones that are most concerning, because I'm not alone in the belief that his view is flawed, that the idea that a president, as long as they believe they're acting in the public interest, effectively can't do anything wrong, just runs in the face of the history of the impeachment clause. Its context set in the Constitution, and what we know from the debates and from the other previous impeachments and the English precedent that our impeachment clause relied upon. There's 400 years of impeachments in England, starting in about the late 1300s, that our framers knew about and brought into the Constitution, which included removal for corruption and other misconduct. So as long as the vote, I think, doesn't rely upon that particular rationale, I think that if I were a White House counsel in the future, I would not recommend a future president to replicate President Trump's conduct.
And former White House Chief of Staff John Kelly said on Friday that if there are no witnesses, impeachment is, quote, a job only half done. I want to bring back in Catherine. Can you remind us about Kelly's relationship with this president, and why are his comments considered really so significant?
Sure. Well, Kelly, who left the White House at the very end of 2018, is someone who was very widely respected within the building, even though he kind of brought more structure, or attempted to bring more structure, to the president's White House, which eventually became a source of frustration for the president, and one of the reasons that they eventually parted ways. But he is someone, a Marine general, someone who commanded a lot of respect, still commands a lot of respect, certainly is someone who is viewed as someone who tells the truth and speaks his mind, even though there was certainly some consternation over an incident involving Rob Porter, a former White House staff secretary, and there was basically just some controversy over the way John Kelly handled that. But despite all of that, John Kelly, really someone who is generally pretty respected inside and outside of the White House. And so his words certainly are meaningful. He hasn't spoken up very much, and that he is choosing to speak out now, I think, is rather telling.
Rather telling, and yet it seems like almost no influence on the ultimate vote in terms of whether or not witnesses would be called in this impeachment trial. So, Molly, I want to turn back to the New York Times. Reporting from experts from John Bolton's book, the former national security advisor claimed that President Trump directly asked him, as well as lawyers Rudy Giuliani and Pat Cipollone, to help with the Ukraine pressure campaign. Remember, these are the president's private attorneys, not White House counsel. So what do we know?
Well, what I know is that, does it matter right now? Does it matter to the Republicans who are going to vote to acquit or not? If you think that what the president did was impeachable, then you'll vote to impeach. If you don't, and you think that he's proved that even though the House managers have, quote unquote, proved their case, according to Lamar Alexander, that Republican from Tennessee, and it's just not impeachable, you'll vote to acquit. So I think that that's where we are right now. But it doesn't mean that it does not mean, once his vote is taken, the House will still continue their oversight.
So that's a really good point. So do we have a sense of whether the House would then try and call on Bolton or continue its investigation?
Well, they can. And actually, earlier this week, Speaker Pelosi was asked that question. And she demurred a little bit because, of course, she was waiting to see what was going to happen with the witness question.
Right. She doesn't want to say, yes, we'll do it in the House,
right,
and then take off all the pressure on the Senate.
That's right. But she did essentially leave the door open to that. So, like I said, this isn't going to necessarily end just... The investigations and inquiries will not necessarily end just because the Senate has voted on these two articles of impeachment. The House can continue doing their investigations, continue fighting to hear from Don McGahn.
And one of the things that we have heard from the President's counsel is that they felt like the House didn't do an adequate job in terms of fighting to subpoena those witnesses. So, given what the president's attorneys have said, do they now do that?
Well, that is a good question, because the other thing that his attorneys said was the House is never going to stop investigating this president, the personal life of this president. They're just not. And so to what extent the House Democrats will focus on that moving forward is a big question. I know that Pelosi has met with various committee chairs, not necessarily doing investigations, but to deal with their legislative agenda, because the Democrats want to retain control of the House. And when Republicans, were moving towards impeaching President Clinton in 1998, they lost. They kept the majority, but they only won a few seats when they were predicted to have won like maybe 15, and they only won 3. So it might sound kind of funny, but they were completely underperformed in that election, and a lot of that was due to the impeachment, the upcoming impeachment matter in the House.
Right. So
fast
so
forward
that
to
has to
2000.
be in the mind of Pelosi.
That's why
there's fatigue, impeachment fatigue.
I think
among the general population.
I think that's partly it, but I also think that she says, they want to see, the public wants to see what we are producing. Legislative. Earlier this week, she unveiled a $760 billion, something like $760 billion infrastructure bill that's not going to become law, of course, but it gives her Democrats something to run on, essentially, because they don't want this to be an impeachment vote. They need to have something to take home to their voters, and even though it's very difficult to see how the Senate and the House, Democrats and Republicans, work together on additional legislation, given what a toxic environment it is in Washington, D.C., you can just look back to late December when the House was voting to impeach the president, and they were also voting to move forward on a new trade deal with the U.S., Canada, and Mexico. And that was a major win, and it was a bipartisan effort, and Democrats were very involved in that. So, again, it's all a balancing act, and Nancy Pelosi is very good at reading her districts, her vulnerable members, and the polls, and the money that they're raising.
So, Keir, Cipollone is leading the president's impeachment defense. What questions does the revelations from Bolton raise, if they are in fact true?
Well, the reporting is very surprising because if it's true, he becomes a material witness to an important conversation of disputed fact. What the report has been disputed by Mr. Giuliani. There's been a White House denial that's been put out. So having Mr. Cipollone in that meeting is very important because he's also the president's counsel. Because it's disputed. If you were a lawyer in a meeting where there were other witnesses who could testify, and so your testimony might be just duplicative of other witnesses, could resolve whatever that was, you wouldn't necessarily.
And ask the clerk to report.
Sorry to interrupt you, Keir, but we're going to go back to the Senate floor as we see that they have come back
Senate
into
Resolution
session.
488 to provide for related procedures concerning the articles of impeachment against Donald John Trump, President of the United States. Resolved that the record in this case shall be closed, and no motion with respect to reopening the record shall be in order for the duration of these proceedings. The Senate shall proceed to final arguments as provided in the impeachment rules, waiving the two-person rule contained in Rule 22 of the Rules of Procedure and Practice in the Senate when sitting on impeachment trials. Such arguments shall begin at 11 a.m. on Monday, February 3rd, 2020, and not exceed 4 hours, and be equally divided between the House and the President to be used as under the rules of impeachment. At the conclusion of the final arguments by the House and the President, the Court of Impeachment shall stand adjourned until 4 p.m. on Wednesday, February 5th, 2020, at which time the Senate, without intervening action or debate, shall vote on the articles of impeachment.
Justice.
Mr. Majority Leader.
I ask unanimous consent that the Democratic leader or his designee be allowed to offer up to 4 amendments to the resolution. Further, that I be recognized to make a motion to table the amendment after it's been reported with no intervening action or debate.
Is there objection? Without objection, so ordered. The Democratic leader is recognized.
Mr. Chief Justice, I have a parliamentary inquiry.
The Democratic leader will state the inquiry.
Is the Chief Justice aware that in the impeachment trial of President Johnson, Chief Justice Chase, as presiding officer, cast tie-breaking votes on both March 31st and April 2nd, 1868?
I am, Mr. Leader. The one concerned a motion to adjourn, the other concerned a motion to close deliberations. I do not regard those isolated episodes 150 years ago as sufficient to support a general authority to break ties. If the members of this body, elected by the people and accountable to them, divide equally on a motion, the normal rule is that the motion fails. I think it would be inappropriate for me, an unelected official from a different branch of government, to assert the power to change that result so that the motion would succeed.
Now, Mr. Chief Justice, I send an amendment to the desk to subpoena Mulvaney, Bolton, Duffy, Blair, and the White House, OMB, DOD, and State Department documents, and I ask that it be read.
The clerk will report.
Senator from New York, Mr. Schumer, proposes an amendment number 1295. At the appropriate place in the matter following the resolving clause, insert the following. Section, notwithstanding any other provision of this.
The amendment be considered as read.
Objection? So ordered. The majority leader is recognized.
I move to table the amendment and ask for the yeas and nays.
Is there a sufficient second? There is. The clerk will call the roll.
Mr. Alexander. Mr. Alexander, aye. Ms. Baldwin. Ms. Baldwin, no. Mr. Barrasso. Mr. Barrasso, aye. Mr. Bennett. Mr. Bennett, no. Mrs. Blackburn. Mrs. Blackburn, aye. Mr. Blumenthal. Mr. Blumenthal, no. Mr. Blunt. Mr. Blunt, aye. Mr. Booker. Mr. Booker, no. Mr. Bozeman. Mr. Bozeman, aye. Mr. Braun. Mr. Braun, aye. Mr. Brown. Mr. Brown, no. Mr. Burr. Mr. Burr, aye. Ms. Cantwell. Ms. Cantwell, no. Mrs. Capito. Mrs. Capito, aye. Mr. Cardin. Mr. Cardin, no. Mr. Carper. Mr. Carper, no. Mr. Casey. Mr. Casey, no. Mr. Cassidy. Mr. Cassidy, aye. Ms. Collins. Ms. Collins, aye. Mr. Coons. Mr. Coons, no. Mr. Cornyn. Mr. Cornyn, aye. Ms. Cortez Masto. Ms. Cortez Masto, no. Mr. Cotton. Mr. Cotton, no. Mr. Cotton, aye. Mr. Kramer. Mr. Kramer, aye. Mr. Crapo. Mr. Crapo, aye. Mr. Cruz. Mr. Cruz, aye. Mr. Daines. Mr. Daines, aye. Ms. Duckworth. Ms. Duckworth, no. Mr. Durbin. Mr. Durbin, no. Mr. Enzi. Mr. Enzi, aye. Ms. Ernst. Ms. Ernst, aye. Mrs. Feinstein. Mrs. Feinstein, no. Mrs. Fisher. Mrs. Fisher, aye. Mr. Gardner. Mr. Gardner, aye. Mrs. Gillibrand. Mrs. Gillibrand, no. Mr. Graham. Mr. Graham, aye. Mr. Grassley. Mr. Grassley, aye. Ms. Harris. Ms. Harris, no. Ms. Hassan. Ms. Hassan, no. Mr. Hawley. Mr. Hawley, aye. Mr. Heinrich. Mr. Heinrich, no. Ms. Hirono? Ms. Hirono, no. Mr. Hoven? Mr. Hoven, aye. Mrs. Hyde-Smith? Mrs. Hyde-Smith, aye. Mr. Inhofe? Mr. Inhofe, aye. Mr. Johnson? Mr. Johnson, aye. Mr. Jones? Mr. Jones, no. Mr. Kane? Mr. Kane, no. Mr. Kennedy? Mr. Kennedy, aye. Mr. King? Mr. King, no. Ms. Klobuchar? Ms. Klobuchar, no. Mr. Langford? Mr. Langford, aye. Mr. Leahy? Mr. Leahy, no. Mr. Lee? Mr. Lee, aye. Mrs. Loeffler? Mrs. Loeffler, aye. Mr. Manchin? Mr. Manchin, no. Mr. Markey? Mr. Markey, no. Mr. McConnell? Mr. McConnell, aye. Ms. McSally? Ms. McSally, aye. Mr. Menendez? Mr. Menendez, no. Mr. Merkley? Mr. Merkley, no. Mr. Moran? Mr. Moran, aye. Ms. Murkowski? Ms. Murkowski, aye. Mr. Murphy? Mr. Murphy, no. Mrs. Murray? Mrs. Murray, no. Mr. Paul? Mr. Paul, aye. Mr. Perdue? Mr. Perdue, aye. Mr. Peters? Mr. Peters, no. Mr. Portman? Mr. Portman, aye. Mr. Reed? Mr. Reed, no. Mr. Risch? Mr. Risch, aye. Mr. Roberts? Mr. Roberts, aye. Mr. Romney? Mr. Romney, aye. Ms. Rosen? Ms. Rosen, no. Mr. Rounds? Mr. Rounds, aye. Mr. Rubio? Mr. Rubio, aye. Mr. Sanders? Mr. Sanders, no. Mr. Sass? Mr. Sass, aye. Mr. Schatz? Mr. Schatz, no. Mr. Schumer? Mr. Schumer, no. Mr. Scott of Florida? Mr. Scott of Florida, aye. Mr. Scott of South Carolina? Mr. Scott of South Carolina, aye. Mrs. Shaheen? Mrs. Shaheen, no. Mr. Shelby? Mr. Shelby, aye. Ms. Sinema? Ms. Sinema, no. Ms. Smith? Ms. Smith, no. Ms. Stabenow? Ms. Stabenow, no. Mr. Sullivan? Mr. Sullivan, aye. Mr. Tester? Mr. Tester, no. Mr. Thune? Mr. Thune, aye. Mr. Tillis? Mr. Tillis, aye. Mr. Toomey? Mr. Toomey, aye. Mr. Udall? Mr. Udall, no. Mr. Van Hollen? Mr. Van Hollen, no. Mr. Warner? Mr. Warner, no. Ms. Warren? Ms. Warren, no. Mr. Whitehouse? Mr. Whitehouse, no. Mr. Wicker? Mr. Wicker, aye. Mr. Wyden? Mr. Wyden, no. Mr. Young? Mr. Young, aye.
Does any member in the chamber wish to change his or her vote? If not, the yeas are 53, the nays are 47. The motion is agreed to. The Democratic leader is recognized.
Mr. Chief Justice, I send an amendment to the desk to subpoena John R. Bolton, and I ask that it be read.
The clerk will report.
The senator from New York, Mr. Schumer, proposes an amendment number 1296. At the appropriate place in the resolving clause, insert the following. Section, notwithstanding any other provision of this resolution pursuant to Rules 5 and 6 of the Rules of Procedure and Practice in the Senate when sitting on impeachment trials, the Chief Justice of the United States, through the Secretary of the Senate, shall issue a subpoena for the taking of testimony of John Robert Bolton, and the Sergeant-at-Arms is authorized to utilize the services of the Deputy Sergeant-at-Arms or any other employee of the Senate in serving the subpoena authorized to be issued by this section.
The majority leader is recognized.
I move to table the amendment and ask for the yeas and nays.
Is there a sufficient second? There is. The clerk will call the roll.
Mr. Alexander. Aye. Ms. Baldwin. No. Mr. Barrasso. Aye. Mr. Bennett. No. Mrs. Blackburn. Aye. Mr. Blumenthal. No. Mr. Blunt. Aye. Mr. Booker. No. Mr. Bozeman. Aye. Mr. Braun. Aye. Mr. Brown. No. Mr. Burr. Aye. Ms. Cantwell. No. Mrs. Capito. Aye. Mr. Cardin. No. Mr. Carper. No. Mr. Casey. No. Mr. Cassidy. Aye. Ms. Collins. No. Mr. Coons. No. Mr. Cornyn. Aye. Ms. Cortez Masto. No. Mr. Cotton. Aye. Mr. Kramer. Aye. Mr. Crapo. Aye. Mr. Cruz. Aye. Mr. Daines. Aye. Ms. Duckworth. No. Mr. Durbin. No. Mr. Enzi. Aye. Ms. Ernst. Aye. Mrs. Feinstein. No. Mrs. Fisher. Aye. Mr. Gardner. Aye. Mrs. Gillibrand. No. Mr. Graham. Aye. Mr. Grassley. Aye. Ms. Harris. No. Ms. Hassan. No. Mr. Hawley. Aye. Mr. Heinrich. No. Ms. Hirono. No. Mr. Hoven. Aye. Mrs. Hyde-Smith. Aye. Mr. Inhofe. Aye. Mr. Johnson. Aye. Mr. Jones. No. Mr. Kane. No. Mr. Kennedy. Aye. Mr. King. No. Ms. Klobuchar. No. Mr. Lankford. Aye. Mr. Leahy. No. Mr. Lee. Aye. Mrs. Loeffler. Aye. Mr. Manchin. No. Mr. Markey. No. Mr. McConnell. Aye. Ms. McSally. Aye. Mr. Menendez. No. Mr. Merkley. No. Mr. Moran. Aye. Ms. Murkowski. Aye. Mr. Murphy. No. Mrs. Murray. No. Mr. Paul. Aye. Mr. Perdue. Aye. Mr. Peters? No. Mr. Portman? Aye. Mr. Reed? No. Mr. Risch? Aye. Mr. Roberts? Aye. Mr. Romney? No. Ms. Rosen? No. Mr. Rounds? Aye. Mr. Rubio? Aye. Mr. Sanders? No. Mr. Sass? Aye. Mr. Schatz? No. Mr. Schumer? No. Mr. Scott of Florida? Aye. Mr. Scott of South Carolina? Aye. Mrs. Shaheen? No. Mr. Shelby? Aye. Ms. Sinema? No. Ms. Smith? No. Ms. Stabenow? No. Mr. Sullivan? Aye. Mr. Tester? No. Mr. Thune? Aye. Mr. Tillis? Aye. Mr. Toomey? Aye. Mr. Udall? No. Mr. Van Hollen? No. Mr. Warner? No. Ms. Warren? No. Mr. Whitehouse? No. Mr. Wicker? Aye. Mr. Wyden? No. Mr. Young? Aye.
Are there any senators in the chamber wishing to vote or change his or her vote? If not, the yeas are 51, the nays are 49. The motion is agreed to. The Democratic leader is recognized.
Mr. Chief Justice, I send an amendment to the desk to subpoena John R. Bolton, provided further that there be 1 day for a deposition presided over by the Chief Justice and 1 day for live testimony before the Senate, both of which must occur within 5 days of the adoption of the underlying resolution, and I ask that it be read.
The clerk will report.
The senator from New York, Mr. Schumer, proposes an amendment number 1297. At the appropriate place of the matter following the resolving clause.
Be considered as read.
So ordered. The majority leader is recognized.
I move to table the amendment and ask for the ayes and nays.
Is there a sufficient second? There is. The clerk will call the roll.
Mr. Alexander? Aye. Mr. Alexander, aye. Ms. Baldwin? Ms. Baldwin, no. Mr. Barrasso? Mr. Barrasso, aye. Mr. Bennett? Mr. Bennett, no. Mrs. Blackburn? Mrs. Blackburn, aye. Mr. Blumenthal? Mr. Blumenthal, no. Mr. Blunt? Mr. Blunt, aye. Mr. Booker? Mr. Booker, no. Mr. Bozeman? Mr. Bozeman, aye. Mr. Braun? Mr. Braun, aye. Mr. Brown? Mr. Brown, no. Mr. Burr? Mr. Burr, aye. Ms. Cantwell? Ms. Cantwell, no. Mrs. Capito? Mrs. Capito, aye. Mr. Cardin? Mr. Cardin, no. Mr. Carper? Mr. Carper, no. Mr. Casey? Mr. Casey, no. Mr. Cassidy? Mr. Cassidy, aye. Ms. Collins? Ms. Collins, no. Mr. Coons? Mr. Coons, no. Mr. Cornyn? Mr. Cornyn, aye. Ms. Cortez Masto? Ms. Cortez Masto, no. Mr. Cotton? Mr. Cotton, aye. Mr. Kramer. Mr. Kramer, aye. Mr. Crapo. Mr. Crapo, aye. Mr. Cruz. Mr. Cruz, aye. Mr. Daines. Mr. Daines, aye. Ms. Duckworth. Ms. Duckworth, no. Mr. Durbin. Mr. Durbin, no. Mr. Enzi. Mr. Enzi, aye. Ms. Ernst. Ms. Ernst, aye. Mrs. Feinstein. Mrs. Feinstein, no. Mrs. Fisher. Mrs. Fisher, aye. Mr. Gardner. Mr. Gardner, aye. Mrs. Gillibrand. Mrs. Gillibrand, no. Mr. Graham. Mr. Graham, aye. Mr. Grassley. Mr. Grassley, aye. Ms. Harris. Ms. Harris, no. Ms. Hassan. Ms. Hassan, no. Mr. Hawley. Mr. Hawley, aye. Mr. Heinrich. Mr. Heinrich, no. Ms. Hirono. Ms. Hirono, no. Mr. Hoven. Mr. Hoven, aye. Mrs. Hyde-Smith. Mrs. Hyde-Smith, aye. Mr. Inhofe. Mr. Inhofe, aye. Mr. Johnson. Mr. Johnson, aye. Mr. Jones. Mr. Jones, no. Mr. Kane. Mr. Kane, no. Mr. Kennedy. Mr. Kennedy, aye. Mr. King. Mr. King, no. Ms. Klobuchar. Ms. Klobuchar, no. Mr. Langford. Mr. Langford, aye. Mr. Leahy. Mr. Leahy, no. Mr. Lee. Mr. Lee, aye. Mrs. Loeffler. Mrs. Loeffler, aye. Mr. Manchin. Mr. Manchin, no. Mr. Markey. Mr. Markey, no. Mr. McConnell. Mr. McConnell, aye. Ms. McSally. Ms. McSally, aye. Mr. Menendez. Mr. Menendez, no. Mr. Merkley. Mr. Merkley, no. Mr. Moran. Mr. Moran, aye. Ms. Murkowski. Ms. Murkowski, aye. Mr. Murphy. Mr. Murphy, no. Mrs. Murray. Mrs. Murray, no. Mr. Paul. Mr. Paul, aye. Mr. Perdue. Mr. Perdue, aye. Mr. Peters. Mr. Peters, no. Mr. Portman. Mr. Portman, aye. Mr. Reed. Mr. Reed, no. Mr. Risch. Mr. Risch, aye. Mr. Roberts. Mr. Roberts, aye. Mr. Romney. Mr. Romney, no. Ms. Rosen. Ms. Rosen, no. Mr. Rounds. Mr. Rounds, aye. Mr. Rubio. Mr. Rubio, aye. Mr. Sanders. Mr. Sanders, no. Mr. Sass. Mr. Sass, aye. Mr. Schatz. Mr. Schatz, no. Mr. Schumer. Mr. Schumer, no. Mr. Scott of Florida. Mr. Scott of Florida, aye. Mr. Scott of South Carolina. Mr. Scott of South Carolina, aye. Mrs. Shaheen. Mrs. Shaheen, no. Mr. Shelby. Mr. Shelby, aye. Ms. Sinema. Ms. Sinema, no. Ms. Smith. Ms. Smith, no. Ms. Stabenow. Ms. Stabenow, no. Mr. Sullivan. Mr. Sullivan, aye. Mr. Tester. Mr. Tester, no. Mr. Thune. Mr. Thune, aye. Mr. Tillis. Mr. Tillis, aye. Mr. Toomey. Mr. Toomey, aye. Mr. Udall. Mr. Udall, no. Mr. Van Hollen. Mr. Van Hollen, no. Mr. Warner. Mr. Warner, no. Ms. Warren. No. Ms. Warren, no. Mr. Whitehouse. Mr. Whitehouse, no. Mr. Wicker. Mr. Wicker, aye. Mr. Wyden. Mr. Wyden, no. Mr. Young. Mr. Young, aye.
Is there any member in the chamber who wishes to vote or change his or her vote? If no, the yeas are 51, the nays are 49. The motion is agreed to.
Mr. Chief Justice.
The senator from Maryland.
Mr. Chief Justice, I send an amendment to the desk to have the Chief Justice rule on motions to subpoena witnesses and documents and to rule on any assertion of privilege, and I ask that it be read.
The clerk will report.
The senator from Maryland, Mr. Van Hollen, proposes an amendment number 1298. At the appropriate place in the matter following the resolving clause, insert the following. Notwithstanding any other provision of this resolution, the presiding officer shall issue a subpoena for any witness or any document that a senator or a party moves to subpoena if the presiding officer determines that the witness or document is likely to have probative evidence relevant to either article of impeachment before the Senate and consistent with the authority of the presiding officer to rule on all questions of evidence, shall rule on any assertion of privilege.
Leader is recognized.
Mr. Chief Justice, I move to table the amendment and ask for the yeas and nays.
Is there sufficient second? There is. The clerk will call the roll.
Mr. Alexander. Aye. Ms. Baldwin. No. Mr. Barrasso. Aye. Mr. Bennett. No. Mrs. Blackburn. Aye. Mr. Blumenthal. No. Mr. Blunt. Aye. Mr. Booker. No. Mr. Bozeman. Aye. Mr. Braun. Aye. Mr. Brown. No. Mr. Burr. Aye. Ms. Cantwell. No. Mrs. Capito. Aye. Mr. Cardin. No. Mr. Carper. No. Mr. Casey. No. Mr. Cassidy. Aye. Ms. Collins. Aye. Mr. Coons. No. Mr. Cornyn. Aye. Ms. Cortez Masto. No. Mr. Cotton. Aye. Mr. Kramer. Aye. Mr. Crapo. Aye. Mr. Cruz. Aye. Mr. Daines. Aye. Ms. Duckworth. No. Mr. Durbin. No. Mr. Enzi. Aye. Ms. Ernst. Aye. Mrs. Feinstein. No. Mrs. Fisher. Aye. Mr. Gardner. Aye. Mrs. Gillibrand. No. Mr. Graham. Aye. Mr. Grassley. Aye. Ms. Harris. No. Ms. Hassan. No. Mr. Hawley. Aye. Mr. Heinrich. No. Ms. Hirono. No. Mr. Hoven. Aye. Mrs. Hyde-Smith. Aye. Mr. Inhofe. Aye. Mr. Johnson. Aye. Mr. Jones. No. Mr. Kane. No. Mr. Kennedy. Aye. Mr. King. No. Ms. Klobuchar. No. Mr. Lankford. Aye. Mr. Leahy. No. Mr. Lee. Aye. Mrs. Loeffler. Aye. Mr. Manchin. No. Mr. Markey. No. Mr. McConnell. Aye. Ms. McSally. Aye. Mr. Menendez. No. Mr. Merkley. No. Mr. Moran. Aye. Ms. Murkowski. Aye. Mr. Murphy. No. Mrs. Murray. No. Mr. Paul. Aye. Mr. Perdue. Aye. Mr. Peters. No. Mr. Portman. Aye. Mr. Reed. No. Mr. Risch. Aye. Mr. Roberts. Aye. Mr. Romney. Aye. Ms. Rosen. No. Mr. Rounds. Aye. Mr. Rubio. Aye. Mr. Sanders. No. Mr. Sass. Aye. Mr. Schatz. No. Mr. Schumer. No. Mr. Scott of Florida. Aye. Mr. Scott of South Carolina. Aye. Mrs. Shaheen. No. Mr. Shelby. Aye. Ms. Sinema. No. Ms. Smith. No. Ms. Stabenow. No. Mr. Sullivan. Aye. Mr. Tester. No. Mr. Thune. Aye. Mr. Tillis. Aye. Mr. Toomey. Aye. Mr. Udall. No. Mr. Van Hollen. No. Mr. Warner. No. Ms. Warren. No. Mr. Whitehouse. No. Mr. Wicker. Aye. Mr. Wyden. No. Mr. Young. Aye.
Is there any senator in the chamber wishing to vote or change his or her vote? If no, the yeas are 53, the nays are 47. The motion is agreed to. The question occurs on the adoption of Senate Resolution 488. Is there a sufficient second? There is. The clerk will call the roll.
Mr. Alexander. Mr. Alexander, aye. Ms. Baldwin. Ms. Baldwin, no. Mr. Barrasso. Mr. Barrasso, aye. Mr. Bennett. Mr. Bennett, no. Mrs. Blackburn. Mrs. Blackburn, aye. Mr. Blumenthal. Mr. Blumenthal, no. Mr. Blunt. Mr. Blunt, aye. Mr. Booker. Mr. Booker, no. Mr. Bozeman. Mr. Bozeman, aye. Mr. Braun. Mr. Braun, aye. Mr. Brown. Mr. Brown, no. Mr. Burr. Mr. Burr, aye. Ms. Cantwell. Ms. Cantwell, No. Mrs. Capito? Mrs. Capito, aye. Mr. Cardin? Mr. Cardin, no. Mr. Carper? Mr. Carper, no. Mr. Casey? Mr. Casey, no. Mr. Cassidy? Mr. Cassidy, aye. Ms. Collins? Ms. Collins, aye. Mr. Coons? Mr. Coons, no. Mr. Cornyn? Mr. Cornyn, aye. Ms. Cortez Masto? Ms. Cortez Masto, no. Mr. Cotton? Mr. Cotton, aye. Mr. Kramer? Mr. Kramer, aye. Mr. Crapo? Mr. Crapo, aye. Mr. Cruz? Mr. Cruz, aye. Mr. Daines? Mr. Daines, aye. Ms. Duckworth? Ms. Duckworth, no. Mr. Durbin? Mr. Durbin, no. Mr. Enzi? Mr. Enzi, aye. Ms. Ernst? Ms. Ernst, aye. Mrs. Feinstein? Mrs. Feinstein, no. Mrs. Fisher? Mrs. Fisher, aye. Mr. Gardner? Mr. Gardner, aye. Mrs. Gillibrand? Mrs. Gillibrand, no. Mr. Graham? Mr. Graham, aye. Mr. Grassley? Mr. Grassley, aye. Ms. Harris? Ms. Harris, no. Ms. Hassan? Ms. Hassan, no. Mr. Hawley? Mr. Hawley, aye. Mr. Heinrich? Mr. Heinrich, no. Ms. Hirono? Ms. Hirono, no. Mr. Hoven? Mr. Hoven, aye. Mrs. Hyde-Smith? Mrs. Hyde-Smith, aye. Mr. Inhofe? Mr. Inhofe, aye. Mr. Johnson? Mr. Johnson, aye. Mr. Jones? Mr. Jones, no. Mr. Kane? Mr. Kane, no. Mr. Kennedy? Mr. Kennedy, aye. Mr. King? Mr. King, no. Ms. Klobuchar? Ms. Klobuchar, no. Mr. Langford? Mr. Langford, aye. Mr. Leahy? Mr. Leahy, no. Mr. Lee? Mr. Lee, aye. Mrs. Loeffler? Mrs. Loeffler, aye. Mr. Manchin? Mr. Manchin, no. Mr. Markey? Mr. Markey, no. Mr. McConnell? Mr. McConnell, aye. Ms. McSally? Ms. McSally, aye. Mr. Menendez? Mr. Menendez, no. Mr. Merkley? Mr. Merkley, no. Mr. Moran? Mr. Moran, aye. Mr. Murkowski? Mr. Murkowski, aye. Mr. Murphy? Mr. Murphy, no. Mrs. Murray? Mrs. Murray, no. Mr. Paul? Mr. Paul, aye. Mr. Perdue? Mr. Perdue, aye. Mr. Peters? Mr. Peters, no. Mr. Portman? Mr. Portman, aye. Mr. Reed? Mr. Reed, no. Mr. Risch? Mr. Risch, aye. Mr. Roberts?
Order.
Mr. Roberts, aye. Mr. Romney? Mr. Romney, aye. Ms. Rosen? Ms. Rosen, no. Mr. Rounds? Mr. Rounds, aye. Mr. Rubio? Mr. Rubio, aye. Mr. Sanders? Mr. Sanders, no. Mr. Sass? Mr. Sass, aye. Mr. Schatz? Mr. Schatz, no. Mr. Schumer? Mr. Schumer, no. Mr. Scott of Florida? Mr. Scott of Florida, aye. Mr. Scott of South Carolina? Mr. Scott of South Carolina, aye. Mrs. Shaheen? Mrs. Shaheen, no. Mr. Shelby? Mr. Shelby, aye. Ms. Sinema? Ms. Sinema, no. Ms. Smith? Ms. Smith, no. Ms. Stabenow? Ms. Stabenow, no. Mr. Sullivan? Mr. Sullivan? Aye. Mr. Tester? Mr. Tester? No. Mr. Thune? Mr. Thune? Aye. Mr. Tillis? Mr. Tillis? Aye. Mr. Toomey? Mr. Toomey? Aye. Mr. Udall? Mr. Udall? No. Mr. Van Hollen? Mr. Van Hollen? No. Mr. Warner? Mr. Warner? No. Ms. Warren? Ms. Warren? No. Mr. Whitehouse? Mr. Whitehouse? No. Mr. Wicker? Mr. Wicker? Aye. Mr. Wyden? Mr. Wyden? No. Mr. Young? Mr. Young? Aye.
Is there any member in the chamber who wishes to vote or change his or her vote? If no, the yeas are 53, the nays are 47. The resolution is agreed to. Mr. Majority Leader?
Mr. Chief Justice, I ask unanimous consent that the Secretary be authorized to include statements of senators explaining their votes, either given or submitted during the legislative sessions of the Senate on Monday, February 3rd, Tuesday, February 4th, and Wednesday, February 5th, along with the full record of the Senate's proceedings and the filings by the parties in a Senate document printed under the supervision of the Secretary of the Senate that will complete the documentation of the Senate's handling of these impeachment proceedings.
Without objection, so ordered.
Further, I ask unanimous consent that when the Senate resumes legislative session on Monday, February 3rd, Tuesday, February 4th, and Wednesday, February 5th, the Senate be in a period of morning business with senators permitted to speak for up to 10 minutes each for debate only.
Without objection, so ordered.
And finally, I ask unanimous consent that the trial adjourn until 11 a.m. February 3rd, and that this order also constitute the adjournment of the Senate.
Without objection, so ordered. We are adjourned.
You can watch CBSN 24/7.
We've got an amazing story to share with you.
Let's talk about the latest developments. There's so many levels to this.
We have a CBS News exclusive.
Fires in California. What happens next, and how does it all play out?
We are on a mission with NASA.
I understand you have some breaking news. It's not over yet, is the bottom line.
This is a massive operation.
It's quite an adventure here at CBSN.
It's been a day.
see the desperation in the journey simply by looking at the trail that's left behind.
So she says she's 17. She looks kind of like she's 12.
Said to me, you know, if you tried to do this in New York City, take a picture of a man, he'd break your camera.
There's something very, very uncomfortable about this.
Today, a white supremacist lens.
This area can be the new Silicon Valley.
There was not a cot in the warehouse, not one cot in the warehouse.
We're so far deep at this point that there's no turning back. This is a long road ahead.
Our nation's capital, decisions are made here that affect all of us. And today, more than ever, people want truth, understanding, and accountability. So join us every evening as we bring you CBS News original reporting from around the world, while keeping our eye on what's going on right here in Washington.
The CBS Evening News with Norah O'Donnell, now from Washington, D.C. Understanding the world begins with the right questions.
Do you trust Kim Jong-un?
Doesn't the blame reside with Jewel?
Is it now our top terrorist threat?
With the right people.
So you have forgiven.
I have now.
Right here.
Check this out.
More news.
I'm Tony DeCopel with CBS News.
More original reporting.
It puts everything in perspective. We are on a mission with NASA.
Every morning on CBS This Morning.
We're going to begin with breaking news.
Wow. That's not normal.
The biggest names in politics.
Whoa, that's news. Are we at a tipping point?
Face the questions you want answered.
Margo, that's a great question.
Good question.
Face the Nation with Margaret Brennan.
For 48 Hours fans, a new podcast.
I'm Erin Moriarty, 48 Hours, and this is my life of crime.
Revisit the Lizzie Borden murders.
Lizzie Borden took an accident.
Go behind prison walls.
What was the crime that brought you here?
Hear a horror story that hits close to home.
Erin, there is no excuse to give your home address to a serial killer.
And much more. My Life of Crime. Subscribe on Apple Podcasts or wherever you get your podcasts.
Hello, everyone. I'm Tanya Rivero. Thank you for joining us. Senators voted against introducing additional witnesses in the impeachment trial of President Trump Friday. No more testimony or evidence will be introduced. That vote was 51-49 in favor. Two Republicans broke rank and sided with their Democratic colleagues, but it wasn't enough to tip the scales. The Senate just adjourned for the day and will not be back until next week. The calls for additional witnesses had intensified in recent days. Lawmakers wanted to hear from former National Security Advisor John Bolton in particular. Bolton reportedly claims that in an upcoming book, President Trump personally ordered him to withhold aid to Ukraine. Nancy Cordes has the latest from Capitol Hill.
The clerk will call the roll.
Mr. Alexander.
The senators voted from their desks one by one.
The yeas are 49. The nays are 51. The motion is not agreed to.
House impeachment managers had cited the latest Bolton bombshell in a last-ditch plea for witnesses.
Do you want your place in history to be, let's hear the truth, or that we don't want to hear it?
But no votes from two key Republicans ensured that 4 witnesses blocked from talking by the White House will not be subpoenaed.
You've got a lot of evidence already.
The vote comes even as some Senate Republicans now concede that the House managers have the facts right. The president withheld U.S. aid, at least in part, to pressure Ukraine to investigate the Bidens.
Do you view it as at least a partial victory that you have a Republican like Lamar Alexander saying you proved it?
He should have done the right thing and voted for witnesses and documents.
But Alexander says he will vote to acquit, as will Florida Republican Marco Rubio, who said today that just because actions meet a standard of impeachment does not mean it is in the best interest of the country to remove a president from office.
If we acquit this president, what's to stop him from doing something worse?
The New York Times reported today that one of the president's lead attorneys, Pat Cipollone, may have been a witness to the pressure campaign himself. That's according to former National Security Advisor John Bolton, whose upcoming book describes a meeting in the Oval Office last May.
So here you have the president saying John Bolton is not telling the truth.
The two sides appear to be heading toward an agreement that would set up closing arguments first thing next week, and then time for senators to give speeches on the floor announcing how they will vote. The final vote would then come on Wednesday, one day after the president's State of the Union address. Nancy Cordes, CBS News, Capitol Hill.
President Trump's attorneys had hoped he would be acquitted by Friday. However, the defense team is now bracing for the trial to continue into next week. Weijia Jiang is at the White House.
CBS News has learned that President Trump is not happy that this will drag into next week because he considers it a delay in his exoneration. But he has also resigned to the fact that it is not up to him or his lawyers, but the Senate. Now, that vote on his acquittal could clash with his State of the Union address set for Tuesday, and he definitely wants it to happen before the speech. I also want to mention that explosive claim from Bolton's book because the timing is really important. Bolton writes that it happened, that the meeting happened in early May, just before Ambassador Marie Yovanovitch was recalled and when Rudy Giuliani was planning to go to Ukraine. White House counsel Pat Cipollone was also reportedly in the room. He did not comment on it today, but the president is categorically denying the meeting described in the book. He issued a statement to say, "I never instructed John Bolton to set up a meeting for Rudy Giuliani to meet with President Zelensky. That meeting never happened." Giuliani, who was also in the meeting, according to Bolton, called it a lie. But the former New York mayor has also said Bolton was very aware of his efforts in Ukraine. Tanya?
Weijia Jiang at the White House. Thank you. Let's bring in Molly Hooper and Jessica Levinson now. Molly is a CBSN political contributor and veteran Capitol Hill reporter. Jessica is a professor at Loyola Law School in Los Angeles. And joining me on the phone are CBS News digital political reporter Grace Seegers and Daniel Lippman. He is a White House reporter for Politico. Welcome to all of you. So, Molly, I want to start with you. Now that tonight's Senate trial has wrapped up, what sort of housekeeping matters do we know going forward we can expect going into next week?
Well, now that we have a Rules of the Road Part 2 to basically bring this impeachment trial to a close, we know that there will be a vote on Wednesday at 4 p.m. 2 votes, actually. One on the first article, abuse of power. The second on obstruction of justice, obstruction of Congress. And the way that the impeachment rules work for the standing Senate rules, each member will say guilty or not guilty to each charge.
Interesting. Okay, we have that to look forward to on Wednesday.
That's right.
Jessica, lead impeachment manager Adam Schiff argued Friday there can't be a trial without witnesses. Let's listen to what he said exactly.
This will set a new precedent. This will be cited in impeachment trials from this point to the end of history. You can bet in every impeachment that follows, whether it is a presidential impeachment or the impeachment of a judge, if that judge or president believes that it is to his or her advantage that there shall be a trial with no witnesses, they will cite the case of Donald J. Trump. They will make the argument.
So, Jessica, does he have a point? We know this is not a legal proceeding. We know that this is a political proceeding with the outlines of a legal one. But is what we've seen play out so far considered to be a fair trial?
Well, I think fair is one of those words that's really in the eye of the beholder. I mean, when I'm in class and my students say something like, that seems unreasonable or that seems unfair, we really try and unpack it and talk about why do they think that. Now, if you want to kind of consider what would we envision when we think about a full airing of all the issues, if we've tried to get to all of the facts, that's a situation that would include witnesses. More information is better information. It's not like these witnesses would walk in there and not be able to explain their story. There would be direct examination and cross-examination. Now, having said that, the idea that this is kind of precedent setting is something that has surprised me that Republicans haven't latched onto a bit more, in the sense that all of these issues where we're expanding executive authority will apply not just to President Trump, but to the next president. All of these situations where we're defining a new roadmap for impeachment will affect not just President Trump, but the next president. Luckily, we haven't had many impeachments in our history. We've only had 3, but we've always had some form of witnesses, whether live or by video. And so this does set a precedent, absolutely.
And because we've had so few impeachments, there definitely has been the looking back to precedent, because as we've discussed here on this show before, there hasn't really been a clear roadmap. So precedent does matter.
Oh, absolutely. I mean, as we've talked about, the Constitution basically says, okay, Senate, you try it. And it really doesn't give any more. I mean, there's no turn-by-turn directions here. There's no GPS. It's like, imagine you get in your car and it's just a blank screen. You just know you have to get there somehow. Now, of course, the Senate does have rules, but it's entirely legitimate to decide we're not going to have witnesses. Is it optimal? Is it a good decision to try and provide more information? Of course it is. But is it constitutionally required? No, let's not pretend that that's constitutionally required.
All right, so Grace, I want to ask you about the Republicans who did vote in favor of additional witnesses, Senators Susan Collins and Mitt Romney. What was the political calculation on their end, do you think?
Well, I think that they wanted to show a little bit of independence, and both of them had genuinely said that they were interested in hearing from John Bolton. But the real calculation, I think, was by Lisa Murkowski, who voted against calling witnesses. And I think, to do a little speculation here, that Republicans really wanted to make sure that there wouldn't be a tie, which would have possibly had to be broken by Chief Justice John Roberts. So they avoided that situation entirely by making sure it was a 51-49 vote.
So, Molly, do we have a sense then, there still is a lot of interest in people talking to John Bolton or hearing what John Bolton has to say, if talking to him will be pursued by the House or any investigative committee in some way?
It very well could. The House is still going to continue its oversight responsibilities and current investigations that they have, into various aspects of this president's administration and his finances. And, earlier this week, Speaker Pelosi was asked that very question. Will Adam Schiff subpoena John Bolton to come basically testify in front of the Intelligence Committee? And at that point, before we knew what the outcome would be on this question of whether the Senate would talk to the witnesses, Speaker Pelosi demurred a little bit, but she did not rule it out. So that very well is a possibility. But at this point, I think that once this trial wraps up, once the dust clears to the extent that it can, Pelosi and her committee chairman of these investigative panels will get together and figure out how they want to proceed, because they also have a packed legislative agenda, items that they need to pass through the House, so they can give their members something to go back and run for re-election on.
Right. They might put this on the back burner for a while.
Perhaps.
We'll see. So, Daniel, I want to bring you in here because we've been watching 3 Democratic senators, Joe Manchin, Kristen Sinema, and Doug Jones, as potential defectors from their party on the acquittal vote. Do we know if the White House has personally reached out to them in any way?
We don't know for certain, but sometimes there's back channels to, from White House allies to allies of these moderate Democratic senators. But I think they are probably monitoring the approval ratings of the president in their home states and seeing if, voting for impeachment and would hurt their standing. But I'm sure there's also we talk all the time about Republicans staying loyal to Trump and not going against him and going against McConnell. Democrats have their own concerns, too. They don't want to be cast out from their caucus in terms of popularity and committee assignments. And they also want to, show loyalty to Schumer because many of them hope to take the majority in November.
Right. All right. So Molly, I do want to ask you, though, we know that the Senate is sort of in control now. The Republicans are in control now, and this ship is sailing on their schedule. But is there anything that Senate Democrats can do to delay the acquittal?
The inevitable.
The inevitable here.
Well, this is what was kind of interesting tonight for all of the Capitol Hill folks who love to cover the Article 1 branch of government, because there was a procedural sort of scuffle earlier tonight. And, there was a question among the caucus, Democratic members of the caucus, do we want to prolong this and offer amendment after amendment and force debate on all these amendments and drag this into ostensibly Sunday and come back Monday and do the same and drag it out until Wednesday? And after a confab, as we shall say, private behind closed doors, it appears that the more cooler heads prevailed, and I have a feeling that members who are running for, shall we say, president in Iowa may have weighed in on that one, because the way that the proceedings will move forward, the Senate is out tomorrow, they're out on Sunday, they return, the body returns on Monday, reconvene. 1 o'clock, we're going to hear closing arguments from the White House, from the House managers. They have up to 4 hours to use, equally divided, so 2 hours, 2 hours. Then the Senate they'll adjourn, come back for that vote. But after that time, after 4 o'clock on Monday, or essentially, well, it would be 5 o'clock. After that time, senators will be allowed to essentially make statements in public on the Senate floor as to why they will vote the way they will vote, because that was one point of contention. Democratic senators and some Republicans want to actually make their case as to why they will vote to remove a president or acquit him. And keep in mind, for 11 days, these senators, the most deliberative body in the country, in the world, they've had to sit down and listen. They haven't been able to say anything.
It's their turn to speak.
They want to talk.
Yeah.
And they will have that opportunity between the late afternoon Monday and Wednesday afternoon.
Well, you just made the point that there are those senators who may have some conflicting sort of feelings about this. Obviously, they would rather be in Iowa at some points. We have from our CBS News reporting team, I was just checking my email, that someone asked, Senator Sanders in the hall, are you heading to Iowa tonight? He said, yep, I'm heading to Iowa tonight.
Exactly. So, Elizabeth Warren, Amy Klobuchar, Michael Bennett.
They're out of there.
They're heading to the Hawkeye State.
So, Jessica, no matter how these votes on the articles go, President Trump will always be impeached. So what does it mean legally if he is acquitted, as he is likely to be?
Well, legally, it's basically the same thing as if somebody is indicted but then acquitted. So there's no legal consequence. I mean, it's a humiliation. It's potentially an embarrassment. I was just actually on a great podcast for kids, and they said, basically, how do you explain this? And it's kind of like you got in trouble at school, but you get to come back the next day. You didn't really have to sit out you didn't have to sit out by yourself very long. You just are kind of humiliated for a moment. You had a timeout, but you still get to come back for snack. You still get to come every day. So he can still obviously run for re-election. There's no legal consequence that comes down. Now, in terms of consequences looking forward, you talked a little bit with Molly about, future congressional investigations. And I would say to your viewers, there's a couple of really interesting cases to watch. They're working their way through the system. For instance, dealing with basically the scope of congressional subpoenas. So we don't know exactly what those investigations will look like. There's a really important case dealing with Don McGahn, who works in the White House counsel's office, and whether or not he is subject to a subpoena and has to comply. Another really interesting case in New York dealing with whether or not you can investigate the president at all. So the shape of those future congressional investigations is something that's at this moment really fluid. It's really important to watch these cases for the next few weeks, potentially few months.
Yeah, it's important to note the story is not ending here, right?
No.
It has some legs. I want to just go back really quickly, though, to this idea of impeachment being sort of a, like you said, you've gotten in trouble, but you still get to go back to school, which is a great definition of it. Could it then qualify as a censure? I mean, this idea had been floated around by some Republicans who said outwardly that they weren't comfortable necessarily with the president's actions, but didn't believe that they rose to the level of impeachment. He was impeached, however, so they didn't believe that it rose to the level of removal from office. Would then the fact that he was impeached be enough of a censure in their eyes?
Well, that's a good question. Jessica and I should say jinx. Sorry,
right.
We weld together. But just to say, that could be a possibility in the future. I'll put it that way.
Right. Jessica, you want to weigh in?
I apologize. I couldn't see you likely turn to Molly. So the censure was something that, there was a lot of discussion about this. I wrote about this. It's not specifically in the Constitution, but we understand that it's something you could do. I mean, if we want to keep the analogy going, the censure is kind of like, okay, you have to sit at another table for a little bit. The impeachment is like, you see all of your friends doing an art project, you can go sit on the other side of the room for the entire morning while you watch them.
Right.
So the effect at this point is symbolic in both cases. It's just one is much more dramatic.
Interesting. All right. That's a good distinction. Former White House Chief of Staff John Kelly said Friday that if there are no witnesses, impeachment is, quote, a job only half done. So, Daniel, can you remind us about Kelly's relationship with this president and why his comments are significant?
Well, he first had a pretty good relationship with the president, but on the way out, it didn't seem like Trump wanted to give him a good exit. And so periodically he pops his head up to make comments that are kind of revealing. They're not, too critical, but he definitely had some disagreements. He was trying to keep the Trump White House from going off the rails, and he was successful in some ways, but in other ways, it's very hard to control, a billionaire president who wants to be his own staffer and doesn't even believe in many of the civil servants at the White House or just, his political appointees in general. And so Kelly often speaks out, to set the record straight about what his experience was in, the White House.
And so, Grace, it's so interesting. You've been doing what you call, quote, vibe checks for CBS News on the mood inside the Senate chamber throughout this process. Friday, of course, marked day 10 of the trial that was not for the faint-hearted. So can you give us some color on how lawmakers' spirits are now?
Let them give the people.
Grace, are you still with us? Did we lose you? Oh, I'm afraid we lost Grace. Well, that question will have to wait. So Grace Seegers, Jessica Levinson, Daniel Lippman, and Molly Hooper, thank you so much for joining us. It's been great.
Thank you.
And coming up after the break, the U.S. imposes a travel ban on foreign travelers at high risk of the coronavirus, how health authorities are trying to contain the global outbreak. Plus, a state of emergency declared in Australia's capital as crews struggle to contain a massive bushfire in the region's south. And the Iowa caucus is just a few days away. We'll take a look at how presidential hopefuls are campaigning in the state ahead of that critical vote. This is CBSN, CBS News, always on.
You can watch CBSN 24/7.
We've got an amazing story to share with you.
Let's talk about the latest developments. There's so many levels to this.
We have a CBS News exclusive.
Fires in California. What happens next and how does it all play out?
We are on a mission with NASA.
I understand you have some breaking news. It's not over yet is the bottom line.
This is a massive operation.
It's quite an adventure here at CBSN.
It's been a day. Wow. That's not normal.
Our nation's capital, decisions are made here that affect all of us. So join us every evening as we bring you CBS News original reporting from around the world while keeping our eye on what's going on right here in Washington.
The Trump administration has declared a public health emergency over the deadly coronavirus outbreak, and Americans flying in from China are being quarantined for the first time in decades. Carter Evans is outside the military base in California, where nearly 200 U.S. citizens are being held.
The Americans being housed at March Air Reserve Base during the first federal quarantine in 50 years will spend 14 days here. Ian Thompson is among them.
How is everyone doing there?
Yeah, everyone's healthy. It seems to be. I mean, all the kids are playing, they're all laughing and joking, and they're doing the best they can for us. I mean, so we're being looked after very well.
The steps outlined in the Trump administration's public health emergency will include a temporary ban on foreign nationals who've traveled to China.
The risk of infection for Americans remains low. We are working to keep the risk low.
Officials in Santa Clara County announced they confirmed a 7th U.S. case of coronavirus, a man who recently traveled to Wuhan.
He has been self-isolating at home. He was seen in a local clinic and hospital, but was never sick enough to be hospitalized.
According to the CDC, even if a patient's initial tests are negative, they could still develop the illness because the test only works when the patients have symptoms. A new study also showed the virus can be transmitted by patients with no symptoms. A woman who traveled from Shanghai to Germany infected 7 other people while she was asymptomatic.
Maybe you can transmit it even earlier, maybe a couple of days before you become symptomatic, and it becomes a lot more difficult to control the spread of a virus.
The people in quarantine here could potentially have more company. Starting on Sunday, any U.S. citizen returning home from the Hubei province is now also subject to a 14-day quarantine. The next American evacuation flight is scheduled to leave Wuhan on Monday. Tanya?
Carter Evans, thank you so much. Some hospitals across the U.S. have been forced to reschedule surgeries over fears that millions of surgical gowns may not be sterile. Dr. John LaPook has the details.
When Cardinal Health recalled 9 million of its surgical gowns amid concerns some might not be sterile, medical centers around the country began to scramble.
This is a big disruption.
Alan Levine, CEO of Ballad Health in Tennessee, says they had to reschedule 200 surgeries.
We still don't know whether we've hit the worst of this yet or not.
Yesterday, the company admitted that a Chinese contractor supplying some of its gowns was using factories not registered with the FDA. The company has said these facilities did not maintain proper environmental conditions. Problems included gowns exposed to contaminants through open windows, failure to provide hand sanitation, and operators eating in the production area. In 2018, Cardinal Health caught the same supplier using an unregistered factory. Back then, the company did testing and concluded there was no impact to its products. It did not tell the FDA. This is surgical tubing, sponge sticks. The gowns are often included in a package along with other surgical equipment.
All the objects inside this surgical pack are supposed to be sterile, but that's the problem. Because they can't guarantee that the gown is sterile, it could have contaminated other objects here.
There's been an increasing concern about the reliability of the supply chain.
The Lakers are set to play their first game since Kobe Bryant, his daughter Gianna, and 7 others died in a helicopter crash last Sunday. They are due to take on the Portland Trail Blazers after they postponed a match against the Clippers earlier this week. Chris Martinez is at the Staples Center in Los Angeles with more.
LeBron James and his fellow Lakers will pay tribute to Kobe Bryant before tonight's home game. They are not saying exactly how the team plans to honor the NBA legend and the 8 others who died.
You know, it's the right thing to do, and you know, it'll be an important night for our franchise and for Laker Nation.
Last night, the LA Clippers played the first NBA game at the Staples Center since the accident. A number of players wore shoes honoring Bryant, and so did the Clippers coaching staff. Clippers forward Paul George narrated a video tribute.
4 days ago in Calabasas, 9 lives were lost, leaving a gaping hole in the heart of Los Angeles. We gather tonight in the house that Kobe Bryant built to honor him and them.
The scene outside the Staples Center remains somber. Thousands of fans and well-wishers have been drawn here to pay their respects.
It just feels like it's surreal. It just feels like a bad dream.
Thursday, in Orange County, people gathered to remember 14-year-old Alyssa Altobelli, along with her parents who died in the crash.
We come here to honor the memory of these beautiful people
to pay our respect and to celebrate their lives.
The medical examiner has identified all 9 of the victims from Sunday's crash, which now clears the way for families to make funeral arrangements. Chris Martinez, CBS News, Los Angeles.
In Health Watch, 2 California teens have come up with a creative solution to try and combat the youth vaping epidemic. Nichelle Medina is in Los Angeles with the details.
Chris Shaw and Adam Kunyathi are juniors at Crescenta Valley High School in Los Angeles.
So there's this vaping problem, which I'm sure the administrators know of, but nothing's getting done about it.
The students created an app to try to combat vaping in their school.
There's almost no way for an administrator to know whether the vaping's happening in the bathroom unless they walk in.
The app allows students to anonymously report when they see other students vaping.
They simply select what gender the restroom is, which building it's in, and what floor.
I'd say it's the #1 thing that we deal with.
Associate Principal Christine Benitez worked with the teens on the concept for nearly a year. She says it was her way to help solve the crisis and get students involved.
Instead of us running around trying to catch kids, the app is helping us deploy those resources in the appropriate areas.
If caught, a student must attend a 10-week program. The school says the goal isn't to punish students, but to make them aware of the health risks.
They don't understand what they're putting in their body. We really have to educate them on how to make that better choice and how to put their health first.
In 1 week, students reported 300 vaping incidents at their school.
Don't do it because it could affect not just you, but even younger generations.
Krish and Adam hope their app makes their peers think twice about using e-cigarettes. Nichelle Medina, CBS News, Los Angeles.
Coming up after the break, after more than 3 years, Britain's exit from the European Union is finally official. We'll break down what happens next. Plus, we're just... Also, I was just noticing in the...
You can watch CBSN 24/7.
We've got an amazing story to share with you.
Let's talk about the latest developments. There's so many levels to this.
We have a CBS News exclusive.
Fires in California. What happens next and how does it all play out?
We are on a mission with NASA.
I understand you have some breaking news. It's not over yet, is the bottom line.
This is a massive operation.
It's quite an adventure here at CBSN.
It's been a day.
Understanding the world begins with the right questions.
Do you trust Kim Jong-un?
Doesn't the blame reside with Jewel? Is it now our top terrorist threat?
With the right people.
So you have forgiven. I have now.
Right here.
Check this out.
More news.
I'm Tony DeCoppel with CBS News.
More original reporting.
It puts everything in perspective. We are on a mission with NASA.
Every morning on CBS This Morning.
We're going to begin with breaking news.
In this edition of 2020 Daily Trail Markers, the Iowa caucuses are just days away, and candidates are expected to spend the weekend crisscrossing the state as they rally for last-minute support. Ed O'Keefe has the latest.
Monday's caucus looming. Joe Biden and Pete Buttigieg today crammed in 7 events between them.
Every 4 years, everything begins here in Iowa.
Go in on Monday evening and caucus for us.
The 4 senators running for president are stuck in Washington, including the frontrunner Bernie Sanders, giving Biden and Buttigieg an in-person edge.
Who among us is most likely to be able to defeat Donald Trump?
The senators are left to campaign mostly from a distance.
I'm here. I'm hoping that the people see it as a plus.
And pay for ad time to make their final pitch.
But I'm switching parties to caucus for Elizabeth Warren in 2020.
Together, we will transform this country.
The ads are about unity, but there's also some infighting.
I've seen Vice President Biden making the case that we cannot afford to take a risk on somebody new right now. I believe at a time like this, the risk we cannot afford to take is to turn to the same Washington mindset that has brought us to this point.
The man not contending in Iowa, former New York Mayor Mike Bloomberg, is making his case on the air. Campaign spending reports show Bloomberg has already spent more than $140 million on TV and internet advertising nationwide.
Bernie Sanders is still back in Washington for the impeachment trial, but his campaign is throwing a concert tonight with some of his surrogates and the singer Bon Iver in his absence. Sanders and the other senators running for president are going to get out on the campaign trail as soon as they can this weekend, and then likely have to head back to Washington. Tanya?
Ed, thanks for that. And for more on all this, let's bring in CBS News 2020 campaign reporters Adam Brewster and Musaddiq Bidar. They're both in Des Moines, Iowa, and are both covering the closing arguments Democratic presidential hopefuls are making in the final days before the Iowa caucuses. Welcome to both of you. Musaddiq, our latest CBS News Battleground Tracker poll shows Senator Bernie Sanders leading in the state. He's still in Washington for the Senate impeachment trial, however. How is his campaign addressing that?
Well, the campaign is relying on its infrastructure. They have more than 250 staffers across the state, and top-level surrogates have been flying into Iowa all week long. Today, Representatives Ilhan Omar and Rashida Tlaib were out campaigning for him. His wife, Dr. Jane Sanders, has also been stumping for Senator Sanders. And as you heard Ed mention, their musician Bon Iver has a concert tonight, Vampire Weekend tomorrow. So they're really working and relying on this infrastructure to help carry that message while Senator Sanders is out of the state. One thing the campaign does feel good about is that if there is high turnout on Monday night, they feel they will do really well. They think that they can do well with young voters and Latino voters, which is a growing demographic here in Iowa. And meanwhile, Senator Sanders is driving home this message that he is the one who can fight for working class Americans. He says that his political revolution can begin here in Iowa, where he narrowly lost to Secretary Hillary Clinton in 2016. And he's also telling voters that the Democratic establishment is scared of him. He says that he is their worst nightmare. And if Senator Sanders is successful here on Monday night, it will largely be in part because of his strong ground game and strong infrastructure.